Yes. Assalamualaikum everyone. Hello. I'm Untitled Chapter. You probably know me already. And I'm currently the head of patent department in a patent firm. I've been an IP firm in Iran called Carafon, which is the agent of Iran's Patent Center and Iran's Innovation Fund. And what we actually do is kind of anything regarding patent application preparation procedures and patent prosecution, either in Iran or internationally, through the collaborations that we have with the other firms all around the world. So we chose this topic, patent protection in non-PCT countries, mainly because Pakistan is not a PCT member. We can say either fortunately or unfortunately. It would have been better if it was, but what I got from our yesterday's session was that you probably want to know about PCT. So I also involved PCT in my slides too. So please, I'd like to have discussions. I'd like to learn from all of you. So please, I don't want to have a monologue. Okay. I shall probably thank Carafon and Comstech for collaborating with each other and providing this really valuable course, I think. Just a quick check on what we learned yesterday to make sure that we are familiar with the key points, actually. So patent is based on what we learned, an agreement between an inventor and the government of a country in which the inventor agrees to publish. I have made them in red. His or her invention, and in turn, the government agrees to give the inventor an exclusivity on the use of the invention in a limited time. So this is an agreement between the government and the inventor. So I'm the inventor or the applicant, so I should decide that if I want to have this exclusive right that we define it, I should definitely disclose completely my invention. We see in the clients that, what we see in the clients is that they don't usually like to disclose their inventions. They come to us and say, okay, draft it, but draft it in a way that nothing is disclosed. Don't disclose that. Don't disclose the numbers. Don't disclose the sizes and other characteristics. So it's not possible, actually. There are actually some tricks, but as a general rule, we have to disclose everything, or else we will get an error from the office action. So, an extension of that, disclosing completely the invention to the public, what we get is right to prevent others to do all of these. To prevent others from using, selling, making, importing, exporting, and distributing that we talked about, or even assigning or licensing. So we get to the more limited time that we talked about it, so I just passed. And we talked about 20 years maximum, so we should take care about this. And because this is actually, we are talking about patent registration, kind of patent registration. So we shall, as inventors and as applicants, should decide that either we want to disclose our invention or we want to pay that much of money just for 20 years. Sometimes this is not worth it, actually. Maybe it's not worth it for many inventions in the health sector. And in the software, it's completely opposite because the growth is the growth in this technology is very fast. And so maybe after 3-4 years, no one can I mean, no one can use your invention anymore. So for 4 years, it's not basically possible to pay that much of money, spend that much of like 3-4 years just for prosecuting the patent procedure. So we should decide at this point that do we want to enter this procedure? Do we want to pay that much money, especially in developed countries, which are costlier, of course? And the other word, the government of a country or region. So this is important. Why? I think that Dr. Mitra addressed this. The valid territoriality rights. So if anybody remembers it from yesterday, I would be happy to. Yes, Doctor, if you want, I thought you may want to answer.
I didn't catch the question.
Oh, we talked, I mean, Dr. Mitra talked about the territoriality rights in patents and generally in IP, but we are talking about patents at the moment. So what is it? What is meant by territoriality rights?
Patents are granted in each and every country, and they will be only enforceable where they are granted.
Yeah, great. Thank you very much. I needed that phrase exactly. So if I have a company in the US and I want to produce a product like a smartwatch and I get something that is patented there. I mean, this is a product. It actually comprises many IP rights. But for example, one of the things that I have in my product kind of overlaps with that patent. So am I capable of producing it? I mean, am I allowed? This is a better word, I think. Yeah, of course not. And what if, okay, this is patented in the US, but in Pakistan, I have a company in Pakistan, I want to produce it in Pakistan. I want to produce it, manufacture it, I want to distribute it, import it. So it's not patented in Pakistan. Can I produce it? Yes, we can produce it, and we can also export it to the countries which this technology or this IP right is not protected there. Okay, so this is the thing that we don't always have to go through those complicated processes of patenting. Sometimes we can produce a product or we can launch a process or anything, any service without even patenting. So we should think about all of these, or that is it worth it or not? So, and the other thing which is very important, and it's usually overlooked, is that only the claimed invention, this word is very important, I emphasize that, only the claimed invention is protected. So what are the patent claims? I think maybe majority of you have seen a patent, right? Is there anybody who has not seen a patent document? I may have it in my. You haven't seen. But I will show today the raw file, not the one which is published, but you can search, if you search, just Google it maybe in your smartphone, you can find a PDF which is in the published format. But I will show there is a parts claim section which starts with this title, what is claimed is, colon, and then beneath that 1, 2, 3, and we have a set of claims, set of phrases, which are, they are drafted completely in a legal format. They may not seem that beautiful as when we read them verbally, they are not that good, but it is what it is. So a patent claim defines the boundaries of an invention and therefore determines what the patent does and does not cover. So the boundaries that I showed. And it is the most important part in a patent application because it defines exactly the subject matter of that invention. So if we have this space, this is the art, the current art in the technology that I'm actually working at. So this is my invention, for example, like a bubble in this space, and this is these are the prior art that I have. This is maybe another invention and its claim, and this is probably something which is unknown yet. So my invention is here. So claims completely set and lay down the boundaries of an invention. So me as a drafter is responsible, and you as an inventor and as an applicant, you'd better go to an attorney who is able to draft the claims that are in a broadest way as it is possible, and it does not overlap with the prior art, because if it overlaps with the prior art, it will be rejected in the patent office. So this is another important thing. So when I say I have patent rights, I just have this. I can't claim this. I can't sue others for the other areas in this space.
Claim on different innovation. Secondly, invention. Sorry.
Yeah.
Claim on different invention.
Yeah.
Is it his own invention or other people's invention claim?
Yeah. You mean this one?
Yes. Again.
Yes. This is other inventions. Probably I'm working in technology. For example, I made this. There are many patents on this. So they have claims, and the technologies, the innovations, I'd better say, have gotten narrow. You can put your the step very further. Yeah. So they're narrow. So they have very I'll say small overlaps. I mean, so, or the difference, I would better say, is small if you compare inventions with each other. So, here's an example. I think we can actually better perceive it this way. So, this is a pencil with an eraser attached to one another. So, if I have a claim and you see a patent, and this is its first claim, for example, which is the first claims are actually the most important claims, or I better say, we don't have time to talk about it, but they are actually called independent claims. Independent claims are the most important one. So this is a pencil. If we want to define it, me as a drafter, for example, a pencil and eraser combination comprising an eraser with an opening at one end. So it has an opening at one end, and a pencil with one end shaped to fit the opening in the eraser. This is shaped such that it's in the this opening, and the shaped end of the pencil being inserted into the opening in the eraser. So this is one claim. And then there is another claim. That space that you were talking about is exactly this, and why we should basically pay attention to this, that this is the claimed invention, only the claimed invention that I have patent rights on. So this is another one, and I have made the differences in red. Again, a pencil and eraser combination comprising an eraser with a conically shaped opening at one end, and a pencil with one end tapered to form a conical end to fit the opening in the eraser and the rest of the phrase. So what is exactly the difference? You see, I have added just two words. I have added a new characteristic that we call it limitation. This is conical, but isn't there any other way that I can define it? Can it be in another shape? So making it conical makes it kind of narrow. So I have patent rights. If I have this claim, I have patent rights on this. If I have this, I have patent rights on this. This is what is defined actually in this claim. So, and so we go further. This is done. We needed this background actually. What is meant, and there's another thing. You should see the, you should consider the custom benefit you want to patent your inventions. It's like, okay, if my innovation is really narrow, is it worth it really if I go through all that complicated processes? Is it worth to pay all of those really high fees for what which can completely and easily be invented around? So this is exactly one of the things that we should pay attention to. What is meant by patent filing? So this is me, an applicant, and I can be in an R&D of a company or in a university, yes. Doesn't differ. I have an invention, and the invention, what is an invention? It should be in these actually three categories. It should be a device, apparatus, or a tool, method or process, or composition. You may ask, for example, what about software? Software isn't here. It's actually a process. And it's defined as a process. So if I have those, just consider that. I go to the agent or an attorney, and he is responsible to prepare my patent application. And what is exactly patent application, and what does it have? It has claims, description, and drawings. And probably those who are with us online have this. But I want to show a raw file that we usually, because we draft US patents actually, or PCT applications. And it's raw. It's like submitting a manuscript. It's in a format, and then it goes, and all of the things happen, like changing the shape of that, and then the office action. The patent office is responsible to publish it. So when this stuff is sold, this is one of the things, one of the files, which is actually files. Yeah. So when we say claims and description, which is generally called specification, this is a specification. So it's a yes. So this is the specification that we're talking about. All those boxes we have a background, and then we have to describe and detail every technical aspect of our invention. With regards to the figures that we have provided, the figures are actually in a separate file as drawings, and each patent office actually has its own provisions. So I go down, and here is the claims. What I told you. So what is claimed is here a method for like synthesizing. This is a pharmaceutical patent. This is drug warfarin, which is completely known. And these are the limitations. What is my invention? So this is the claim, and we get to be abstract. So we have a separate file, which is the drawings. That's like this. So this is a separate file, and I shall describe this. for descriptions shall be with regards to the figures. And in some instances, when my invention is about biological sequences, I don't know if any of you are working with biological sequences, like DNA sequences or amino acid sequences. Any of you?
Yeah.
Yeah. So you have to prepare a sequence listing actually. So you are aware of that. And it shall be in a specified format actually. And can you say what shall we actually do you have it in Pakistan?
Yeah, we do. Actually, we have a case where we patented a genetically modified crop, and that modification was based on some gene that we inserted.
Yeah.
We patented the sequence and the conclusion of that gene with some regulatory elements.
Yeah.
That sort of
Yes.
stuff. Or as a completion, obviously you can't patent the biological things.
Yes.
It's a
And
natural
is it in a
conversion.
separate file or it's in the description? Because this
We claimed it in.
okay, you claim. So it's not in a different platform. It's not added in like a software because US or PCT or I mean like EPO or many patent offices, especially in the developed countries, have this platform. You have to go to this software, add those sequences. So okay. What was this? This slide is added. I don't know what's that. Okay, so this was it. And when I want to file it to the patent office, I have to pay some fees. And these may be different actually. Not all of these are, I mean, you don't see all of these in all patent offices, but it's usually the same wording. I mean, you see the same thing, filing fee, transmittal or designation fee, like search fee, examination fee, and additional fees that may, for example, if you exceed like 30 papers in PCT, you have to pay for each additional page. Or claims. Like in Europe, it's like if you have more than 15 claims, you have to pay an extra fee for each claim that you add. In US, it's more than 20 claims. And the pages also have the same condition. So you file it, I mean, usually the agent, but you can file it straight. If you are a national or a resident in that country or in that region, you can file it yourself. You don't need an agent or a registered attorney there. So the patent office actually checks formal requirements and examination. So what does the examiner actually do? I think we don't have Dr. Soy. Dr. Soy is an examiner, right? So who could help? First, he determines what is exactly claimed. This is exactly what we talked about. Those space again. So this is very important. Usually description is important, but description is kind of interpreted. Claims are interpreted based on description. So claims are more important, but description must be inclusive. It must be complete. You have to describe everything because when you file it, you can't change it. You can add anything. Like say, oh no, I hadn't mentioned that. I have this new characteristic I want to add it, so now it's patentable. So it's not possible. Whatever I have, I put it there, and maybe if patent office may say that okay, you don't have unity of invention, so I file divisional patents, continuation part like in US, or we have the similar things in other countries. So then, after determining what is exactly claimed, this which is claimed, not the description. Based on this, the examiner finds the closest prior art. And what is prior art? Can every document be prior art?
No,
What's your thought about it?
I think in that particular area, from which point the earlier person has finished his work, people, and that is the prior from which he got something new, different from that particular point when all the other literature in his field
Yeah.
is have done whatever they have shown, whatever they have created. The next step which he has taken, let's say it's all those previous research has reached at point A, then he has claimed point B something else.
Yeah.
So the prior part is all over that part which is already the different people has done.
Yeah. Thank you very much.
You can say
Any other ideas?
Closely related or closely associated products.
Don't consider the close. Consider prior art in general. What is prior art?
The previous work done on the same subject.
What is previous? How do you define previous?
Like it should be.
All the destroyers or work done that is before the priority date.
Exactly. Thank you. Before the priority date. Yeah. So before getting to the next step, so this is the definition of priority. Sorry, prior art. So this is important, and that's why we say that when you do an invention, just when it's got to a stage that you can say, okay, I know this works. This generally works. It has some minor modifications, but it works. Just go to an agent or attorney and draft and file it, because this is very important. We know that every day there are. Sorry, yeah.
Yesterday I was having this conversation with some students of chemistry as well. Usually when people who work in chemistry working on a PhD, they look at prior work done in journal publications. So they'll go to publications elsewhere, Taylor and Francis, there are different repositories. I was just wondering, do these journal publications and this, these patent platforms and the repositories, have something in common? I mean, a person who is working in a chemical, looking at previous work in publications, or it might have actually happened in a patent or something might have happened in a patent, might have happened in a publication. I'm just wondering.
So that's why you should basically consider everything. You should try to find anything which is closest to your work, actually. Finding patents, are you add a question? No? No, okay, sorry. So that's why we should do a comprehensive search in everything which is in public domain. And that's why even when a patent is granted, there are your competitors that try to invalidate your patent. What are they doing? They're searching for the document that the examiner hasn't found actually. Maybe there is a pamphlet somewhere, maybe there's a product which is commercialized in a country and it's disclosed, I mean the technology is disclosed. So it's never 100%, it's completely manually. It's done by human in each stage and you may have errors. Examiner may, you may, any agent that you employ might do it, might miss something. So this is where I file my invention. Like I file it tomorrow. So from the moment I file and it's actually it's like says I have filed at example 9 a.m. or from that date basically say. From the date that I filed before this date, everything is prior. Everything which is public. Everything which is in the public domain and it can be found. There may be something which is trade secrets actually. No one can find it. We are not talking about that. We are talking about the things which can be, which can be found. So these are prior art. But if there is a publication that exactly the day after I file my patent application, is this prior art? So, this is the procedure. When I file this, it takes time to like examiner, there's an examiner determined for examining my patent application. It may take like months. So when he wants to search for the novelty of my patent, the examiner actually investigates all documents before the date that I filed. So even if another person has filed an application, and we know that when we file an application in most of the countries, it's like it gets published after 18 months. So I may not know what has been actually filed. So there may be another patent application filed after my date, but I'm basically the owner because I have filed first.
And then he will be rejected, those who file after that during that period.
Yeah, before you mean
After, if you have.
after filing it.
After filing, you, if other person files 6 months after you have.
Yeah.
That would be rejected or
Yes, have rejected.
if in America you.
Or if the examiner may miss that. Okay, so I can sue. So I can say, okay, no, it's wrong. This is mine. Mine has a filing date and prior of that.
I have one question.
Yeah.
For example, if the same inventor publishes one patent in one country, and after that, if the patent is granted, and later he publishes the patent in another country,
Yeah.
what is the definition in that case? Because the inventor is same.
What do you mean? The author is the inventor.
Yeah.
So,
for example,
Is self-discloses?
yeah.
So if you self-disclose it before, this is exactly what was discussed yesterday. So if you disclose it in any way, not just papers, it might be in an event or anywhere you are talking to your colleague and is recording your voice, whatever.
What about the business point of view? For example, I find out that this patent is licensable in a particular country, and then I find out that it has a demand in that country where I want to in future to be patented. In that case, can I not file again in another country this similar kind of thing? And just
It's global.
it's global.
It's global. So when they examine it, it's global. But the patent rights itself is territorial. So your rights is territorial. Yeah. But when the examiner examines your work, it's with a global process.
Yes, well, that was my question as well. A person if is filing his case in America
Yeah.
and he has filed his case and in another country, Canada or something like, and whatever, the examiner is the government of that country. They are examining his case for in that particular country.
Yeah.
They are the examiners, and they examine all the other work done in all other countries.
Yeah.
Overall.
Everything that is published.
So before,
But they give right for America only.
Yeah. And then what?
Before TRIPS, it was not, let's say, an international obligation to have a global search. So you could actually have innovation, which was at that time we call local novelty. Even Pakistani law was based on local. So if something is not disclosed in Pakistan, not disclosed in Pakistan, could theoretically at least be patented within Pakistan if it was not disclosed in Pakistan.
But
After
not disclosed in Pakistan, but
if people generally do not know about, or the people interested in that field finds generally do not know about. And then we changed the law, called it what TRIPS requires. So now the novelty or the assessment of novelty is global. Even if it is which I think will come now, that's global. But the rights is based only in Pakistan. You cannot use that right, and that is based on the
Sorry?
concept of secondary.
Whatever, yes.
So
What's the
something
other?
I can
Just like
somebody
any,
violate,
search
but
when
they
you
might
go
be
for a
right
site.
infringe, I
Yeah.
can sue them, but
So
outside
everything.
country, I myself.
Whatever, maybe LinkedIn post.
In
Yeah.
that country, can I do that?
You can, and it's just not disclosed.
Madam,
In Pakistan,
Yeah, sorry.
they are not published.
after filing the patent, can we advertise it for the business
So
purpose?
shall we wait so others can hear your question? So, yeah,
Well, my question is, after filing the patent, can we advertise it for the business point of view?
can you what?
Advertise it?
After we file it?
Yes, yes,
Yes, we can.
we can.
But it depends, you know, this is something about business.
Yes.
What if your patent is not granted? You have like disclosed it, or you might decide. That's why you have to, in each step, you have to use the consultancy of an agent.
Oh.
Yeah.
Fine. Sorry. So he also has a question, and he had a question which is interesting. And what he's asking is, let's say that I filed my patent application in one country,
Yes.
and then I'm not submitting.
You are my professor. You can answer it.
So this is yours. And then he asks that if I go and file the same application in
Yeah.
another country, when is the right time? Let's say so that the other country does not consider my prior application somewhere else as prior art.
So can
that's
you
what he's.
talk it? Yeah. We'll get to that.
Okay.
Yes, we'll get to that.
So
We are talking about grounds, all the grounds. Yeah.
I just have a question about the global expenses. Isn't it a demerit when you consider if someone is buying in Pakistan, and because of the global research, if someone sees that this thing hasn't been filed in America,
Yeah.
and someone sees the opportunity and just file it there. So isn't it a demerit of filing a patent?
No, you can file it, but it may not be accepted. But it depends, you know, it depends to the country. Some countries or the examiners are not that trained. So they may not find. Yeah. We have it. We have this situation in many countries, I can say.
And what about the unpublished patent applications in the knowledge of patent examiners?
So the examiner can find it. But if that person, this is something we call interference. So if that person, I mean the person who has filed before me, but his patent application is not published yet. If he goes and sues, yes, he has the right. Because we have the first to file right. Who files first, not who invents first, but you know, yeah, this can be actually prosecuted in the procedure actually.
And the examiner can search prior art in the unpublished.
The examiner has access actually. Yes.
Access is one thing, but can he search?
Yeah. But when he has, because they have a database. Yes. But it's usually in the published documents. Usually, you can say. But then, yes, they do have access.
So one more thing, if the inventor is common in both the countries, so it means he
Sorry,
cannot,
would you repeat it?
if the inventor is common in both the countries, it means he cannot sue himself. Only the examiner can watch it,
Yeah.
can look at it, and he can just put some this reservation or something.
Yes. Yeah, exactly. And what we said about grace period, you remember? If it's self-disclosed, in some countries I have, if like 12 months, I have this opportunity to use this 12 months. If I have self-disclosed, in some countries, like European countries or EPO as a general rule actually, if I publish even one day before my filing date, yeah, your case is just failed. But like in Iran, we have 6 months. In Pakistan, you said it's 6 or 12. You don't have. So, yeah.
Answer to a question, you said that once I file,
Yeah.
after that I can advertise. But what if someone else also filed before publishing? And what if my application is not accepted?
Yeah.
So,
This is exactly what we talked about. You must have a strategy for that. And there are different risks. You have to take them.
so that
This
means
is
that,
it.
I guess that I should not advertise until my application is published or accepted properly.
Well, usually patents are on products which are like MVPs, they are a bit far from like going right into the market. That's usually it. Yeah. But yes, you can advertise it because you have filed it. And actually, researchers also do the same. They publish their works, they have to. They are PhD students, master's students, I don't know, professors, they need that. They want to like get grants and stuff. So you do it, yeah. But if the invention, sorry, it's very important, like if you disclose it and it's not accepted,
Yes.
so your competitors will copy that. So you have to, you consider the risks. Yes.
Are the examiners subject experts?
And sorry, can I add something? You can withdraw it also. I forgot that. You can withdraw it. And another way that I forgot again is that you go to an agent, you go to a firm, and you do this novelty search beforehand. This is a good thing. This is the right way actually to take.
I think the good strategy.
Sorry, your
A
yeah.
good strategy is like I should wait. First, my application will be published, and then I should go on to advertise.
No, you actually shouldn't advertise right after filing, but you must, this before publication is very important. This is an opportunity you have. You may decide suddenly, you may get that, oh yes, there is a document somewhere, or I know there's this close something which is similar, but mine is an improved version. So, okay, mine is not then I go to the firm, they say, yes, this is an improvement, this is yours, and it works, and it works in business actually. I mean, it raises your revenue, but if you disclose it, everyone will copy it, okay? So you withdraw the application and then it will not be published within the time which is, sorry, you wanted to add something and then we'll get to you.
I don't want to add something. I have a question that what about the examiners? Are these subject experts?
Yes,
For example, like in an example, you have shown that a novel method of synthesis of warfarin.
yeah,
So it means that this will go to someone who has background in pharmaceutical chemistry or chemistry.
Yeah, yeah.
Okay.
In most of the countries is that. Because when I'm not, it's usually called posita, a person having an ordinary skill in the arts, not very expert. Because if I'm a very professional person, everything is ordinary to me. It's usually that, isn't it? Yeah. So it's a person actually having an ordinary skill in the arts, but yes, he should actually, because when I'm not expert in that field, how do I know what is known, what is common in that art, and what is not? Yes.
The database which you are talking
Sorry,
about.
sorry.
The database which you are talking about, which have access to the autonomies.
Yeah.
This database is in the public domain. For example, there are, in chemistry point of view, there are certain libraries. For example, you are detecting a molecule and then you
Yeah.
have to pay for that. So
Yeah, we do
is
have.
it a specialized database, or if I as a researcher try
Yes.
to find out on the some certain
Yes,
base?
yes. There are open source. But if it's really important to you, you'd better, you'd better not to pay that much money for just searching one time. So if you go to a firm and they do know what to do actually, and they do have access to those databases.
Okay.
Yes, this is a better way, because you go and you don't know what to search actually.
You can search on WIPO database and WordPress.
Yes, yeah, Mom. Sorry. This is exactly what you said. SpaceNet, all patent offices have their own databases actually. Patentscope, Google Patents, I don't know, Lens is an Australian database which is open source, surprisingly actually. But it's good. It's especially for biological sequences. I add this. So they are, but they're not much really but there are many paid databases that you can use. And yeah, you can have many beautiful graphs and analytical data there that you don't actually have in those open source databases. If you want to use database for analysis, like knowing what has been the trend of patent publications over the time and what have been the key players in patenting. You can, if you want to use an open source database, the best one at the moment is Lens. But the SpaceNet also has, it's not that good. I mean, it's not, yeah, it's not that beautiful actually, but it is. And Patentoscope does, but Lens is better than that because it doesn't consider the duplicates, triplicates. Sometimes Patentoscope has this bug. But Lens in analysis, in patent analysis, having a general overview is of course better. So.
Sorry, I just want to make a comment here.
Yeah.
Especially for the DNA sequences
Yeah.
for that matter. We use NCBI. NCBI
Yes,
is
of
the
course.
National Center for Biological Information. There are other European center and whatever. And we put our sequence in that website. We do the blast
Yeah.
section.
But sequence doesn't contain the sequences disclosed in the patents. That's it. That's the point.
Actually, for in our case, many of the cases, whenever some genetic sequence is modified or natural,
Yeah.
it's being used or reported in either the reference genome,
Yeah.
in the reference genome database, or it's in ESD, express sequence tags,
Yeah.
and other stuff. So most of the times, scientists put their sequence in
Yes.
that database.
I
Whenever
know.
we
This is
do-
true. This is true. You should do both because it doesn't contain the sequences disclosed in the patents. And I would add EDI, EMBL.
Yeah.
This is both for both sequences disclosed in the literature and in the patents.
Yes.
That works too, but again, I would suggest for patents, let's.
I also have one comment.
Yes,
There are
yes.
many databases.
May I just go?
There are many patent databases, but there is no patent database which covers all patents. So for chemicals or pharmaceuticals or for DNA sequence, I would recommend that we can use SciFinder because that actually allows the search of sequence also, and it covers many databases which are very expensive and researchers cannot.
Yes.
So SciFinder you can search the structure, the sequence, and the claims which are mentioned in different patents. And they are-
Is it open source?
No, it's not open.
I know.
It covers everything.
Yeah, I know. Yeah.
And examiners are.
If I have
And it has very good flexibility. You can choose even the
Yeah.
basic
Yes,
ones,
yes.
and then go and add something. And
Yeah, like
it has a very
and Dr. Mishra actually added in Patentoscope, you can draw the chemical structure.
even if you take a picture from a book.
Yeah.
They can assess it and make it.
Yes, it is handed actually. Yeah.
True structure, yes, you can search.
Yes. So, can we go on? There was another box there. This was finding the closest prior art. That's we know actually what is prior art now. And sorry, we have not that much time. I have until 10:45, right? Is it? Yeah. So compares the claimed invention against the prior art based on 3 main criteria. It's actually more, but these are the main criteria. And what are those? Novelty, which is a general sense. We can talk about novelty, inventive, and inventive steps, especially like for ages. You know, patent examiners actually are trained, like in Europe, they're trained for few years. They're just reading the cases to know how to judge. Novelty is easier actually, but how to judge, especially inventive step. So we can talk for ages, but in general, as a general concept, the invention must show some new characteristic which is not known in the prior art. So if I have only one added characteristic, as compared to the prior art, it's novel. So inventive step is the other one. The invention must involve an inventive step that could not be obviously. This is an important term for patent examiners. Deduced by a person with ordinary skill in the relevant technical field. So I know it may seem complicated. It is complicated even for patent examiners, even after years of being trained. I think Dr. always can admit that, because you have probably been more with the patent examiners. And I know, but it's okay. But it's okay. This is the thing which can only and only be judged by an expert. So if you are basically drafting a proposal before doing the project, the best way is actually to do a search before going into that project. Yes, with the aid of an expert. Because you definitely, I can definitely say that we can judge this inventive step. I mean, you cannot say, okay, the idea that I have at this moment probably has inventive step when I finish this project. I don't know what happens. Maybe someone else does something. I don't know. And the last one is industrial applicability, that the invention must be capable of being used for an industrial or business purpose beyond a mere theoretical phenomenon. And this usually works always, but for some mathematical inventions, software, and some of the things in the health sector, yeah, it may be challenging even. So, yeah.
A question regarding this third one, industrial applicability.
Yeah.
Right? Might be there is some invention which don't have any industrial or commercial, value, but it might be an invention. Is it possible?
It's not that we say that, okay, this has like applicable this in this industry. It's judged based on like can you help me, Dr. Maurice? But maybe I can put it well.
So it may happen that in certain cases of basic research, you may have this problem of direct perceivable industrial application. It may be too broad to say that this applied in this sector, for example. But usually you can actually say that I'm developing this invention for this very specific application, and that's where you can. And this is actually required in Pakistan. It's a direct requirement of patentability. It's the least problematic to abstraction. It's the inventive step that all fits.
So just like the formal.
It's kind of.
Yeah.
I wouldn't say formal, but it's very close to just formal.
It means more. As I say, it must not be theoretical phenomenon. Like I have, as a general rule, whatever your invention is, you're limited with those characteristics must have a technical effect. This is what actually.
If someone has invented or created a new compound,
Yeah.
and he doesn't know that what are the uses.
Yes, exactly. This is what I wanted to
He knows
add.
the use, he can file a patent.
Yes.
If he doesn't know the use, then
Yeah, it's not this. I mean, you wanted to say this, is it?
Yes.
Yeah. So you may not know the application yet, but this is. I think I can explain it with an example. This is a real example for the first time that somebody basically programmed. had the idea, but on the paper for a calculator. Okay, so but it was just theoretical. It wasn't like it wasn't put in a device. It wasn't put in a real calculator. Like saying, okay, this is a program which is actually written on CPU. So the CPU uses what is actually saved in my RAM of that device, and the CPU does this operations in a process. If I have a mathematical like formulation, like if I have a mathematical theory that I know that mathematical theory does that thing, this is not an invention. Yeah.
Excuse me, when talking about inventive step, the invention must involve an inventive step that would be obviously could not be obviously deduced by a person with an ordinary skill.
Yes.
Is it debatable? It is not and cannot be coined from an ordinary person and skilled person. I mean, how did you try to draw that line between a skilled person and an ordinary person?
Yes. Actually.
So when you say ordinary skill, it means it's a skilled person. So for example, in this gentleman, Dr. Shafiq is actually in the area of biosciences, biomedical sciences. Generally, he may be considered like the expert. So somebody being on a little lower level, having the skill in the art has to have. I cannot be the first because I don't have any idea about this field. So first has to have some skill in the art. He must not be. But this is not a real person. So this is the interesting part. So who becomes the first? So it really depends on which procedure you're talking about. At the patent office, first is the examiner. And the examiner has to, I think, come down to a lower level to actually think like an ordinary person with skill in the art. In the courts, especially in the cases of invalidation or infringement, the judges become the first or the expert that are hired by the judges become the first. Now the third problem is that the examiner cannot possibly be the first because he or she is the person who is first exposed to all the inventions that are not even in the market. Nobody knows about them.
Yes.
He knows or she knows 5 years ahead of the time what will come after 5 years. So this is the kind of tug of war, and that's why this becomes so difficult to know what is the right.
It doesn't mean that they're not that professional.
Yeah.
They must basically adjust their perception, I would say. They must decrease the level. Yeah. They are trained to do that actually. And about
And we expert in the criteria of patentability.
Yes.
It is very important. Because the criteria of patentability is far different from the criteria of assessing and scientific article to accept in a scientific journal.
completely different. Yeah. And as I said, this is a level when I say, okay, I can judge inventive step, is after I have read many cases which are possibly even litigated. I go see, okay, what judges said, what patent officer has decided. Actually, I read all of those, they discuss it. Yes, they have meetings that discuss about the cases, and they learn how to actually judge. And for the inventive, this is just a very simple example. When we say that the invention must involve an inventive step, like a characteristic, which has a technical effect, of course, that could not be obviously deduced by personal. Okay, this is like I have this cup in the prior art, and it has one handle. So I'm the expert in this technology. This is very simple. I just add another handle. This is obvious. Somebody had thought about it. Yeah, and it does not lead to an unexpected result. This unexpected result is very important, especially in the biological patents. Because in biological patents, sometimes your innovation is very small, but it leads to a result which is completely unexpected. So even if it's small, it can be patented. It has this inventive step. Yeah, so this is, you are all researchers or professors, and you know, actually, you know what is what this inventive step means. You know, there are lots of researchers that when they want to start a project just for publishing, actually, they go take this paper from here, that paper, okay, I mix it, and this is a new paper. Yeah, he hasn't done anything, actually. It's just for publication, so it doesn't have that inventive step. So I think we have many other slides. And you're actually awesome, I would say. Thank you very much, all of you, because I didn't really expect it. All these discussions actually excites me, you know. And you don't know what's inside me actually now. So based on what we said, now I want to know what are the routes. We talked about the general procedure. This is the general procedure in all countries and patent offices. But what are the routes that facilitate this procedure for me? There was a Paris Convention, which I think is established at 1883, if I'm not wrong. Yeah. So there are many provisions that they all fall within these three categories, actually. The most important part is, I mean, in today's session, we don't want to talk about this. These are important, actually. We don't say they're not important, but we are talking about the routes and what is provided. This is more important for us. We won't talk. This is national treatment, common rules, and we don't have to, we probably waste our time. So right of priority, what it is, and how it helps me, how it facilitates my procedure. Again, I have an invention. I go to an attorney, I prepare a patent application with those characteristics, the thing that I showed you. Then I'm in my month 0. I file it with the Pakistan Patent Office. So this Paris Convention actually provides me 12 months that I can claim wherever I want to file my patent. Your question. Wherever I want to file my patent, this is not considered as a prior art, and I have 12 months to file my patent application in other countries or regions, like Germany, Italy, United States, or even regional patent offices that we talk about as a separate route to them. So if I miss that 12 months, what happens? I can't use it anymore. So this is only for those countries which are and which have signed that Paris Convention actually, and Pakistan is.
I have a comment. I once heard, and perhaps all the people who hear they can better address this comment. I once heard from a presenter that to patent something in one part of the world, it can be used in, I mean, you know, you can take it to a court of law in any part of the world because you have a patent in one part of the world, any country, it doesn't matter. I don't know if that is true or not. Would you like to address it?
It depends on the,
I
case.
don't know.
It depends on the case. When the case is in validation of the novelty, yes, you are true. But when the case is the freedom to operate,
Thank you.
I think the short answer that she already gave in the beginning. was that you get the rights which is territorial. So you get the territorial rights. You can only enforce your rights of exclusivity in the country which has granted you the right of exclusivity. And the basis of that is the general principle of sovereignty in international law. So a country cannot grant you a right for another country.
Yes,
That does not have the power.
thank you very much.
If I have published my novelty in a research paper that is
Yeah.
accessible to everybody around the world, and someone else in another part of the world makes a product out of it. So can I file a lawsuit that I have already published this thing, so we
Yeah.
cannot manufacture it?
Yeah. Or maybe the patent examiner finds it. But if it doesn't, yes, it does. And this is actually the way that patents get invalidated.
I have a question.
Yeah.
How to include Pakistan in PCT and what are the drawbacks, if any?
Well, this is something, the level of governments, yeah. I think Dr. Mitra knows it better. Doctor is asking actually how countries can be members, how can they actually, like,
No, it depends on the government governing system. In Iran, many other countries, like that, they have to have the parliament system. And if the parliament ratify and accept the joining system, and they send an official request to WIPO, and there is delegation of each country in Geneva, right? Okay. Ours is foreign ministry, I think yours as well. And they requested and they assess the situation. You have to have a minimum and standard level of the criteria, for example, number of examiners and the systems you have, connection to the WIPO, the electronic system, you are connected to WIPO or not. In your case, the acceptance and the implementation, it takes for I think like 6-5 years, okay? Because if we need to have some kind of standards, the number of examiners is very important, because when you join to PCT, it doesn't mean that just Pakistani people can file their patent through PCT. It means that any other countries, any other members of the PCT, should be there should be some facility that they can file in Pakistan as well. Okay, you should fulfill that criteria.
Yeah.
So
But you can motivate actually
there
the
was
government. If you have linkages,
okay.
It can
Yeah.
be started on government level. It
So
can be started on government level and we will be included as a member of PCT.
yeah. But you should motivate those who can actually do this.
So at the beginning, you said that Pakistan is fortunately or unfortunately not the member of. So this means that it might have some drawbacks as well, becoming the
Yeah.
member of PCT. So what are the
Because
drawbacks?
Dr. Mitra actually answered it.
But Ms. Fatima said that fortunately or unfortunately. Fortunately is good for that. For example, if you are a country that you are most using the technology, not developing the technology. And if you are a country like that, your technology level is not good, and you are the user, and very good and big market, for example, now for pharmaceutical products, okay? If you join the PCT, it means that you facilitate the procedure of patenting foreign companies here, okay? Otherwise, if you don't join PCT, when the other companies, the foreign ones, wants to come inside Pakistan and wants to file the patents and get the rights of protecting their products, whether pharmaceutical or
Yes.
they have to file in Pakistani language. They have to find a Pakistani lawyer. Okay, it is somehow maybe difficult for them. Okay, in that way, you facilitate entering the other countries and companies. So we cannot say that, okay, if Pakistan is not a member of PCT, it is very bad for Pakistan.
Yeah.
It is a policy.
Yeah,
Thank you.
exactly.
In Pakistan, we don't have to file our national language. We file in English.
Your official language is English?
Yeah, and documentation, yes.
Documentation is
Because in each country, you should file for their national language. Maybe English is accepted as your national language.
English is not a national, Urdu is national language, but English, sorry, legal language.
Official,
Official
yeah,
language.
official language.
Official language. Official proceedings and everything is in English.
Because in Iran, the official language, for example, is Farsi. When other companies, for example, know where it is, when they want to file patent, they have to
translate.
Yeah, they have to translate and the translation, because in my institute, Custom Institute of Iran, we are somehow are examiner of the foreign patents, and because they don't, they can't find good, attorneys in Iran, they just translate like Google Translate, and everything was awful, and in that case, we reject the patent.
Yeah.
That's awful.
I'll go to you.
I have a question about the duration of the patent right, penalty rights. It is only 12 months per hour to go. 12 months.
Here in this Paris Convention,
It is 12
yes.
months.
From the very first date that you file your patent application for the first patent office, it starts. You have 12 months. But PCT, that if you have enough time, because I have promised Dr. Ovis that I will finish at 10:45.
I was just saying that.
No, of course, this is the schedule. And PCT provides 30 months, which is really valuable. And we say what cons actually has, this has pros, but it also has cons. Compared to PCT of course better. But this works sometimes, even for those countries which are PCT members, and they have that actually facility, we can say, they can use PCT, they go through, it's not like choosing saying, okay, there's something that I check, I go through Paris Convention, not that. But when you don't file PCT application, so you don't go through that PCT. Okay, so when I want to file in like 2-3 countries, maybe less than 3 countries, because you blink and the 12 months is over. So I want to like file it in Pakistan, I want to patent my invention in Pakistan and maybe Germany. I found an investor there. So this works there in those cases. So
I have a question. So
Yeah.
can you go back to this last one? So let's say I miss the 12-month period.
yeah,
I didn't file, let's say I filed in Germany in the United States in a regional patent office, but I did not file in the UAE for that.
yeah,
And I want to file now.
yes.
What will happen? Can I file in the UAE?
I don't know there, but some countries have some extensions, but they're not much, like 1 month, 2 months, like that.
So
It
I will
depends
not,
on
I
law.
will not, let's say generally speaking, I will not get a priority.
No, you can actually claim the
I
priority.
can't claim the priority,
Yes,
but I can still file.
yeah, but like you have filed this, and Pakistan, for example, Pakistan Patent Office provides this opportunity that if you have filed and it's not published, like you can withdraw it. So you see that, okay, I don't get time. So why do I file here? It's because I want the examiner to search the prior art from here, before. But if I can withdraw it, it's not published yet, and I can start a new procedure, actually.
But in Pakistan, abstract is published next month.
The title is not yet.
Yeah. So I set here regional patent office here. So what are regional patent offices? And they actually provide a new route.
Can you just briefly summarize? For example, in 2020, I filed one patent in Pakistan in 2020.
Yeah.
And I filed the same patent in Vietnam. Actually, that is the case I'm already going through.
Yeah. Yeah, you can go through this Paris Convention and you can claim the priority of Pakistan, your Pakistan graph.
But because from if I see the starting date, filing date that is in Pakistan is that I told you is 2020. But
Oh,
it's
yeah,
now-
so it's past actually?
Yes.
Yeah, so no, you can claim the priority. Is it published?
No, it is not published. It's under the.
If it's not published and you know like it's patentable, it has those criteria, so it's not published. You know, I may file this here and it's still it is patentable here and it's not published, and I may file it here and it's still patentable. There's nothing published actually. It depends, it completely depends on the case, yeah.
What if a person files an application in Pakistan and after 6 months he publishes the as well, and then a person in another country sees that research and after passing during 12 months he cannot file that, but after that
Yeah.
12 months can he file in another country which he has not filed because he has not
You
patented
can file it, but if it is published, your own work is your disclosure actually, your self-disclose. You know, it's a prior art itself.
When you file an application, then you can publish it.
So
That's a
we
different-
kind of mixing several concepts, right?
Yeah,
There's a publication which you publish in a journal. There's a publication which is in the patent journal, which the patent office does. After all, just like I saw I showed the
yeah.
graph yesterday, acceptance, application, publication grant. So you're talking about the
I am
self-publication.
self-published article, etc.
As she mentioned in the beginning, you can actually publish if you want, file it, publish it, it's your choice, you can do it. But once you publish it, and then after the priority time, you go out and you try and get a right in another country,
Yeah.
which was also the difference I was asking. You destroy your novelty by yourself.
Yes, by
So
yourself.
that's what she said, that you were self-publishing and you were self-destroying your novelty. And I think also after.
Yeah,
That point in the beginning. Yes, in the beginning that. The gentleman in the front, he asked that if he has filed in 2020 in Pakistan,
Yeah,
can he file in 2022 in the US? You can. If it's not published, you can. What you can't claim is the priority.
yeah.
So
You
the
can
only
claim the
thing, the
priority.
only thing you can't claim is the early date. So what will happen in the US? And that's why she's emphasizing publication. What happens in the US today? For them, the prior art starts from today's.
2022.
Why do
It
people
starts from-
claim priority? I apply in Pakistan and then within 12 months I want to go to some other country.
Yeah,
What's the benefit of priority for me? Those 12 months, even though I did not apply in another country XYZ, because of priority, XYZ will only check my prior art before the priority date.
yeah.
So for 12 months, whatever is published, whatever becomes public knowledge, does not destroy my novelty.
Yes.
So that's why you go for priority. That's why she's emphasizing so much that priority is important, and especially if you don't publish yourself.
Yes.
Here I
Then
want
if
to ask,
this work of 2 months, then check it from after 2 months or 2 years. That
Yes.
that may be some-
In case if you do not.
Yeah.
lot of research can be done.
if the inventor publishes and he wants to apply to another patent office, another country, can he claim the priority date that he first applied in Pakistan and then he published? in the
Yeah,
journal?
yeah,
But
During the 12 months is.
Yes, it's okay.
But he can, if
Yes.
he publishes in the journal, then he can.
Yeah.
She.
And your question, like you have fun in Pakistan, okay, you want to go through this Paris Convention, okay. So you missed the 12 months and it's published, maybe not Pakistan, like you have filed in US. So you have filed in US, you missed this 12 months, and then you want to file to Germany.
Yeah.
US has published your work after like a period, it's maximum 18 months, but it may be published actually. So if it is published, your own work is considered as a prior art. Yeah, it's your own work, but it's a prior art because it's disclosed and it's in the public domain, and you can't claim the priority of this one in this application called month 0. So this is also a good route for those countries which are not PCT members actually. There are some regional patent offices that, I mean, countries have come together and they have come to an agreement with each other that, okay, we have just one, we can have a patent office that can get all the applications from anyone who wants to apply for protecting his invention in just one patent office, and that applicant can have a bundle of patents in those countries that have agreed on it. And I'll show the regional patent offices to you. So I have one single patent application, and I file it to a regional patent office, for example, in Europe or Africa or Asia. And then I have it, but the process goes on, like examination and stuff like that. Formal requirements are examined here. And then I have a bundle. So I just prepare a single patent application. It might be needed because in most of them it's like that. When you get here, you must be validated. I mean, that patent application must be validated in each country. So it might need some minor things like just translating only the claims or maybe just translating the patent application, but it starts with one single patent application. What's the difference? Here, you have 12 months. If you have filed it in Pakistan, you have to go a patent attorney like in Germany. Okay, you drafted for me in this format, like German language, you file it, and then Italy, and then United States, and you may miss this 12 months due to this. But here is just a single application. It starts with a single application. So the regional patent office is the most famous one. European Patent Office. It includes 38 countries that you can find it on its website, all of them. The African Regional Intellectual Property Organization, or ARIPO, which includes 21 countries. They are English-speaking countries. The African Intellectual Property Organization, AIPO, 17 countries, French-speaking countries. Eurasian Patent Organization, those countries, I mean, not all of them, but the countries in the Eurasia. So like Russia and Tajikistan, like that. Patent Office of the Cooperation Council for the Arab states of the Gulf, GCC, 6 countries, and these are the countries that you can actually proceed through the regional patent system.
Is Oman one part?
Sorry?
Is Oman actually Oman is also part of it.
I'm not sure, maybe it's added. Oh, okay, so it's there. So this is an example, but this is the same in other ones, just maybe minor differences. In EPO, you file your application and so bottle of water. So, on farmer application, the search procedure starts within 18 months. I have the opportunity to withdraw. And maximum 18 months, it will be published. Again,
One thing, we take a break of
Yeah.
a few minutes. We'll just take a few minutes break.
Well, you can ask some questions from other people.
Yeah.
We just, yeah, we just.
So for Pakistan, whereas I'm saying, I will keep this one.
May I ask you a question? Do you think that if we have a regional or textual patent system or authority or such like that in Islamic countries, for example, in this 57 countries in the OIC region, we have?
Sorry.
I don't think so. Do we have, for example, like EPO, like GCC, like Article? Do we have something like that in this OIC? I mean, this 57 Islamic countries?
Sure.
Do you think that doesn't work if there is? Perhaps.
It might work like OIC.
You don't know what is OIC?
I guess if you have some sort of these regional organization, it might work like this OIC is working right now.
You know, it means that if OIC countries agree on a decision to have such kind of organization or authority, it doesn't mean that this organization can just file a patent, because these Islamic countries that have some things in common, and they are mostly in not near level to each other. It can have some kind of development program and to unify some system to help the countries. Because when you, for example, in WIPO, we have a very fluctuation in different countries. For example, Switzerland is different, far more different from, for example, Afghanistan and Pakistan and other countries. Okay, but we have some kind of common language together. We are trying to do something in this issue, and as I said yesterday, we have all the time in any policy, in any decision, we have top-down approach and down-top approach. Down-top approach is a request by people, by researchers, by technologies. You are such like ambassadors of this course, okay? To go and say and promote such things. It is very important. I think OIC, I mean the regional treaty and organizational authority can help. Today, we have at 1:30, we have a short lecture by Mr. Chaudhry, and the other one, I mean, Chaudhry from, I mean, the representative from Pakistan in Geneva, who is, I mean, contributing IP work of Pakistan in WIPO as well. He's going to have a short, talk for half an hour. But if you want to add something, please say at that time, okay? Very important. It is very important. Thank you.
So quickly कुछ ऐसी चीजें थी जो priority और I'll go in Urdu right now. So बहुत सवाल आ रहे थे priority of filing के अलावा. I'll just take 1 minute. हम जब भी priority का मतलब
Can stay for hours.
Oh, we have friends from Uzbekistan, so I have to go back. When we think of priority, what comes before the word priority in terminology is the word filing. Okay, so life does not start with priority; it starts with filing. You file in the US, and you're not thinking about filing anywhere else. You don't even have to concern yourself about the word priority because you're not thinking of filing anywhere else. The date that you're thinking about is called the filing date. Now, from the first filing date, in the ensuing 12 months, you can file in different parts of the world, different countries of the world. And if you would like to rely on the first filing date, in the subsequent countries, you will call them that date. And in the subsequent countries, you will have the filing date on the date on which you're filing. So the priority date only matters if you start thinking of filing in other countries. Otherwise, you don't even have to think about the word priority. Only filing in Pakistan, you're only concerned with the word filing. If you don't file within 12 months from the first filing, which is priority date, you lose the priority. You only lose the priority. You don't lose anything. You can still file in another country after 12 months, in the 13, 14, 15 months, as long as your invention has not been disclosed. So the important word is disclosure. That would include, as Ms. Fatima actually also mentioned, your self-publication, your publication by the patent office, somebody else publishing it and destroying your novelty. So disclosure is the word that is really important, and that will include all the kind of publications. Yeah. So these were I think a couple of things that were required.
What about the 20 years? Like from the priority first
It starts from the priority date.
By disclosure, you mean disclosure form, disclosure of the title, disclosure of the abstract.
Enough disclosure. Okay, so that is something that she will answer better. But enough disclosure to actually enable a forfaiter or another person to actually make the invention. Enough disclosure. So it has to be sufficient.
Subjective thing.
Patent law is subjective. Honestly speaking, and that's why we are having so much. It's always like this. When I teach patent law, and I'm pretty sure when you teach patent law, it's so difficult to teach patent law because it's so subjective. She has been trying, like everyone else in the world tries to tell you about inventive step. It's honestly that's not that easy. It's very difficult when you're standing here and you think, how should I tell them?
Patents granted in one country, the same patent is rejected in another.
Yeah. And inventive step, they were so a little bit of history, a little very short. Inventive step was not part of the laws. It was only novelty, and it was only industrial application. And industrial application was not that important. Even in Europe, and even till I think at least 1980s, I think Greece, Spain, and Italy did not have inventive step required. It's only in the recent past that countries had to actually introduce inventive step in their laws, and inventive step is the area of the room that gives you the room to wriggle because it's subjective. So the court is actually thinking, will this be obvious? So one judge will say, and it, not only the patent granted in one jurisdiction and not granted in court cases, two judges or three judges are saying, two judges are saying one thing, and the other judge would say, no, it's obvious. So there's a dissenting note, and it happens so much in the United States. You almost always have a dissenting note in the patent cases.
And
So
that was this news that a judge who was a cool judge retired. I said, was retired, and though all those patent attorneys who were working in the sector of biotechnology they were sad actually, because Because they said, yeah, she was really fair actually with them and with the cases actually. Thank you, doctor, for helping me and Dr. Mishra. Yeah. No. So this is the process. It's actually the same, but it's important that we know in EPO we have this 18 months that we are allowed to withdraw. This is important for businesses actually. And here I will have as the applicant a search report on those criteria.
If somebody puts an application, what are the major reasons why you would like to withdraw the 18 months? I mean, what would be the major reasons why would you or that person withdraw the application?
Say, for example, I have this product, like this is an MVP, minimum viable product that I have. I file it here, and at this point, I get that I didn't know, but the major characteristics, except for some minor improvements, are disclosed before. They are in the prior art. So if it is published, even my minor improvements get published. Yeah. So I withdraw, or for the cost, or even I have this MVP, I go to negotiate with the investors, and I understand that, okay, I get that this doesn't work. No one wants it. Why should I pay that much money for something which I can't probably commercialize it? No one wants it. Yeah, it has no market actually. So here I get a search report, and here I can actually, my attorney can negotiate actually with the patent examiner on these criteria. Like the patent examiner says, okay, this is actually patentable, but you must narrow your patent claims if you want it to be patented actually. So again, that is space that I showed you. I have claimed, I have opened my hands, and I say, okay, this is mine. And then the patent examiner actually modifies it. No, you should narrow it. You have this, you shouldn't claim this. So this kills innovation actually. This kills innovation. So that's why patent offices actually are trying, they're trying very hard in any patent application, especially in the developed countries. If you file a patent application, you see that. The patent examiner tries hard to narrow your claim actually. They take it simple with the inventive step. It's not, it should be actually somehow that's satisfied with that, with having that criteria. But the main thing is that they are tough on narrowing your claims to exactly the innovation that is there, not more. So, and then here, it will be granted. This may take maybe even 5 years, 3 to 5 years, yes, or even less. And but there are some exemptions, like in those inventions. I mean, you can just fast track the process in the inventions. Maybe that are really important as considering the environmental aspect. They can be used in those applications, or health, like those inventions regarding COVID. Yeah, they were all fast tracked. We had inventions in Iran that they were granted in 6 months, like what was really weird. Yeah, you can fast track them due to situation, and just you can apply for it. So until month 48, 60, there is a 9-month opportunity for the competitors, the proprietors, competitors, to file an opposition saying that say to patent examiner, okay, look, patent examiner, you should consider this document that I found, but you didn't. So you can invalidate actually the whole process that you have gone. So this is 9 months. And then from this point on, it shall be like in all countries under EPO, under, I would say, European Patent Convention, who have signed that agreement with each other. So it was validated nationally. So they may want translating like abstract and claim or abstract, but EPO generally has an official language. I think it's English, German, and French. If I'm right. Is it more?
So I think at the EPO there was that, I don't know now, but before the national validation had to be done
Yeah.
for each of the EU.
Yes, yes. But I mean,
27 languages.
yes, yeah, but I mean, the official language is
Yeah,
this.
yeah.
I mean, you have not made choices. So you may do not need, I mean, you may not need actually translating your application. But they have different provisions, they may charge you again. This is definitely the process. So. And these are the fees actually, is changed from April 1. This increased actually the standard filing fee, European search fee. And if you choose, I mean, if your examination is actually done by EPO as far as I know, and then you file for USPTO, you can, I mean, you're granted a kind of considerable discount. Yeah, these are yours. Yes, yes. I forgot to put it. I mean, I got it from a website actually. So again, going back to that figure that we had, what are the cons? Based on what we said, can you say what are the disadvantages or what are the cons of this Paris Convention? This was another route, the regional patent system, but through the Paris Convention, you can file directly after the first filing, you can file for a country or a regional patent system. So I file in Pakistan and then I'll go to EPO because I want my invention to be patented in several countries, yes. So what are the, what do you think are the cons with this Paris Convention that is it?
Priority rights.
We actually said
Priority rights.
priority rights. What do you mean by priority rights?
The person file of application in Pakistan,
Yes.
and he not only saves the priority rights but also the patent.
Yeah.
And he have a duration, she have a duration of 12 months.
Yeah.
So go to a regional office, just like EPO.
Yes.
Then he can file another application. Yes, not only the priority right, but also the patent.
Yes.
That is, Pakistan has to have another regions.
Yeah. So, but I think this was a pros. Right?
Non-dates are different in different countries.
Sorry?
The patent grant dates are different. And time durations are different.
Yeah, of course, they have their own procedures. This may take 5 years in Germany, it may not be accepted, it may be failed, it may be granted in Italy, it may take like 6 years here.
But in EPO, you have the same.
But you still have the priority.
The filing date would be the same if you're filing on the same date, even in the Paris Convention. If you're filing on the same date, if you're claiming the date same priority, the rights will be for 20 years from the priority date. The difference in grant dates, it does not really matter. Except And the Pakistani law, for example, you cannot institute a suit for infringement unless you have been granted the patent. So that's a Pakistani law, and I think that's what that also stands.
Yeah.
I think one of the cons would be multiple applications, so we have to actually go and file and all these.
Exactly.
Right?
Yes, yes. Yes,
I think
you're,
it was so obvious that people, everyone knew this. But I think it was so obvious that.
yes, and what you said was true. Like in a regional patent system, you have just one patent office, and that one patent office examines, yeah, instead of all those countries. But here, each is separately examined. Yeah. So this is one of the cons, actually. And what if you're not sure where to file? Because it's costly. You want to go, maybe find an investor. Do you get the time? You are preparing at the same time your business plan. You are doing all those stuff with the
Also, it is costly.
your feasibility study. Yeah.
Also, it is costly. We have to pay the individual fees for all the.
Yes. Yeah. Right. So it requires, as Dr. always said, requires preparing multiple applications with multiple formality requirements. Again, makes it costlier. So, and we don't get in those 12 months, is it patentable? No examination is done there. I mean, not that no examination, because I have gone exactly to the national phase. So it may not be patented in Pakistan. And the patent examiners find something. And I have filed with the patent offices like Germany and Italy, and I've paid. So I've just wasted my money. Yeah.
But it is also possible that patent is granted in Pakistan but it is not granted in other countries.
Yes. Yes, yes, yes.
Or patent is not granted in Pakistan and we may have patent in other countries.
Yeah.
And it even becomes more interesting under the PCT. It may also happen that you're filing through PCT.
Yeah.
20 different countries, you get a patent granted and then you don't get a patent.
Yes. Yeah, yeah.
File the same. Yeah.
And I just wanted to ask just all of you, we are actually done now. So we can stop here. And Dr. Ovis is gonna talk about all the formalities in Pakistan and the procedure, actually, the national phase in Pakistan. So it's up to you.
You want to talk about PCT?
Yeah, I want to talk just not that much, the details.
I think you should continue.
Maybe a brief. Is it okay, everyone?
Yes.
Thank you. So this PCT doesn't, I mean, it has fixed all those problems, all those cons, actually, I would say. So it stands for Patent Cooperation Treaty that makes it possible to seek patent protection for an invention simultaneously. This is important. In Paris Convention, it wasn't simultaneously. I have filed for a country, and then I go to another country, but this is again a single patent application simultaneously, like in 155 countries. So this makes it completely easier. And by filing only one international patent application. And this is important. PCT application, it may be filed by anyone who is national or resident of a PCT contracting state. Pakistan is not. But is it not possible that we use this? Of course it is. It has some non-ethical, I would say, traits. But I won't say that.
I wouldn't say they're non-ethical. It's like if you think that if Iran is, for example, I can collaborate with you.
Yeah.
And ask you.
And maybe some of the traits. Yeah. But yes, you can have a co-inventor who is either national or resident of that country, which is like Iran, or any other country which is a member of the PCT, or even if you must have an address. Like I go establish a company in Iran or any other country which is PCT member. So I have that address and I can use it. Yes. So you can do it in other these ways. So it is possible if you need, and from the moment that you file your PCT application, it's patent pending. So you can go, you can have your pitch deck, for example, and you are not actually concerned that, okay, I'm disclosing my invention actually, and you have 30 months. This is considerable. Yes, this is significant, I can say. At the moment, I think it's 155. This is updated actually. Is it right? It was 154 and one was added a few months ago. So how many non-PCT countries are there? Just for your record, maybe. There are 39 countries that are not members of the PCT. And for 23 of these 39 non-PCTs, you can use Paris Convention that we talked about it. But for the rest, they actually don't have any IP live. So they're just doing their own work. Or they may have some local laws. Some of them, maybe 4 of them, I think, they have some local laws that states that, okay, so if you have gone, filed your patent application and it's published even in countries like UK, US, Australia, those China developed countries based on their law, you can re-register it in my country. These are local laws, but they're not that important. So again, saying what are the cons of Paris Convention? This is a question. Which of these 2 quotes is correct? This is very important.
Actually was so detailed.
Yes, yes, it was. I just wanted to check if. Yeah, of course. Thank you very much for that. So if somebody came and wanted to, okay, give me that much money and you have an international patent because we have it in Iran. They charge you with really, I mean, you can say so much money, and then they go and you actually have an application, you don't have a patent. So just general procedure, me again, applicant, in month 0, I file a single patent application to the International Bureau of WIPO, World Intellectual Property Organization. And I say it may be directly or indirectly in the second slide of this. And I get 13 months. And this is the opportunity I can choose the countries that I want to enter the national phase in those countries. The whole, this 30 months is patent pending. Or I mean, my invention is patent pending. That's why in many products you read this patent pending. It may be PCT application or any application which also has the same thing. So at the end of this 30 months, it must enter in national phase. If before this 30 months, we have not actually checked those countries, PCT does this actually automatically. I just check them. That's a formal thing. That's really easy. You prepare the application, you don't need an attorney. Of course, it's better that your application be drafted by an agent, an expert actually, but you can file it yourself. By filing yourself, you don't have to pay somebody. Like in Paris Convention or any other countries, when you're not national or resident of that country, you have to basically employ a attorney, a registered attorney of that country. So here, no, it's not needed. As I said, there are two direct and indirect procedures. The direct one is just e-filing your application through WIPO International Bureau, and the indirect one is filing through the receiving offices. All those patent offices in the PCT members, they are receiving offices. So what must application include? What we talked about it. Claims and description, they also should satisfy this sufficient disclosure, drawings, and formality requirements. Like you have to fill forms, names of applicants, inventors, addresses, and stuff like that. So it has this platform completely online, very easy. And it has all those videos training you how to file. Just pay the fees, determine international search authority, like saying, okay, I want EPO to be my international search authority. There's a list in the website of WIPO that all these international search authorities are actually mentioned there. And you have to you can decide based on the amount of money that you want to pay or the country that you want to proceed. And this paying all the search fees and examinations and stuff like that. In PCT, it's called search fee. So these are exactly the fees that must be paid: international filing fee, transmittal fee, and additional fee for more than 30 pages. But this is important. There is a waiver for e-filing, and that's obvious. Who does not use this? Put this aside, and a very good waiver, I can say about 90% reduction that we use it in Iran. If the applicants, all of the applicants, not the inventors, you can have a co-inventor from a developed country. It's okay. But the applicants, either being a legal, actually, either being an individual or a legal entity, so they must be national or residents of a least developed or developing, or some of the developing countries. There's a list. WIPO publishes this and updates this, I don't know, maybe from time to time. So you can check it, like Iran is one of them, and we use it. And it's really worth it, but it's nothing. I think we pay, I don't know, I think it's 100 euros, something like that. It's really worth it. It's really worth it. But if it's not, I mean, if you don't get this favor, it will get to more, I mean, it will be more than 1,500. So these are the fees actually. I'm not sure all of them are updated. This is that e-filing reduction that I told. And some of the search fees of the known ISA or international search authorities.
Can I ask you something?
Yes.
So for example, India, and I know that India is an ISA. Why would I not choose India? India's cheap.
Yes.
It's $32. So why would I not choose India?
Yes, thank you for saying that. Yes, I forgot. One of the pros that PCT has is actually this. You go through this PCT route, you have your priority. So you have this 30 months and you have a search report. There is something provided in PCT. PCT is actually 2 phases. We are not going into details because we don't have time, and you will get tired, of course. But it has two phases. In the second phase, you can apply for a preliminary examination, sorry. And in that phase, the examiner shall actually investigate every technical aspect of your invention based on those novelty, inventiveness, and industrial applicability criteria, and all other criteria that actually are assessed. So if I want, for example, this happens actually. Why? Because investors usually like a granted patent. When I go to them, I say, okay, I want you to invest on my what I have actually produced. So it says, how do I know you have exclusivity? Just say, I have filed an application. Everyone can do it. Just draft an application and just file it. How do I know this is exclusive actually? If I give money on this, this is mine, only mine. So this helps actually because you have a search report. You go and say, okay, you see, this, for example, EPO has examined my work. But when you choose countries like India, what happens? India does not have a good examination system. So it's just rubbish, I can say. Definitely rubbish. When you choose it, we choose it in Iran because it's not important for us because we have Iran Patent Office. We examine the cases ourselves and only file those cases with the USPTO that we're maybe 80% or more sure that it has those inventiveness and novelty criteria. But in other cases, this usually works. India, I can definitely say they don't even read the case. Like, okay, this like everything which is like this, just the shape is the same. They go find it and they put in that report. It has no relation with what you have actually filed.
I have one
But it's cheap.
question. For example, if you file through PCB, we pay some specific fee for all the countries, like 155 countries?
No. Just the fees that I said. But then, for example, in this 30 months or even earlier, you choose, for example, I want these 5 countries. I have decided that, okay, my potential market is in those countries. So then when you go into national phase, then you have to pay those fees. Yes. So this is general procedure and they're actually done. Patent application filing, direct, indirect, we talk about it. It goes, I have chosen an ISA or an International Search Authority here. It goes there. Look to number 3, a patent search is done. International search report is prepared and then is sent to the International Bureau of WIPO in Geneva. And then this WIPO, as we talked about, it has a database and publishes all those applications in this database. This is maximum 18 months from your priority date. This 18 months that we are talking about is measured from the priority date. Filing in the first patent office.
So even in the case that I'm filing, let's say, after 11 months, 29 days, on the last day of my project.
Yeah, it may be published very soon.
So it would, so the WIPO, the ISA will have the responsibility to examine it
Yes,
and publish
yes.
it. Not, sorry, search it and publish it within the next 6 months.
The application itself must be published, but the
It's
search report is
unsearched,
not
it's
saying that
unexamined,
the search report must be published exactly with the, but the search report is published too. So this is, and you said why not choosing India?
Yeah.
If I'm really working, I do really have a business. This is serious. I have a patent application, I've chosen India, and there is this, I would say, messy a search report from India there on this database, and everyone can see that. So what that means, you have not valued your own work yourself. And yeah, for example, India hasn't even read your case and has actually said, okay, this does not have inventiveness and novelty. So this matters actually. And yes, after 3 months, 30 months, it's maximum 31 months in some of the countries. But 30 months, you have to decide. And the application is automatically sent, but you can choose to file separately, not through the PCT. You have filed PCT, but you decide sooner, you don't want to wait until the 30 months finishes actually. You file it separately yourself. But if you don't want, you can wait until the, through this PCT procedure, it will be sent automatically to those. This is a sample of international search report. I don't know, maybe you cannot see that. Here are the categories. You may have kind of similar search report in Pakistan or your country. Category X, like X means it doesn't have novelty, Y means it doesn't have inventive step, Y because the examiner has found this document which basically says that your claim like 1, 2, 3 does not have novelty based on this document. So this is international search. And this is called written opinion. It just says, okay, claims like 1 to 11, they have novelty or they don't, inventive step and industrial applications. Just that. This is in the initial examination that is actually done for every application which is filed with the PCT. But if you want, you can enter phase 2, which phase 2 actually costs more, and you can have a research report with more details, like the search reports that we get in the national paper. Yeah.
So, okay. So let's just quickly differentiate between what an ISA does,
yeah,
and what the national office will do in the national paper.
Yes.
So an ISA is actually only giving you citations that exist. It's not saying that we will refuse your application, we will not send it to the national paper. So that's very important.
But they examine the claims actually.
Yes.
They say this claim does not have novelty or inventive step. But what is the advantage for me in this step? If my application is drafted well, I have this opportunity that before going to the national phase, I can modify, I can amend actually. I can amend my text. Yeah. So all the procedures of national phases will be basically facilitated. All the negotiations that my attorney is gonna have with the examiner, all those response that I should prepare for that examiner, they will be decreased, of course.
And that's also where your comment about my question about India comes in. If the ISA is not doing its job well, I will not know what can hit me in the national phase when the examination is actually happening.
Yes.
And the examination officer says, I'm going to refuse you your patent in this country because I did not know whether something was existing. And that was the first time I actually got to know. That's why you need it.
Thank you. So this is completely showing that the traditional, the Paris Convention has 12, and this is 30. This is nothing. It just passed. Okay, we talked about the pros actually, but I have brought them here for you. You can read them, like producing costs, chance to have novelty check, postponing national phase fees. You go get some money for national fees that you are gonna enter after 30 months and you're still patent pending. And provides more, I'm reading from bottom to top, sorry. And all the things that we actually talked about them, we don't have time, but I think you know about the provisional application. It's not needed to be described actually. but this is a very good option. Provisional application, as far as I know, in USA, costs like for small entity, it's like I think $150, and for micro, it's 75. And really worth it because you will be patent pending with just paying that. And it does not publish. This is important. You have not completed like improving your product. So shall we finish? I think this is the last slide. Just saying the procedure in USP2 is completely the same. It differs, of course, in some provisions and rules. But in general, I want you to know that you can file a utility patent. It's all those, we said, devices, compositions, processes, and stuff like that. Design patents, which are like industrial designs. I think we had architects here. Yes, you can use this design patents, which may be obtained by anyone who invents a new, original, and ornamental design for an article of manufacture, any article. So the subject matter of the design patent relates to the configuration or shape and plant patents. Just saying that this plant patents is specific to USA actually. In other countries, it's like in Europe and most of the countries, you can patent the plants only and only if it's obtained. This is specific for those working in biotechnology by like genetic manipulation and something like that. Yeah. But in USA, you can also, it may be obtained by anyone who invents or discovers and asexually reproduces any distinct and new variety of plants. It doesn't say that it must be produced through a technical procedure done by human, like those genetic manipulations. And
just to add to the slide, we have a registered design law, so we have registered design. We are not calling it patent. So in Pakistan, we don't have design, but I know that the USP2 slide. And just to clarify for the.
And yeah, I'm not an industrial design expert.
No, I'm just saying that we call it.
I know it kind of differs. It's not the same. Design patent is not completely the same as industrial designers.
In Pakistan, we don't even call it a patent. So it's a design. It used to be called industrial design, and now it's called registered design.
And in most countries, I guess.
And I also know that we do not have something like plant patent. We do have a law on plant breeders' right.
Yeah, Iran is actually the same. So thank you very much, everyone. Sorry for taking your time, but I exceeded my time in all those cups and
For our taking, we can take a 5-minute break so that everyone can stretch their legs and fill their stomach with tea and water. 5 minutes. 5 minutes. I also. Now the Zoom lady has actually suggested that I should start because the recording is in progress. My name is again Dr. West, and Fatima did an amazing job. So she has clarified so many concepts, and this makes my job much easier. And I hope that I will not take too much time because what I'm going to discuss is very boring. That's the disclaimer. All I'm going to talk about is the procedure, and I'm going to show you the forms that you will use on different stages. I'm not going to talk about substantive law. We have already discussed novelty, inventive step, interest in applicability. I'm not going to talk about whatever strategy you can use. All I'm going to show, what I've done is simply I put all the forms in one presentation. That's all I've done. And I can also tell you that this is the form, this is the fees, this is my job today. Much of it has already been discussed by Fatima, and The thing that needs to be emphasized is that Pakistani patent duration is 20 years. 20 years start from the filing date or the priority date, whichever is relevant. We have discussed about territorially limited, and we have also, there's one thing that I would like to really emphasize is that Fatima already mentioned that claims are the most important part of a patent application and a grant. And always remember, an infringer infringes the claims of the patent, not the product. So if the product is not according to the claims, actual product, and somebody is copying it, that does not mean that they're infringing your patent. They may be copying your product. If you're not making your own product according to the claims, you actually do not have any claim against the infringer. So that's clear, right? Okay. So these are different stages. Yesterday I did not mention in my presentation the stage of search. The stage of search is a pre-filing stage. Fatima already mentioned that. It's always, it's not just, I should not use, the right word is advisable, but that kind of hides the importance of search. So it's not simply advisable. Let's say it's a must that you actually do the search. And that's why it's important, and professors have also mentioned the different patent databases that are available for free. One of the problems that I've seen, especially working with startups, that they don't look at the patent database. You as researchers do, but startups, they don't. And then they want an exclusivity for 20 years for something that they're not even sure that whether it's patentable or not. So important thing is to actually go to the database, maybe, I don't know, forget about yourself being a founder or the CEO of the startup. 2 weeks, 3 weeks, whatever, and search as if you want to kill your invention. That's how you should search. Search as if you want to destroy the novelty of the invention, because that's what Dr. Mitra and Fatima also yesterday said. The examiner is sitting there to actually ensure that he or she is not granting a patent on something that exists already. So think like an examiner, try to kill what you're doing. It sounds strange, but it's important. So these are different stages, and we have different forms for different stages. In Pakistan, we have different forms for different levels. I've not mentioned about the mentioned application forms. So most important for you all as researchers is P1A. So P1 is the name of the form. P1 and P1A, you usually use these two forms as Pakistani applicants. So P1 is when you yourself are the inventor and yourself directly applying for the patent. Okay, there's no university, there's no other applicant in the middle. That's what you use, and that's the fees. P1A, when you are the inventor, but you're not applying. The university is applying on your behalf, or your employer is applying on your behalf. That's what you use, P1A. Okay. With both P1 and P1A, you can use P3 or P3A, depending upon whether you are filing a provisional specification or you're filing a complete specification. So you can simply look at the cost of filing, for example, provisional application. So as a strategy, if you are a startup or you think that I don't have the money or the resources right now to hire an expensive attorney, or it's not only the case that you're choosing a provisional specification because your invention is incomplete. You may also think, okay, today I'll file, let's say, P1 along with P3. I'll pay, what is that, 8,000, 9,000, yeah, almost 9,000. I'll pay that, and I will get the filing date. That date cuts off the prior art. You have not filed complete specification, you have not done anything amazing in terms of filing a patent application, but what the most amazing thing you have done is actually secured the filing date, and it will not change. It's not going to happen that somebody else will come later and give the prior filing date. No. So I would advise especially to those who are actually feeling that we don't have the right funds to actually get patent drafted, to start with a provisional specification. Okay. The only, in my opinion, the big drawback is that your application does not get examined unless you file within 12 months a complete specification. The provisional specification is not examined. If you will not file a complete specification within 12 months, your application will be abandoned. Okay, the application will be abandoned. That's the only downside. It's not even going to be examined. Obviously, it's not going to be published. So it does not really destroy your novelty. If you think that you cannot follow up in 12 months and you want to let it be abandoned, and you think that your invention is something that's not going to become obsolete in 12 months, it's okay. You go again, file another application, maybe next time you file a complete specification from the very beginning. So, but yeah, so many of the researchers actually use provisional specification when the invention is not complete. And my suggestion would be, and it's not an advice, my suggestion would be that you can use this if you think that you don't have enough resources at this point to hire an expensive lawyer and draft a very good complete specification. A complete specification should be good. You cannot take chances when it comes to complete specification. And this is pretty much true for all countries, not just Pakistan.
So what's the use of putting on provisional application if it's not going to examine it?
Okay, what's the use of having a provision?
Secure the date.
Secure the date.
That's the biggest.
But sir, if the application is abandoned, the date will also.
Yeah, it's gone. Your application is gone. It's finished. But the good thing is, as it's not being examined, it's not being published, the novelty is not being destroyed. You can go back, file after 18 months, 12 months, 15 months, again the same, not the new idea, again the same thing. Again the same thing, because it's not disclosed, unless you disclose it somewhere else. It's not being disclosed by the fact of filing in the patent office. So these are two forms, P1A. I've only shown P1A because I think most of you will be using P1A. These are some information that you need to put in, and I think in the next slide I have these. So in P1A, the most important thing is that you have this on the reverse side, the endorsement by inventor. So you need to endorse, and here you will have the name of the assignee, the applicant, which you are not an applicant in this case. And this is the title, this is the inventor's name, and then you provide the number of claims and pages, and then you sign it, and then you write it, the applicant signs. And this is form P3, which is simply asking you to provide some specification. In the provisional specification, you don't have to file the claims. In Pakistan, you don't have to even file, you don't have to give anything technical. All you need to keep in mind, and Fatma, please correct me if I'm wrong, I'm not an expert on patents. So all you need to keep in mind is that you should not write something which is too narrow, because in the complete specification, as she also mentioned, you cannot claim something which you did not write in the provisional specification. I said the provisional specification is not examined, but that does not mean that the patent office will not look at the provisional specification when it's examining the complete specification. It will take the complete specification and will match it with the provisional specification. And if complete specification claims something broader than what you have actually mentioned in your provisional specification, it's a problem.
Yes,
we need to be a bit broader. You have a broader view in provisional application.
Yes, it's safe.
Then we can cut it off in final.
It's safe. It does not really hurt you. To do it. It's better to be safe than sorry in that sense.
So claim we should be submit the more precise.
At the time of complete specification, yes. At the time of complete specification, and that's why you don't put the claims in the provisional specification. Because even if you think that your invention is complete, let's say, and you're only stopping because you don't have enough money to hire a lawyer to draft a patent, it's just wise to not include claims in, because the law is also allowing you, and that there's a logic behind that. So the logic is that, okay, fine, for whatever reason you're doing, you may have the time, 12 months to rethink, maybe you reassess the invention from a different perspective, and you say, wow, okay, I can do this too. And then you can actually start claim
At the
that.
time of the submission, is there any conflict of interest form is available?
What do you mean by conflict?
Means, is there any dispute in case of the inventors? There is any dispute between them? It might be possible, can be raised.
It happens. It happens in the law. Actually, I actually resolves by giving the registrar the power to actually hear both parties and then try to resolve it. So this is possible. This happens. Okay. So these are some kind of sections in the patent application itself. Fatima already talked about it. We have talked about it like several times. There's a title, there's an abstract, there's a description which includes there's a background and claims and drawings. Claims are considered to be, in the words of a UK judge, the metes and bounds of a patent. Claims are the heart and soul of the patent. This is what you're asking the society or the government. This is the contract that I talked about, the social contract. This is the contract. You're saying, I am giving you the information, this knowledge, the claims. Oh, society, please give me 20 years of exclusivity. No one should be able to use this invention which I'm telling, because I'm telling you what my invention is. So claims are considered to be really essential, not essential, but the thing about a patent application. This is just a copy of the patent journal that is published every week on the internet. Simply log in to ico.go.pk, go to the patent section, and then there's a drop-down box, select patent journal, and you will see all the journals. I don't know from when they're available, because I think they remove it. At the time of filing, they also publish titles of the applications. I don't know which other country does it. I don't know if the titles of applications are published by other countries. I don't know. I don't know if Iran does it.
Iran actually. Iran.
It's very interesting to actually see that this is happening in Pakistan.
I don't know.
It's very interesting to see that this is happening in Pakistan. And again, that goes back to the question that you made, how much disclosure? I don't think the title is just, title normally does not disclose too much. Sometimes it only says compounds. Only says compounds. That's it. You know, we have no idea what's behind that.
And please don't choose that title like the title of the paper.
Yeah.
Yeah.
So this is like, let's say, first very let's say narrow, I don't even want to use the word publication, introduction of title to the world. These are the applications that we have received, and so there's nothing more. Application number, company, applicant, the country of the applicant, priority, the priority date, and interestingly now they have actually also, oh, this is really good. So they are now also putting the priority application number, which makes it easier for you to go to the publicly available patent databases and see what this application is about. Which again is a very interesting question, whether by putting this and this together, whether there is a publication or not. This is very interesting because if you combine this with this and go and check on the internet, you can find the whole thing. So now this is a bit tricky. They didn't used to do this before, but yeah. And this is the file page. Quickly.
So can I see there is one name as well. So do we actually use the company name or the name? For example, on the third position, we have the.
Yeah. So somehow this was one thing that so usually for Pakistani applicants they are publishing the application with the names of the inventor. So most probably Dr. Muhammad Kamal Tawseef is an inventor, most probably, because this is what their practice is for Pakistan. So I just requested them to also include the name of the applicant, because for the international, for other companies, they are usually using the name of the applicant. So why not for example, I know for a fact that I don't know, I'm pretty sure that you also have patents in Pakistan, but I know for a fact that Professor Fazana Shaheen has a lot of applications and a lot of patents. And when her patent gets published, it's her name that's there, even if the applicant is her institution. So yeah, so it's a good point that you mentioned. Okay, quick. Once this is published, then we go for examination. I'm not going to go into examination. After the examination done, and in Pakistan we have formal examination and substantive examination at the same time. The applicant replies. You are the applicant. You reply. You provide your response. If there is no amendment to your specification, you don't have to use any form. Okay, you simply reply that I agree with you, I don't agree with you, or this is my reasoning, whatever. Usually there is an amendment, okay, and for that amendment you have to use form P17. Most of the forms have similar information in it, and you pay. It's not a huge amount, 750 rupees. Yes.
I just want to add that the amendments part and the negotiation with an examiner and inventor is a very, very common routine in the patent prosecution process. I know that maybe some inventors, when they receive the amendments, they receive the rejection from the examiner and think that, okay, it's not patentable. But in USPTO, in DCT, EPO, in that type of the offices, maybe there are 30 times, 6 years, 8 years, going back, and they finally get it.
It's
really
multiple. It's not just once, it's multiple.
Yeah.
And it makes lawyers.
And without no exaggeration, there's maybe 30 times going back.
Sometimes lawyers also make it like that, so that they come back to the
They charge.
the lawyers can charge again.
Can charge again.
So yeah, this is true. Yeah, that's why patent according to the okay,
So let's just say that when the examiners examine and they put in objection, it's not patentable. So they again work on it and say, no, it's patentable, and they discuss with the examiner again and again, move on.
It can happen multiple times, and thanks Dr. Mitra for pointing that out. So it can happen multiple times.
So sometimes, is it possible that during this period, the examiner at the end agrees with him that, okay, now this is better, no, it's better.
This is what happens at the end. Hopefully. Hopefully that happens at the end. That's yeah. Everyone is happy at the end, and then it gets published. Everyone lived happily ever after. Okay, so if there are no objections or the objections are removed, then there's an acceptance by the patent office. They convey to you that okay, fine, this is the time when we party and we're happy that everything is okay. There's an exception, acceptance, and then once the acceptance is given, then in the whatever the latest journal will be, possibility they will publish that in the journal. Now, the same application, when it gets published in the journal in Pakistan, you don't get to see the claims. Okay, they don't publish claims. They don't publish the whole application. What they do publish is the addition to the information that they have. So, for example, this is already public knowledge because when this application came in, the new application was published, the title. So this is published already there. The filing date, I think, the name of the company. Now they add the new information, which is IPC. Yesterday I showed you these 4 digits, and I said, this represents the type of the field of activity of the field of science. So this is the IPC, the International Patent Classification. So every application has to be classified in a class. And these numbers are given, there can be more than one. This is called the acceptance number. And at the end, I think, if I remember correctly, this is the number also converted into registration. Yeah. And this is the abstract.
International patent classification is related to like the particular field of that person, is it
That
physics, chemistry, or
Yes.
and then that degrees, metallurgy, whatever.
So for example, if the class that starts with A, I don't remember what classes, but the class that starts with A is life sciences, or it's called actually human necessities. So most of our researchers who are sitting here use A because it's pharmaceuticals, it's also agriculture, it's life sciences. C is chemical related. So professor, your class, I think, would be C. C is also good. So A, B, C.
All are equally good.
Yeah. So this is the information that you get that's published in the journal after acceptance. You also get the drawings. Some of the drawings also get published. Okay. Once it is published, the third party, the rest of the world, has the chance to oppose your acceptance, your application. So the time period is 4 months. Okay, so you can oppose in 4 months the application, the publication or the acceptance of the application. So Pakistan in that sense is a pre-opposition. What's the right word? It's pre-grant opposition country. In some countries, their opposition after grant. I think EPU is after grant, right?
No. Yeah.
So there are some countries who provide an opposition period after the grant, but Pakistan says no, because, and there's a logic behind it. The right, a patent right is considered to have a prima facie validity, and a prima facie validity can only be accepted. Prima facie validity means on the face of it, the courts think that there has been a substantive examination procedure and the experts have actually looked into whether it's novel, non-obvious, and industrial applicable. So the court says, we believe that the right is valid, and only if the infringer challenges, then we'll say, okay, fine, let's look into validity. So Pakistan says our system is very thorough, and it is before the grant. So that's why we have a good right when they're going to enforce it.
She has another meeting in the afternoon.
Yeah.
She wants to know that how many minutes it takes, because she wants to know if she can move to the other place or not.
10 minutes.
10 minutes.
Just to stop me up. Whatever I'm doing, just stop me.
No.
Okay. And the notice of opposition is also cheap. It's not that expensive, and it's a good thing that the society should have the chance to oppose a grant before the grant, a patent before the grant, because knowledge is good, and the freedom to use. So this is the form P7. It's not that expensive. You have to specify the grounds of opposition. Why are you opposing?
So these journals on which it is published, are they all online journals?
They are published online.
Okay.
It's on the website.
And watching those journals, people can oppose that, and they can return. It can be rejected at that time as well.
No, then
there are serious opposition.
Then there's a whole process of opposition. So you provide you give the notice of opposition, then the applicant gets a chance to reply, and then there's again something, and then again something, and then there's a long series of hearings, and at the end of that you get a decision by the
Sir, maybe sir, when you say that they're in those journals, their claims are not shown on those journals.
Yeah. So you go to the patent office and you request them for a certified copy of that specific application.
Okay.
So for example, in this case, you go to the patent office, you ask for information on this, and then you pay a fee to get the information.
Okay, so sir, I have a question. When the patent is granted, then what can be the reason of the opposition? Like it has been granted, then why?
It has not been granted. In Pakistan, it's not granted.
In countries where just like it has been granted, just like you have said, EPO, then what can be the reason of the opposition?
A new document that the patent office could not find. The examiner could not find a prior art document. Very common.
In other words, they can say that in other literature of whole, because they are looking at the whole global literature, they can say that this article, there may be thousands of things on that. They can say that look in some other country, this has been done.
Yes.
So
It's pretty much.
because that on that case, we are not looking at that particular country. We are looking the whole.
We always for novelty. That's what she said. We are always looking global. We are always checking the global innovation now. It's technologically it has been global for a long time, but after TRIPS, it's a legal requirement incorporated in the national laws.
So,
That you
what is
look at
the TRIPS full TRIPS?
trade-related aspects of intellectual property rights. So because of that, we have incorporated that in our law. So we need to assess global knowledge. Okay. So yeah, so we have a position system before grant, so that the publication means, I'm just digressing for a little bit. Publication actually means that the patent office thinks that your application, your invention is novel, is inventive, and it has industrial applicability, and it fulfills all the requirement of the law. This is what publication means. If there had been no opposition system, it's as good as grant. Okay, but for the benefit of the society, because the patent office is giving such a huge important right for next 20 years, it says let the public come forward and oppose if they have something to oppose, and if they are successful in opposing, the patent is gone.
So what if someone finds like there's something contradictory after the period that has been mentioned for the opposition? That what
Yes, after grant you have a time period for revocation. You still have the chance to revoke. So you can go to within 1 year, you can go to the controller, and after that, I think it's also concurrent, I'm not sure, but you can go to the court. CIP chapter.
With respect to the licensing, is there any connection?
Yes, so you can, before grant, you can only license the application. You cannot license the grant. And only at grant, your right gets, हम उर्दू में कहते हैं, आपका right पक जाता है. आपका पकड़ने वाला जो पकड़ने का period है, वो grant के बाद. So that's post grant. And also, you can only sue for infringement after the grant. You can sue for whatever period before the grant too. For that, if you want to claim damages against the infringer, you can actually go back all the way to the filing date. But you cannot file a suit for infringement before the date of the grant. Okay, if there is no opposition or the opposition fails, okay, so this is, if there is an opposition within 4 months, there has to be a notice of opposition. This is the fee, this is the form that you need to fill, P7, and the opposition procedure goes on. Notice of opposition from the opponent, then they reply, then this and then we have a long set of hearings. And at the end of that, you get a decision either, and that decision is either if the opponent wins, your application is gone, it's rejected, it's refused. If the opponent fails, if there was no opposition or the opponent fails, you actually you are told that the time is finished, and you should file a request for sealing of the patent on P10. This is the fees, and once you pay this, your patent is sealed and granted, and from that date of grant, you can actually you can license and you can sue. From the 4th year onwards, you have to renew the patent activity. If it's grant, if it's application, you need to renew it from the 3rd year on, third year 3 onwards. for year 4, year 5, year 6 till year 19. So year 19 is the last renewal for year 20. And this is the cost of doing this. And as Dr. Mitra yesterday also mentioned, that the cost keeps going up. In the early years, it's less. In the later years, it's more. Two reasons for that. One is that it is more valuable for you and that's why you're coming back. But it's also for the society to make it costlier for you to renew it so that your patent right gets expired and the society benefits from using it or selling it or producing it. The reason why society is interested, there are two types of competition. One is called dynamic competition, the other is called static competition. Patent systems encourage dynamic competition or competition in innovation. Okay, and competition in innovation, one of the ways of actually encouraging competition and innovation is by giving the inventor or the innovator a time where nobody else can actually exploit that. Which also means that the innovator can keep the price high because there's no competition. Because there's no static competition or price competition. By price competition, we mean that every one of us can actually compete with each other. When there's every one of us competing with each other, the price will go down, keeping other things constant. The price will go down, and that is not good. One theory is that it's not good for innovation. But the society also wants, what does the society want? Society wants innovation, and the society wants innovation at a cheaper price. So that's why the society puts through the government this fee which keeps going up, so that if it does not make any sense to renew it, you will not do it, and society will benefit from that.
Like sir, would patent office notify if the patent has been renewed or not after some, let's say, 3 years onwards?
Yes. They tell you that you should be. They should tell you that you should be filing the renewal.
But would they tell public about it? That it is renewed or not renewed?
It will tell the public whether it has expired or not. It will not tell them about renewal. So they will publish in the journal. They publish on the website actually, not in the journal, that these patents have been expired, which has the same effect.
So when patent is granted,
yes,
maximum it can be go to 20 years.
Yes.
But
calculated from the date of filing.
From the date of filing. Now they have granted you patent, and for after 3 years, if they don't, they have to go for extension of their. But if they don't
after 3 years.
After 3 years.
3 years of then you file the renewal.
Renewal
of the year, and the 5th year, the 6th year. Every year.
Okay, every year they have to file. Okay, and they don't automatically expire after that.
So if you don't file renewal, there's a possibility to actually file a late fee and put the renewal in. If you don't, the patent office just publishes that this patent has expired. So, everybody can do that.
So years from the date of.
No. The renewal is the 3rd year from the date of filing. So you have to keep. It's more of a maintenance fee. The right word for that should be maintenance of the application, and then after the grant of the grant, the word renewal is not the right word.
Sir, you said that it is after 3 years from the patent is filed. Application is filed. How much it may take 3 years to at least grant?
Yeah. So don't confuse yourself with the fact whether it has been examined or not examined. You have filed the application. To even maintain the filing of the application, okay, you just pay the fee. Now I don't know practically if you have to pay the fee before the grant, but for sure you have to pay after the grant, and it happens that they ask you to pay the dues. So it's, let's say it has been granted in 6th year, so you pay from the 3rd year. In the 6th year, actually, what is due on you on the 3rd year. So yeah, they're not very strict.
I mean, sorry, can we keep the Q&A to?
I'm done.
Thank you.
Okay, maybe so this I already mentioned this about revocation, revocation. Yeah, there's a possibility of revocation. Thank you very much.
That's why I have 2 questions, but I would pose that after the.
Yeah.
Because Sanas is
We have Dr. Gomez after Sana's presentation again, because he's going to talk about the trademark system in Pakistan. Thank you, Doctor.
I didn't give you.
Sana, do you have my voice? Dr. Sanas, do you have my voice?
Hi, Mitra. Yeah, can you hear
Hi,
me?
how are you? Thank you for accepting our invitation.
You're
Are you
most
ready?
welcome. Yeah,
Okay.
let me.
Would you please share your PowerPoint?
Yeah, sure.
Thank you.
Give me a second.
Time is yours. Thank you.
Can you see my slides
Yes.
properly? Hello, everyone. Can you hear me?
Yes.
Yes.
Hello, good morning. I don't know what's the timing now in Pakistan. Good morning, everyone. Thank you so much for having me. I'm so happy to join you, unfortunately online, but happy to be with you all. So my name is Sanas Javadi. I'm a lawyer with intellectual property and international trade background. And I'm also a mentor and an advisor to UN agencies and international organizations, as well as European Union Intellectual Property Office. So I have been working with WIPO, with International Trade Center, with Swiss Federal Institute for Intellectual Property, and also European Union Intellectual Property Office. I'm based in Geneva, Switzerland. So today I will address very briefly, because I have limited time and I have to leave you all before 1 hour. Sorry for that. So I will just address some generalities of protecting branding under the concept of intellectual property system. So today I will provide a general analysis of different aspects of branding in intellectual property system, including trademarks, industrial designs, and geographical indications. So of course, I mean, I can go on and go on, because each and every part of trademark, industrial design, and GIs, they have different issues to address, but because of the, you know, like the time limit, I cannot address all details in this session. But of course, if you have any questions, you can ask afterwards. So I don't know, like I unfortunately I was so busy this week that I couldn't follow up all the discussions, but I think you're all aware of the importance of intellectual property system, as well as having the protection of intellectual assets these days, especially in digital environment, especially after the pandemic, that everything got virtual and online. And of course, the branding is the very major and the base of entering to local or international market, either in physical market or in virtual one, in digital world. And here in Switzerland, we are working a lot on the branding strategies of businesses, because it's the very first element that businesses take into consideration when they want to enter the market, before entering the market, and also when they want to expand their market into other countries, to export markets, basically. And what is really important is that, and what I witnessed when we are discussing with the businesses, with the startups, with companies, and also they refer for their RP cases, is that in most cases, no matter where you are, either you're based in Europe or elsewhere, In many circumstances, unfortunately, the businesses consider intellectual property system as a registration system. They think that once they register their IP rights, they're fully guaranteed and they don't need to do any other steps in order to protect their business interests, which is totally wrong. What we are trying to teach to businesses and what I'm trying to do here in Geneva, because we are protecting and helping a lot of women entrepreneurs and women businesses, either in person or remotely. So we are trying to help. We are trying to help them to have IP management rather than mere IP registration, and considering the appropriate IP strategies before entering the market. Because when you have, you know it better than me that some aspects of intellectual property that are not going to be registered under the each and every jurisdiction. So for some, for example, for some of copyright aspects, you cannot register them, or like for trade secret or confidential information protections, you cannot have the possibility of registration under the local laws. So you have to consider some other options, for example, having strong databases in place or having the contractual framework in place. So what we are trying to do is like helping the business to have more than IP registration, and defining appropriate IP strategies as a part of their business plan in place. And IP strategy should be defined based on the market that you're entering. For example, if you want to have business with UAE, the strategy that you define based on the local laws and economic situation of the country is totally different from the strategies that you can obtain in Switzerland, or even the strategy that you can adopt in Switzerland is totally different from EU countries. So for each and every country, you have, before entering the market, you should do some sort of analysis and adopt certain strategies based on your marketing plan, based on your business plan. Then afterwards, you can start protecting your IP rights. So this is also applicable to the branding part. The brand, as I mentioned, is the very first step that you take, even before starting to protect your technology or software. You need the brand as the identity and differentiation means in order to identify who you are in the market, so that you can differentiate yourself among other competitors or other companies in the market. Especially this is quite important in international market, not only in local market, because in international market the competition is so intense, and you have to have a high competitive advantage in order to be able to compete with others, especially as a developing country. So, and as I mentioned, we always emphasize this in WIPO. I really like this phrase, no one size fits all policies in place. Businesses think that, okay, once, for example, I register my trademark in the international phase, I'm fully guaranteed, I'm safe. No, it's not true. As I mentioned, based on each and every country that you're entering, even based on each and every sector that you're going to enter to, you have to adopt different policies, and you have to have a prior analysis before entering that respective market. So as I mentioned, under the intellectual property system, we have few items as being defined as a branding component of intellectual property system, which is trademarks, geographical indications, industrial designs, and domain names, which is related to your website, the protection of your website. So your website name can be also considered as the brand of your company, and you can have the legal means to protect that. So as I mentioned, brands are the real mean for creating the value for your business. And once you have protected your brand, you should be careful, and you should have your IP portfolio in place. You should have your IP management strategies in place in order to monitor your rights in the market, in order to somehow follow up what is happening in the market. Is any other companies are copying or infringing your rights, or if they are actually taking actions against you. Sorry for the background noise. So because I'm at home, so you have to have this maintenance and monitoring in place, and you have to also adopt the strategies in order to have the possibility of enforcement. For example, for the contracts that you are negotiating with your partners, either again local or in export markets, you should have appropriate clauses in your contracts in case of, for example, any sort of copying or infringement of your brand. Who would take the action? Who would be responsible? Who would incur the cost? So these are all the things that goes again under the scheme of the brand management. So as I mentioned, again, the mere registration is not enough, and your major responsibility even starts after registration, because you have to be careful all the time what you have to do, what a strategy you have to adopt. And you know, it's likely that especially the multinational companies are always monitoring this, and they have a very strong IP team. The very famous case of Apple and Samsung, you know, because, you know, like they are always following up what is happening in the market and what products their competitors are producing. So of course, when there is a similar product in the market, the other companies can have the possibility to sue the competing company for infringing of their rights. So what is the brand? Because normally, at least in many cases that I've witnessed, people mix trademark concept with branding. But branding is more than trademark itself. In many cases, people use brand instead of trademark. But brand is a more general term as the interface and the central nexus of communication between your business and the clients, the customers that you have in the market. So again, this brand can be different based on each sector. The business sector that you are active in, for example, if you're active in food sector, your branding strategy could be different. I mean, if you're active in oil and gas sector, if you're active in agriculture sector, so this branding nexus can be different. And it can cover all these IP components that I mentioned in the previous slide: trademarks, geographical indications, industrial design, and of course, the name of your website, and also the reputation and business strategies that you adopt within the years in the market. So now everyone, for example, the franchising brand like fast foods, McDonald's, Starbucks, or Burger King, or so many other famous brands, or in ICT sector, IT sector, Apple products, these are all like the companies that they have built their brand within the years. It has not happened within one single night and through one mere registration of the trademark. No, they have built and they have adopted the strategies to build their brand. And this branding scheme is normally a part of their business strategy. So it's inseparable. But in certain countries, you see that no, they don't care enough. They just have a business plan in place without considering the intellectual property aspects and under that branding aspects. So as I mentioned, so the meaning of branding is much more general than what you adopt as the trademark. And how you can have a successful brand, because I mentioned that your brand is an interface with your customers, with your potential market that you're going to enter to. So you should have a very clear, specific, and somehow a specified brand in place so that you can have differentiation power. And also you can have the possibility of the showing of the quality that you're representing. For example, again, for the case of Apple, you see that a very simple, you know, like Byton Apple can be considered as a trademark of a company, which is really simple to remember. It can really transmit a clear message to the customers, and you can always remember it, and you can always differentiate the products of Apple, like the mobile phones, laptop, whatsoever, compared to other companies. But if Apple company was using this trademark for some other products, maybe this trademark wouldn't have had the powerful differentiating power. So you should really choose a very specific and clear brand in place. And of course, this is not a mere legal issue. You should have a strong marketing team in place in order to help you to have a strong, in the very first place, logo, not even the brand. And what is really important is that nowadays, because of all these copycats and copying that happens in the digital environment, and you can have Google images everywhere, the companies should be really more even careful so that they can, because before registering your trademark, you should have the market analysis and the search to check if your trademark has a previous equivalent in the market. And sometimes the companies forget about this step and they go ahead with the registration phase and they incur a lot of registration costs. And in the end, and this has happened to my clients, that they forgot about the search part. And then they came to me and they said that, okay, they received the provisional or final refusal by one of the IP offices around the world. So this is where you have to be careful since the beginning, identifying a logo, a message, a symbol that is really clear and has differentiating power. And again, I emphasize, based on the sector and the customer category that you are targeting. For example, you're a cosmetics producing company. So your target age would be maybe teenagers in certain countries or old people in certain countries like Switzerland, or depending on the sector that you are targeting. Or for example, you are producing bio or healthy products and food. So your target maybe would be athletes or like the people who do a lot of sports. So based on the clients, the customer that you're targeting, you should adopt your brand based on that, so that in the eyes of your customers, your brand is enough attractive and appropriate with the mean that you're following up in the market and goods and services that you are promoting. And after that, for the this is the very final stage, of course, when you have done all your legal protection and everything is done, when you want to start the advertisement and marketing for your goods and services, this brand in general should be able to transmit a very clear message, and it's properly communicated to your clients. So if you have put a lot of efforts to have a strong brand in place, but you have not put enough efforts to communicate it properly and use appropriate advertising means, so you cannot be successful in the market. So a successful branding strategy is based on customer needs and desire, and knowing your consumer or customer desire before entering the market is like a component of your brand success. So I have to be a little bit more quick because of the time, because I have to leave in 25 minutes. I apologize for that. But I hope there would be some other circumstances that we can highlight, and we discuss more about the branding for your businesses. And so what is trademark? A trademark is a sign distinguishing goods and services produced or sold by a company, by an enterprise, from the other companies in the market. And it could be words, letters, numerals, pictures, shapes, colors, labels, or a combination of these all. And we have also different type of trademarks, of course. We have I always call it individual mark, which is relating to the mark that you are adopting for your own business. If you're an entrepreneur, if you are like a startup, or if you're a company, no matter what the size of your company is, you have your individual mark to distinguish your goods and services, which is like your name in real words, so that you can show yourself with that name to other businesses in the market. So the ownership of this mark belongs to you, to your company, and no other companies are authorized to use your mark without having your prior written, in most cases, consent. So this is the very first component of trademark that you use when you want to enter the market. In many countries, even before entering your business, you should have your trademark in place. So this is one thing. And trademark is mostly used for the differentiating and distinguishing the goods in the market. Then you have service marks. You have service marks, I mean, as it says, for promoting of your services in the market, like Amazon, or collective marks. In certain cases, companies are willing to have collective marks in place, which is distinguishing the goods and services that are offered by members of an association or a trade union. So in many countries, including Switzerland, because I work a lot on collective marks and geographical indications, I really like it because, you know, the producers, especially, I will describe it in the next few slides, when you're based in certain region, they're really willing to use collective marks in order to have more bargaining power in an international market. They're really using collective marks in order to have, how do you call it, better market position compared to the individual trademark. Of course, you can have always the possibility of mixing all these together. As I mentioned, these are all the components of your branding. So you can have your company trademark in place. Beside that, for I don't know if you've ever seen like the back of the products that you're buying in the supermarket. Sometimes you can see the logo of the company that is the producer of the certain product. Then you have the label of the I don't know, like the trade association or the union that are the member of certain producers that are active in certain field. They are the member of certain union, and also certification marks, which is somehow like a standard mark that shows that your product has certain quality and you're authorized to enter that product into the market. So this mark identifies that your product is safe. So behind your product, you can have trademark in place. You can have the collective mark, collective logo, the symbol of the trade union you are the member of, and also certification mark. So this trademark that you are protecting gives you exclusive ownership rights to prevent other businesses from marketing their products or services under the mark that you have already registered. So the major thing to do is registration. Of course, in certain countries, common law countries like US, even before a startup registering your trademark, you should have started to put your product or services into the market. You should have your logo in use in that certain market and show that you have been active in the market for a few years, and then you start with trademark registration. But in many other countries, and I think it's the same in Pakistan, you should have registration in the very first place to show that you are the main owner in order to be able to prevent infringement or copying of your trademark. And in most countries, as far as I've analyzed before, I don't know exactly about Pakistan, but the trademark is valid for 10 years. And before the expiry of 10 years, you can have the possibility of renewal. So certain months before your trademark is expired, you can submit another application to respective trademark office and request for your extension of trademark. But again, in some cases, and this is a recent case, that a company based in Dubai, they contacted me, and they had this problem that they had forgotten to extend their trademark validity somehow, and another company, it was basically a restaurant. The restaurant had started to open the same branch in another part of Dubai, and and they had also lost the deadline for having the possibility of extension. So we had to contact the IP office, the trademark division in UAE, to ask what we can do, if we can have additional time to extend the trademark. Otherwise, you have to start from the beginning. This is why I mentioned that the maintenance is really important. And this trademark protection, of course, gives you a lot of exposure to secure the investment that you have done for years and the resources that you have used for your entering into the market. And of course, it's always a symbol and a credit in the eyes of your customers, and it can attract customer loyalty and brings you reputation in the market. And what I really like in trademark world is that, again, businesses think that they can use trademark for differentiating of their products and services in the market. And they can have direct advantage of their marks in the market. But you can have indirect advantages using your trademark through licensing or franchising your rights to other companies, like all these chain stores or chain supermarkets or chain fast food, coffee shops, clothes brand, all these brands that you see in the market, and they're somehow universal. So with one single license or franchise agreement in place, you can authorize other parties to use your mark under your permission in certain market. For example, you have a Pakistani trademark, and you are willing to have a branch or have business in Turkey, in UAE, in Switzerland, in Italy. And through licensing or franchising scheme, you can have the possibility of somehow not even assigning, because assigning is the full transfer of ownership. You can have the possibility of giving the permission to other companies to use your mark under your name, under the provisions that you set, without the need that you would be present in that market all the time. So this is somehow indirect revenue for your business in order to attract more partners and clients into your business in other international or export markets. So not only trademark can give you identity for your business, it can bring you so many additional advantages. And of course, you should also be so careful that, as I mentioned, you should follow certain steps before registering your trademark. You should, first of all, this is a somehow marketing strategy that you should adopt. You should use a mark which is not general, because as I mentioned, you are going to differentiate and identify your business in the market. So for this, you should have a mark in place. Again, the example of logo of Apple. If Apple company is using the logo for producing the food product or fruits, this is a general term, using the logo or the name of Apple for producing fruits. But when you use this mark for a different category, of goods and services, you can have the differentiating power. So again, this differentiating power, the more, specified and distinguished your mark is, the more you can have the possibility of having it registered, and you can have this possibility of having it more memorable in the eyes of your customers in the market. And also, your mark shouldn't be descriptive, because again, in many jurisdictions, having descriptive marks is not either registrable, you cannot have the possibility of registering it, or it cannot give you enough exposure and visibility in the market. For example, if you use the phrase of books and magazine store, which is really hard to protect because there could be thousands and thousands of bookstores all around the world. So you should really use a mark which is more somehow specified and more distinguished rather than descriptive and describing what you are selling. And of course, another issue that I will address in the next few slides is that you should be also careful on how to present your product in the market, your trade dress, not only your trademark, not only the logo that you are using or the name that you are using for your business, the appearance and visual aspect or trade dress of your product is also so important, like packaging of your product is really important. So again, based on the search that you do, and in most cases, IP offices, trademark offices all around the world, they have their search databases, they have their trademark database or brand database. And in other cases, there are some other databases in regional or international level. You can have the access to European Union Intellectual Property Office database. You can have the access to WIPO, World Intellectual Property Brand Database, to check what are the equivalent or similar marks for the same class of goods and services available and already registered or under registration process, I mean, in your desired market that you are willing to. So the search, as I mentioned, after that, you have your somehow your logo or your mark designed. You, before sending the application, registration application to the trademark office, you should do the search. And of course, the search is not 100% sure. It doesn't give you 100% certainty that you are safe and you think that, okay, I didn't find any equivalent or similar mark in the database of WIPO, so I'm safe and I can register my mark in China. No, I received recently a notification from China that we couldn't find any equivalent of the, sorry for the dog, yeah. So we couldn't find any equivalent in China trademark office database. There was nothing there. But when we started to go, because we registered the mark through Madrid system of WIPO, when it went to international to national phase in China, China sent us, a notice of a refusal, that the trademark registration is refused because there are 1, 2, 3 similar trademark already registered in China, while we couldn't find any in the database. So sometimes, I don't know why, but the databases are not really giving enough information. And of course, the least developed countries, they don't have, how do you call it, very complete database in place. For example, during the pandemic, this is one of these, like my child of pandemic time, that I did an assessment for European Union Intellectual Property Office, but the office in Southeast Asia, an assessment of the role of women businesses and women in local communities in intellectual property system. And I had to do a comparative analysis between using the trademark geographical indications and a comparative analysis with using the patent and technology in ASEAN region among women businesses. But unfortunately, the databases that, okay, if you refer to Singapore, you can find a rather a complete database in place. But if you want to find, or if you want to access the databases, trademark databases or design database in Cambodia, in Laos or Vietnam, they're not so complete. So it cannot give you enough information how many trademark has been already registered, who has registered it, when has registered it, and all these things. So in certain countries, the databases are not really complete, so you have to be careful. And oftentimes the businesses ask me, okay, we did the search, now this is a search report, are we safe? No, you are not, but this is a precaution that you take in order to minimize your risk before entering the market. And of course, you can also use the proper notice marking, like, you know, for in certain countries, especially in US, they use it a lot, like TM for trademark, SM for service mark, or R or C. R means registered, C is like referring to the copyright. So with this sign, you show that you have some sort of legal protection in place. And again, I don't take your time for the managing your IP assets, which is really important, and it goes beyond the mere registration. So I have to be really fast because we don't have much time left, I think. Yeah, less than 10 minutes. So the protection routes. First, you have your national IP office. If you want to have your protection in Pakistan, for example, your main business headquarters, your main business activities is based in Pakistan. So as the national route, you can use Pakistan. But for example, if you have your major part of your business being rendered, I don't know, in Dubai, you have to go through UAE. So it really depends in which country you're most active, so that you can start your national protection procedure from that place. And then when you have this national protection, or in certain countries, once you have the application number in your hand, even before having the protection granted to your trademark, you can start either the regional phase of protection through regional IP offices like European Union Intellectual Property Office based in Alicante, Spain, or international route through WIPO, through World Intellectual Property Organization. But again, this goes back to your business strategy, to your marketing strategy, if you are willing or if you can expand your market. Because again, some businesses are doing this for prestige. They think that, okay, if I have my trademark registered in Switzerland or in US, this is a very prestigious thing for me. And I can say that, okay, I have registered my marks in these countries. No, I mean, why you should do that when you don't use your mark in those markets? So you really have to go to either regional, for example, if you have business in Europe, if you don't have business in EU, why you should register your trademark there? Only if, according to your market monitor on the search that you do, you come to the conclusion that, okay, I might have the possibility of copycat infringing of my rights in certain market. For example, for the case of saffron, I work a lot with saffron producers in Iran. And unfortunately, their rights is under constant infringement by other countries. I don't mention the names. So one of the concerns that they have is that it's not just entering those markets to have business. They want to register their marks, the case of China, to avoid and prevent the copying of their marks, which is happening constantly. So plus the fact that you want to guarantee your business and you want to enter a certain country to have more business in international level, registering of your trademark can somehow minimize your how do you call it, litigation costs at a later stage if you are exposed by potential infringement. So these are the two things that you should be careful about. And as I mentioned, in certain businesses, they incur the cost that is not really necessary or feasible. Maybe sometimes you can only do the national protection. At a later stage, you want to expand your market, you decide, okay, now I want to expand to other countries. But which countries again? One time, one of my clients, he came to me and he had listed more than 30 countries. Okay, I want to register in all these countries. And I asked why. So this is again this should be based on your marketing plans. You cannot just go, you know, like to whatever countries you think that, okay, it's nice or nice to have, because you have to incur additional costs. And so for regional routes, you can have African Regional Industrial Property Office, you can have European Intellectual Property Office, and also Benelux, Belgium, Belgique, Netherlands, and Luxembourg. Sometimes they provide additional protection in the case of enforcement. So you have to also double check this if you, rather than using EU IPO, if you want to go through Benelux IP office as well or not. And be careful. Sometimes businesses mix this. Now UK is out of EU. So if you want to protect your mark in UK, I mean, we have Brexit in place now. You have to go directly to UK Intellectual Property Office or do it through WIPO route, through Madrid system. And Switzerland, of course, Switzerland is not a part of EU, so you cannot go to EU IPO to register your mark in Switzerland. So for Switzerland, you have to go to Swiss Federal Office for Intellectual Property. And the most efficient way of protecting your marks is Madrid system. It's an international system in WIPO, World Intellectual Property Organization. With one single application, you can have the possibility of registering in so many, I mean, more than 100 something contract parties, so the countries that you're willing to. And this can minimize your costs, registration costs, as well as your time, because you submit your application directly to WIPO. And I think Pakistan joined Madrid system last year, if I'm not mistaken. So through your national IP office, normally you can go directly to WIPO and you can, you know, like somehow appoint and designate the countries that you're willing to register your mark, and based on the number of the classes of goods and services that you are willing to register and the number of the countries, and also the base of your national IP office, the charges would apply. And normally the procedure based on each and every country takes from 1 year to 1.5 years, or sometimes 2 years. And we have a recent case of India, which takes 3 years to register a mark. So it really depends on each and every country, because people sometimes think that, okay, we went through WIPO route, we went through Madrid system, and now WIPO is the major decision maker for my international application. No, this is not true. WIPO is just an administrative interface. WIPO only receives your application, but WIPO is not deciding about the component of your application if your trademark has the possibility of registration, for example, in US or in Canada or EU. So WIPO would transfer your application to the designated countries that you have already ticked and chosen on WIPO forms, application forms, MM2 for the countries that you choose, and MM18 for US, because again, for US, you should have, you should use another separate form, which are all available electronically on WIPO website. So I mentioned to this the importance of prior search and assessment before entering the market. But another thing that is really important, again, I emphasize today, I cannot address all means because we are running out of time, and I have around 40, 50 slides. I couldn't even address all. So before entering the market, you should again assess if your trademark is suitable in that market. For example, you wanna enter a European country and your mark might have a certain mean, or the other way around, a European company wanna enter an Islamic market, and certain names, certain logos might be offensive under Islamic rules. So before, or maybe some words have a special meaning which is not good under the certain local languages, and you should be really careful. This is again going back to your assessment, the prior assessment that you do, that the meaning of your mark, your logo, the words, the symbol that you're using is according to your market that you are entering. So rather than assessing the prior to check if there is any prior registration in place, and also if your mark is according to the local rules, you should also check the meaning behind that according to the moralities of the country that you are entering to. So I will briefly mention to industrial design. I cannot unfortunately cover all aspects of trademark. I cannot go into GIs because I had very interesting stories to tell you about GIs. But yeah, so anyways, so I mentioned that beside industrial designs, you can have also, beside trademarks, you can have also industrial designs to distinguish the visual aspects of your products into the market. So trademark distinguishes the goods and services that your company offers in the certain market. Industrial design distinguishes the visual aspect of your product. So the packaging, the appearance of your product. And again, in certain countries, including Switzerland, you have a strict packaging rules to enter the market. So you have to obey and you have to align with these packaging requirements before entering the market, because sometimes packaging has, somehow health consideration, like for example, for the food product, for agriculture product, you want to export your product from Pakistan to Switzerland. And on the way, there might be a lot of things happening that when your product reaches a Swiss market, it is expired or spoiled and you cannot use it anymore, or even maybe it's dangerous for health. So the packaging again help you to have more possibility of export to certain countries, because here in the customs they check how is the packaging of your product, especially for the food product, or if your packaging is according to the local laws, because the packaging of your product shouldn't be misleading in Swiss market. So again, packaging is another component of branding of your company. It protects the visual aspects of your product in the market. And you can see all these famous designs of the companies like the Nike products, because the industrial design can protect the visual aspect of each and every product, even from food sector to a garment, to clothing, to the decoration, to the cars, visual aspect of your technology, the visual aspects of your mobile, your laptop, the car you are driving, everything, even the mug, the cup that you're drinking your tea with, they're all protectable under industrial design laws. And the difference between trademark and industrial design, I mentioned that industrial design is visual aspect of the product. And the difference between industrial design, because you use the word industrial, sometimes people mix it with patents. Industrial design is different from patents because industrial design doesn't have any technical features. So again, in industrial design, after having your trademark in place, is another component to consider when you want to enter the market. And in order to protect the industrial design, your design should be new. There shouldn't be like trademark. There shouldn't be any other design like that in place before. It should be original. It shouldn't be the copy of some other company's designs. And if you intend to not to protect your design, not to register your design either in Pakistan or international phase, you can still protect it under copyright law. But you know it better than me that sometimes proving the ownership or having the evidence for non-registered IP rights is really difficult. So normally it's recommended to register your design if you can. And another important thing that I forgot to mention, both for trademark and for design, be careful. Don't disclose it before the registration. Because again, this is also applicable for patents. So before registration, I had another client, a young lady who did this mistake. Before registering her trademark, she put her logo, her design actually, on Instagram. So this is how you disclose your mark into your audience, and somehow this can affect the novelty of your mark before. So because, you know, with one single search, it could be evident that your mark is already in the market, or some other companies can copy it, or they do another mistake. In some businesses rush into investment. They really want to have investors for their technology, for their business. And during the negotiation process, they disclose the IP rights that are not protected already, including trademarks and design. So this would also affect the possibility of registering your mark in your targeted market. And sorry, this is for Iran, but I should have turned it for Pakistan. I think Pakistan is not also the member of Hague Agreement. So Pakistan is member of Madrid, but not Hague, because Hague is in the international registration system for designs. And you can have also, again, the possibility of going through WIPO route and having your design registered in international phase. And the protection means is like trademark. So you can have the national phase, regional phase, and international phase. And if Pakistan is not the member of Hague system, for the protection of your design in your targeted export market, you should go individually to each and every market. So for trademark, the same. For design, the same. If you are not the member of international system, you have to incur the cost, and you have to go to individually to each and every country national procedure. And of course, you can always go directly to EU IPO for regional registration, or choose EU IPO within WIPO system. So I think I'm running out of time. I'm almost finished because I cannot continue more. There's so many questions, I think, or no. So tell me, please, always, or I don't know who is there. Please tell me, because, you know, I can still continue, but I don't have time. I have to rush. So what should I do? Can you hear me?
Yes. Yes. Thank you. Thank you for nice and productive presentation and your constructive contribution to the program. If you have any time, you can just answer to some of the question.
Yeah, sure.
Is there any question from the room?
But Mitra, if you have, I don't know, like if you have time later on today, I can join later.
Yes. We have. Okay. I know that you have another meeting right now, because we just some slight changes in the time of the presentation. Thank you. Very nice and very productive presentation. And like always, okay, thank you. No question from the room, and we can have you after your next meeting, okay?
Yeah, sure, but let me
just Dr. Wace wants to add something.
So I'm going after.
No, you are going to right now.
No, okay. So okay, then yeah, we'll have you later then.
Yeah.
Sure. I mean, what time? You know, because always I have to change locations. You know,
whenever you can come back. So whenever you can come back, just come back.
Just send me a message, okay?
Yeah, I will send you a message, and this is my email. Yeah, these are both my email addresses. I think always has everything. Mitra has everything. So I mean, in case, okay, for future, if ever you have any questions, I'm always available. So I will be back, okay, in maybe less than 1 hour and so.
Perfect.
Because, you know, I cannot finish it like that. I really want to continue to complete at least the generalities. I cannot go to much details this time, but I would be more than happy to provide more details at a later stage.
I hope that we have you here in Pakistan next time, not online.
I hope so. It would be my great privilege. So I will connect soon and try to finish at least, because I will deep dive to beautiful part of geographical indications. So see you soon, guys. Thank you so much.
Thank you. Bye.
Bye-bye.
Good. Let's not waste too much time because I have to finish before 1:30. So now I'm quickly going to talk about, again, my task has been made easier by Dr. Farazadi. I'm going to talk quickly about the trademark filing procedure. I'll keep it simple, like I tried to keep the patent procedure simple. Again, I'll be focusing more on the procedure, and by procedure I mean I'll be focusing more on the forms. Okay, that this is how you actually file a trademark application. Sanaz already talked about the reason why trademarks exist. The core thing to understand is they act as identifiers. Think of your names. They act as identifiers for everyone else. You are identified, differentiated, distinguished from the rest of the world by a name. Think of your NIC. Think of any unique identifier that's attached with you as a person. The same thing is done by trademark for products and services. The idea is simple: distinguish a product from another product. It could be exactly the same. Think of Coke and Pepsi. They are not exactly the same, but they seem like same. So you know Coke, you know Pepsi, and you ask for Coke or you ask for Pepsi. So that's what that's what trademark in general does. Again, it's an exclusive right to exclude everybody else from using that identifier. In Pakistan, you can, Dr. Mitra yesterday also mentioned, registration is advisable, highly advisable rather. It's not necessary. Your trademark rights are established primarily by use. So even if you use it before and you don't register it, you can still go to the court and get your trademark right based on use enforced. It's good to have registration. Obviously, we call it again prima facie evidence of validity. You can renew your trademark in Pakistan for indefinite time, but for 10-year period. So every 10 years you renew. Unlike patent where you have to pay the renewal fee every year, you pay the renewal fee for trademark every 10 years. And Pakistan is a member of the Madrid party to the Madrid protocol now, which means that you can also file in different countries using one single application, the Pakistani application. I'm not going to talk about Madrid today. I'll be focusing on the trademark filing procedure and the forms. Forms are important. You obviously start with a search, then application, then there's an examination, then a publication procedure, opposition, registration, renewal. Okay, so for filing a trademark, you actually use before filing, you go for the pre-filing search. There's a database at the trademark registry which you can search by filling form number TM55. These are all official fees. You pay 1,000 rupees. You make that application, and every application, you have to remember one thing: trademarks are registered in classes. So I didn't mention this. A single trademark is registered or applied in one single class in Pakistan. Pakistan is a single class, single country, single class, single trademark application country. So you have to specify here the class and the goods, and then you have to attach with it the logo, which you want the trademark registry to search, and you submit it, and within a few days, in a week time, or sometimes less than that, you get a report from the trademark registry giving you all the trademarks that match with your trademark that you have provided in that class, and it also gives you the status, whether it's registered or pending. This gives you a good idea whether you should go ahead and file the application or you should change the trademark. That's why we call it also clearance search. That's not the only thing one should do. You should also search what kind of trademarks are available in your field in the market. And with the internet, it's also very easy. Now you can actually go on the internet and search whether somebody else has a similar trademark existing, which is being used for the same goods or services. Okay, so two types. One, official search, which is done by the trademark registry, either on the form. You can also personally go. It should not be 15 minutes. Actually, it's 1 hour, I think. You can go to the trademark registry, sit there, search the database. They give you a terminal, and you can search the database by yourself. You will not get an official report, but you will get the information that you need. And then you also make that market and internet search. If you want to search in different countries, there's a possibility. It's called there's a website called TeamView. So there are databases of different countries in TeamView. You can go select the countries, select the class, give your trademark, whatever the trademark is, and search, and it will give you results from different countries. I think including Malaysia, but Pakistan as well. Okay, the trademark application you can make normally file TM1. The fees is 3,000 rupees. If you're a Pakistani, if you're not a Pakistani, if you're filing from outside, you use TM2, which is 3,000 rupees. This is interesting. Normally people don't know about these applications as well. So this is the normal application. In the normal course of your business, you use TM1 if you're a Pakistani. Collective mark application. Collective mark means that you have made a association or a group, and you identify your product from that a trademark which is collectively owned. So it's not single. This is here it's a single undertaking. Here it's a collection of undertakings. In the case of collective marks, you yourself use that mark on your product, and you can use that mark along with your single trademark as well. So for example, think of Basmati. Okay, so Basmati can be considered a collective trademark. Okay, so you are identifying your product, you're telling the world that in my packaging, in this packaging, there is Basmati. Only selected entities can use that mark. And on top of that, you can also identify this is Falak Basmati, or this is Guard Basmati, or this is the other names. So collective marks and individual trademarks can work together. Okay. Then you have certification mark, and this is also interesting. You know of different regulators, for example, in Pakistan, regulating food, for example. The Pakistan Standard Association, PSPCA, these all are collective, these all are certification marks. They certify you against a set standard, and they put their name on it, that this product has been certified and has been found matching with certain criteria. ISO 9000. When you wear woolen clothes, you have this woolen mark on that. All of these are certification marks. So you can file certification marks on these forms. So just the forms. So you'll be probably using mostly this TM1. What goes in those forms? You put the trademark, obviously, you identify the class, and within the class, you identify the goods or services, goods or services. In the trademark rules of 2004, we have a schedule where you have all these classes, and in front of them, there are goods or services specified. If you want to go into detail, you can go on the website, WIPO website, and type niche classification. And it gives you a very detailed list of goods in all classes, okay, in each class. You put the applicant's name, trade name, the trade name is the business name, the nationality of the applicant, and you also put in type of business. So if you're a sole proprietor, you would write there. If you're a partnership, you would put partnership plus all the names of all the partners. If you're a company that you put, then you put the name of the company itself. business address, you have to specify if you are using that trademark, since when you are using that trademark. So if you're using it, let's say from 2019, as I said, you can start using a trademark before you file. You can, okay? So if you started using the trademark in 2019 and you're filing today, you will write being used since 2019. If you're not using it, then you will write or tick proposed to be used. It's in the form. Then you provide the address of service. You put the date, you put the signature, and your designation on the form. Clear? Anything difficult? They're pretty okay. They're not that difficult. 3 and 4, collective trademark, certificate trademark forms. Once you have filed the application, the first thing that the first document obviously that you get from the trademark registry is the receipt of your filing fee. After that, what the trademark registry does, right now, they're adding your information manually. So they print a acknowledgement receipt, which is acknowledging you that you have filed the application. On that, there's an acknowledgement, there's a number, trademark number, your filing date, and all the information that you have provided in TM1 form that you use for filing. Okay, you have 21 days to go through it. If there's any discrepancy between your form and the acknowledgement receipt, you tell them there's a discrepancy. After that, you cannot change anything. It has to match TM1. Okay. If you think there's a discrepancy, you tell them within 21 days. If you don't, then you will have to file a different form and pay a different fee to make changes in the database. Acknowledgement receipts, then there's an examination procedure where the examiners examine both for the formal requirements, if you have put your signature in there, if you have put the right class, the right codes, all the information that goes into the form is okay. That's a formal examination, and then the substantive examination where they actually assess the trademark, whether it is registrable or not. That's the period. At the end of that examination, they may accept your trademark as it is, and then it may proceed for publication. If not, they will send you a show cause notice, and then you have to reply to that. Okay, it's same as examination report of patents, but the name is different. The only thing, the similarity is that there are objections that you should satisfy or amend your trademark. If you are amending your trademark or any information, you will have to file TM16, which is rupees 600, and you can actually ask. This is basically a request to amend your application. So far, so good. If you are filing through a patent attorney, you will also have to file something that we call TM48. You don't have to worry too much about it, because if you're filing through a patent attorney, he or she knows that TM48 needs to be filed. Okay, once the examination report, you have filed your reply to the show cause notice, and everything is good, hunky-dory, and everyone is happy, then trademark registry will send you a notice of acceptance. And as soon as possible, they will publish your trademark with all the information in the journal. Again, the journal is available on the website. You go to ipo.gov.pk, go to the trademark section, drop down, click on trademark journal, and you will get the latest journal as well as some journals from the past. This is how an advertisement looks like. This is a trademark. I just took one page, this is the application number, the class, the goods, who is the applicant, he is sole proprietor, the applicant name and the company name, sole proprietor, address, and when it was filed. Here, yeah. The agent name also comes here. Any questions?
Well, what I understood is that let's say I have a unknown company and I have a so-called logo for my company, and I didn't go for the trademark. And you said that after, let's say, 1 or 2 years, if someone takes the logo and uses it or even trademarks it, and I can still sue them because I haven't used it. So what's the purpose of the trademark? Like, I can just use it for years, and whenever I realize that somebody is using it, I can just sue.
Oh, good.
So what's the benefit?
Yeah, the benefit is that a legal answer would be when you go to the court, you don't have to prove your ownership. So you have already proven it, and you get it at the end of the whole process. You get a certificate telling the world that you are the owner. So when you go to the court, you don't have to prove again that, see, I've been using it for such a long time, it's exclusive to me, and this is my property. You don't have to do that. If you don't file, you have to actually go and first convince the court that this is my property and this person is actually infringing my property. So you have to go through the whole thing. So that's the short answer. You had a question.
Yeah, my question quite similar to his question. Let's say I create a new brand, but my product is not yet ready to enter the market. So
you have created a branding and your product has not entered the market.
So you said that I can register, and in the form that I can write propose to be used.
Yes.
Right?
Yes.
But what happens if at the same time there's another person who entered the market first using exactly the same branding? So who has the right to use it?
The other person,
even though I registered to be proposed.
If you have already registered and you are not using, that's what you're saying. You're not using, but you got registered, and there's somebody else who has been using it since earlier.
I mean, yeah, he used it earlier.
Yeah, so earlier right prevails.
Even though
earlier use prevails, right? The
even
use
though I
based-
registered first.
Even though you registered, and this happens so.
Sir, say a person who was not registered but using that particular trademark, how would we prove that I am using it? He has registered that.
Through evidence, so you give evidence of use. How have you been using it? Was there any advertising material, some packaging that you might have ordered? You might have got into, you obviously for sure got into contract with a distributor. You must be advertising it. So all this evidence, you must be buying some material from somebody else. You must be asking someone to print the packaging, for example. So you have to show that you have been using this trademark for a certain period of time. At many times you can actually file an affidavit. All this evidence does not need to go, but you can file the evidence, and later when it becomes really contentious, litigious, only then you provide the evidence. But yeah, there's so many ways of showing it. Can I take this question? I mean, I am running out of time, so I'll take one question. I'm sorry.
It means that any company, no matter how big it is, it has to register its logo.
Not has to, but should. Because the right can be established by you.
For patent, copyright and trademark, the procedures is the same and the registration authority is the same, or there is some difference?
So yes, so there's this umbrella organization called Intellectual Property Organization. Under that organization, there is statutory offices. Patent Office for patents, trademark registration, trademark registry for trademarks, copyright registry for copyrights, and design registry for design.
So there might be
Physically, they are in one place, you can go and find.
procedure can be slightly different.
Yes, and the forms are totally different. Okay, so there is a notice of acceptance, general publication, and according to the law, this is considered to be sufficient notice of acceptance to the public. Trademark Journal is registered as a newspaper, and newspaper means this information, if it's published in this journal, has been communicated to the public. So there is no argument that we did not know. Okay, so that's what a lot of people actually hired attorneys for, keep looking at every month at these journals. So that if it's not only about, so if somebody else copies your logo and files, you have to keep looking at this journal, because you can oppose this application, somebody else who is copying your logo. Similarly, if your application is published, somebody else can oppose your application. So there's this opposition stage right after the publication. Now, just recall, in patents in Pakistan, we have 4 months period for opposition. Anyone can oppose within 4 months after publication of a patent application. In trademarks, It is 4 months, but it has broken down into 3 periods. First 2 months, okay, so you can oppose in the first 2 months. If you're not ready for opposition, your document is not ready, you can file extension for 1 month. Okay, so 2 plus 1 is 3, and then you can again file an extension for another month. 2 plus 1 plus 1. In patents, you don't get any extension. 4 months, if you didn't file in 4 months, basta, finished. In trademark, you get the chance, if you are unable to file in 2 months, you file an extension within 2 months for 1 month, and then for the 4th month as well, you file an extension. Confusion? Clear? 2 plus 1 plus 1, 2 months. If you need an extension, file for 1 month. If you need another extension, file for another month. And that's it. You cannot get any more extensions. You use TM5 form. This is TM5 form for filing opposition, and you have to specify the grounds of opposition, which are available in the law as well. I think section 28 or 29. In reply to the opposition notice on TM5, you file TM6. If you are defending, if it's your application and I'm opposing, I'll file TM5 with the grounds on which I'm using to oppose, and you will file TM6 why this opposition should not stand. You'll give the reasoning, you'll give the grounds, and you will defend your application. Once this is done, I file opposition against your trademark. You file a reply, which is called counter statement TM6, and then I can file a rejoinder saying that no, you are not right, and my opposition should stand. This is all procedure. Okay, this is available. This is possible. And then evidence is shared, just like you mentioned, and I mentioned to you, you can exchange evidence of use. And once this is done, then this goes into hearing. Right now, the procedure is long, so try and use a trademark which is not opposable. So use a trademark which is not similar to something else already existing. It gets difficult sometimes, but this is advisable. You don't get registration till the opposition is done, and that's why I'm saying choose a trademark which does not linger on or makes your procedure long. These are the forms. Once, let's say the opposition was not filed, or the opposition was filed and was not successful. The opponent was not successful. You will get registration. If the opponent is successful, your application will be rejected. Okay. If there's no opposition or the opponent is not successful, you get a demand notice from the trademark registry. Then you use registration form number TM11. This is the fee, and once you pay this, in a few months you get the registration document. You can only sue for infringement based on the registered trademark after your trademark is registered. But you can obviously, just like the question was, you can sue for infringement. You can sue somebody else for infringement based on your use, even if there's no registered trademark. So there's a possibility, but you have to prove that you are the owner of that trademark. From the date of filing, you will, after 10 years, you will file the first renewal. Okay, if you want to keep your trademark, and then you pay 15,000 rupees for that renewal, and you can keep renewing after every 10 years. 10 years. These are the forms. TM11 for registration fees. When you pay the registration fees, that's what you pay, and TM12 is renewal. Very good. Thank you very much. Right on.
So, during opposition, there is no penalty for the opposition party or company, but after infringement suing, is there a standard of penalty?
Yes. So if you sue for infringement, you get many types of relief. We call them relief. One is damages. That this person has been using my trademark and please damage it. And this is for the past activity. For the future activity, you get injunction. You stop the person from using the trademark in future. So for the past, if you want to get some things for the past activity, you get the damages, and for the future, you get the injunction.
That's a, I have a rather simple question. Which one are the codes? Like there are codes for banking codes, that code, and that code. Who should we go to? Like,
Yeah, so for infringement proceedings, you normally go to the IP tribunal. So since 2012, we have, I'm done now. If they're
It's
there,
okay.
if they're there. So you go to IP tribunal, which are in Karachi, Lahore, and Islamabad. And also for infringement, you go there. For invalidation, if you say that this trademark was invalidly granted by the registrar, I don't agree with this grant. This is a possibility to actually challenge the validity. Then you go to the High Court, because the trademark registrar is equal to the member or the chairman of the IP chapter. The trademark registrar is equivalent to the district and session judge. So you have to go to the next level for.
Easy.
Okay, good. Then I have to, thank you very much. And we can continue at lunch or.
Thank you very much, Dr. Owais, for very practical information about the Pakistan system. Yeah, it's useful and constructive. I would like to express my deepest and greatest gratitude to Mr. Salman Khalid to accept the invitation in a very short time. We are really happy to have the honorable representative of the Pakistan in UN agencies. Do you have my voice?
Yes, indeed.
Okay, this I just want to say that this is a two days advanced course in intellectual property. Last year we have the 2 days preliminary workshop on intellectual property, and this year it is the advanced course. I like to say that in these 2 days we have a very good contribution, and we are very impressed by the Pakistani researchers and people who are very interested in intellectual property, knowledgeable researchers. And I know that I hope that you are have very constructive role in the UN agencies, especially in connection with World Intellectual Property Organization, to support Pakistan also in the policy making, making the connection and bringing the development agenda programs like WIPO Academy programs to Pakistan, to have some courses like summer school, professional development programs, and so on. We are going to hear you. Thank you.
Thank you very much. In fact, I must thank you for extending and accommodating us at a very short notice. In fact, I would begin by thanking Comstack in general for this wonderful opportunity to Pakistani citizens. I mean, intellectual property is that area which does not have a lot of focus in developing countries, particularly in Pakistan as well. So it's very heartening to note that a dedicated training is being organized not only for the first time, but in fact for the second time on this very important topic. So please allow me to extend our deepest gratitude to Comstack, the Coordinator General, Professor Muhammad Chaudhry, and his team for pioneering this wonderful opportunity and executing it in a perfect sense. As you rightly pointed out, my name is Muhammad Salman Khalid. I am the Second Secretary at the Permanent Mission of Pakistan to the United Nations in Geneva. We basically represent Pakistan in the UN agencies and other international organizations which are located in Geneva, and they are close to 35 organizations. You might have heard of the Human Rights Council and the Conference of Disarmament. So these are some of the two key functions that are being carried out in Geneva. But
But in addition, of course, we also represent Pakistan at the World Intellectual Property Organization, which is the prime international agency for promoting the protection of intellectual property. I just wanted to take this opportunity to thank Comstack for this event, as well as to introduce the work that we are doing with the objective of seeking future partnerships, because intellectual property is an area which cannot be appropriately utilized unless all the public as well as private stakeholders they join hands together. I mean, yes, we are in continuous contact with the Intellectual Property Organization Pakistan, but this is a field where researchers, academicians, SMEs, startups, everybody is very, very important to this area. I would not want to keep you guys from lunch, but I would just briefly highlight some of the activities that we are doing. For example, earlier this year we have signed an agreement with WIPO. We call it the service level agreement. The objective is to improve the IP administration in Pakistan. For example, in the previous lectures over the course of this training yesterday and today, you have been listening a lot about trademark applications and patent applications and so on and so forth. So we are trying to provide IP Pakistan with latest softwares that can be used for example, for online patent filing that smoothens the process for researchers and creators. Similarly, this project also includes digitization of IPO's records. I mean, we live in a world where everything is on a computer, so we are trying to shift all the data that IPO has to in a digital format. I would also like to share a good news with you. IPO Pakistan is also working on a project which involves the use of artificial intelligence to examine the IP applications. So of course, this is something that is going to take some time, but I think we are having a good and active Director General at IPO Pakistan who is spearheading these efforts. Similarly, we have recently finalized a 6-year country plan with WIPO. Some of the notable projects that are included in the country plan are, first of all and foremost, the development of a national IP strategy. As you may be aware that intellectual property in the previous years has not enjoyed the focus that it must have by the preceding governments. And we don't have a national IP strategy as such. In the past, there has been some efforts also in Geneva to have a national IP strategy, but we are trying to revive that process. It's a 2-year project, and probably we'll be starting it later this year. Then we have 2 more projects. One of them is on branding and design. You know, branding is very, very important. For example, once you have an IP asset, it could be a trademark, it could be a patent. It's very important that you take that product of yours to the market. So here comes the role of branding. I personally believe that Pakistan as a country, we are lagging behind in branding. We have a lot of very good products. For example, pink rock salt. I'm talking here about the geographical indications, because being an agricultural country, we have a lot of commodities, edible commodities, which can fetch us very premium prices around the world. So, I mean, branding is one area where we need to focus. Finally, there is another project on supporting the IP-related work in Pakistani universities. So, over the past few years, in coordination with the Higher Education Commission of Pakistan, IPO has established around 47 technology support innovation centers in Pakistani universities. So we are trying to upgrade the facilities that are available in those, we call them TISCs, We are trying to upgrade the facilities so that the students in the universities, they can make better use of the intellectual property related services in the universities. Another area that we are working on are geographical indications. I'm not really sure if you have been taught about geographical indications in the last 2 days, but very simply, in a very layman language, it's a specialized kind of a trademark which is collectively owned by the people of a specific vicinity. I'll give you an example of basmati rice, for example. So basmati itself could qualify as a brand, but since it's collectively owned by the people and who in those specific vicinities where basmati rice is grown, so there's a dedicated international legal framework on that. That brings me to the fact that there are 24 international treaties that are administered by WIPO. Pakistan is only a member of three or four of them. The latest accession was Madrid, as you might have been told by the instructors just before me. So that brings me to accessions. So we are also trying to improve Pakistan's standing as far as our accession to the international agreements is concerned. One of the most key priority is the Patent Cooperation Treaty. So we had the honor of having the Director General of IPO Pakistan in Geneva last week at WIPO's General Assembly, and she was very hopeful that we will be in a position to accede to Patent Cooperation Treaty by next year. Of course, this is a technical field, and generally as a mission, we simply try to enhance the capacity of our national stakeholders, provide them with trainings. That brings me to another important aspect of training. We are trying to find training opportunities for all sorts of stakeholders. For example, judges, because at the end of the day, it's the judges, it's the law enforcement, it's the customs, it's attorneys who have to implement the intellectual property related laws, play their role in the dispute resolution. So we are trying to find training opportunities. Recently, we had a discussion with Director General of the World Intellectual Property Organization. We are discussing with them to have an IP training institute in Islamabad. I mean, this is something, a very good initiative that has been taken by WIPO. They are helping countries to develop IP training institutes. So this is something that we'll be hearing more in the upcoming months. Additionally, we also felt that intellectual property is an area where diplomats, commercial attaches who are posted to Pakistani missions abroad, they do not know, they don't have the background in that, because IP as a subject, I'm not aware that that this subject is taught at the graduation or master's level in many universities in Pakistan. Of course, we have a number of subjects that are being taught, but I have not found any university where IP is taught as an optional subject. Please correct me if I'm wrong, but so we have requested WIPO Academy, you just mentioned. So they are developing a small module for the Foreign Service Academy in Islamabad. So from next year, all the trainee diplomats who come to Foreign Service Academy for a 1-year-long training, they will also be taught a small module on intellectual property. So I just wanted to highlight these things, these projects, so that some of these projects may be of interest to you, to the instructors, to Comstech, to the audience. I also wanted to highlight that IP filings is one of the areas where we are lagging behind. For example, why IP filings are important. One of the one of the reasons is that in the international indexes, for example, there is an index that is published jointly by WIPO and some other international organizations and research institutions. They call it the Global Innovation Index. So their IP filings is one of the criteria. Also, within the World Intellectual Property Organization, there are certain committees where member states they become a member for a certain period of time. For example, the Program and Budget Committee, the Coordination Committee, and so on and so forth. So we have a criteria that how members they become, how member states they can become a member for a specific period. And let me tell you that IP filings, especially in trademarks, industrial designs, and patents, they are one of the criteria. So it's very important that we bring our IP filings up to the regional level. We have one of the leaders in our region is Iran. They have I think they are only second after India. They have a very good number of very healthy number of IP filings in Iran. So probably we could also discuss as a future activity between our Iranian colleagues and IPO Pakistan. So this is all I have. I just have few suggestions that may be of interest to Comstech or our guests in the audience and our instructors. We have opportunities in Geneva from WIPO with regard to the following. IP for startups, for example. Startups have made a huge mark in Pakistan. They are making a huge mark in Pakistan, and trust me, this information has also reached international quarters. I remember that a number of my colleagues in WIPO they shared this information with me that startups in Pakistan are doing very good work. So I mean, we could also think of a project where we tell the startups that look, IP is also important, and maybe they could have a dedicated team or a person who can look at their IP assets. IP for SMEs, there are a number of tools that WIPO has developed. There are some online tools for SMEs in which they can manage their intellectual property. WIPO has also proposed us to have a kind of an awareness raising or a dedicated program for software developers. Pakistani software developers, as you may be aware, our IT exports are increasing in the last 2 years. So I think this is time that we also bring IP to our software developers. We encourage them that, okay, freelance work, online freelance work is also good, but maybe they can possibly look at having their own startup, registering their company, and similarly IP for women entrepreneurs. We have a proposal from WIPO that Madam, you mentioned WIPO Academy. You mentioned the development agenda. So in context of the development agenda, WIPO has proposed to us to submit a proposal in which we bring together women entrepreneurs, the role of intellectual property, and their connection with enhancing rural tourism. So I am mentioning all these things, and that brings me an end to my presentation. I just wanted to highlight these because we are continuously searching for national partners which can become anchors for our projects, because as a mission we can find opportunities, we can become a bridge between our national stakeholders and world intellectual property organization, but it's not possible for us to execute those projects on ground in Pakistan. So there has to be some kind of ownership in the country for efficient utilization of these opportunities. So once again, please allow me to thank you and pay my sincere gratitude to Comstech for surely one of its kind training in Pakistan, and I'm very happy to be here, and would be very happy to continue this dialogue. Thank you very much.
Thank you very much. I'm really happy to hear that very hopeful news for Pakistan in different for different projects like GI, because I think that the GI is a neglected core competencies for countries such as Pakistan, and your kind efforts on TISC project. It is very important project for especially to foster in the innovation and technology development process at universities especially, and also about the AI in IP and IP in AI, because they have to both can help each other. Yeah, and initiating the IP training center in Pakistan with the help of the IP Academy. I believe that it works a lot, especially in collaboration with this project. And I think Pakistan can be a hub for OIC countries in collaboration with WIPO and comstech, and they can initiate the programs, and Iran can help in this program by the experience we have in our country. And because the INSTP secretary is located in Iran, we can jointly we can help each other, and also help to OIC countries to promote their own system and own types of the intellectual property management, because maybe our matters is not just the registering and protection of the patent, also focus on the other part of the innovations like GI. GI is very important, and branding system is very important in our country. And maybe our routines and our models for the patent protection maybe are far from different from the other countries. Maybe we have to make some flexibilities in our IP law, patent law, weak system, a strong system about the process patent, product patent. And I do believe that in that course, IP awareness, such kind of workshop will be very helpful. Thank you, Salman, very much. And Dr. Awais wants to add some points.
Assalamu alaikum, Salman. Can you hear me?
Yes, thank you, Doctor.
Perfect. Salman, thank you very much. And before I go on with the appreciation that I really want to share with you about your comment on startups. So the D Bank just raised around $17 million from Sequoia, and this is just in. So this is, I think, today's news. So this is also big news, especially after a few weeks of interesting news coming about the Pakistani startup system. So it's a good news. So thank you for mentioning that. I must really appreciate you individually, because I have been in this field for the last 18 years. I've been to WIPO, I don't know, uncountable. I cannot count how many times I've been there. I've interacted with a lot of policymakers. Why am I singling you out? Because you reached to me on LinkedIn, I think a couple of days back. It has never ever happened before that a public official, that is official who is actually sitting in Geneva has reached out to me and has offered that we can do something together. Secondly, I really appreciate you having the kind of knowledge that we need in our civil servants. I'm not saying with regard to IP, they are very intelligent and they're very smart, but with regard to IP, I will be telling you with all honesty, I've not seen many who understand what IP means. So this is really great that you're sitting there. And I was just browsing through your LinkedIn profile, and most of the posts that you have liked or posted are related to IP. So this is such for me as an IP professional in the field for the last 18 years, such a exception. And I really thank you for doing what you're doing in Geneva, representing Pakistan. And I'm very hopeful
that at least the national IP policy initiative that you mentioned hopefully will take off. I actually presented back in 2014 a paper on, so I created a framework for assessing national IP policy that I presented back in 2014 at WIPO, and in 18 in Malaysia in a conference. So that is available with me if you would like. And I also was part of the IP policy formulation team back in 2017 in Pakistan. So that is available with me. If you would like me to contribute to that, I'll be happy. I'll be happy to also contribute with the training that you mentioned for civil servants. I would not like to impose myself. What I'm saying is that I am available whenever you need it. It's really great that you have talked about the importance of IP. And I just wanted to highlight one more point. Being an academic, so IP is actually taught in several universities. I have been teaching IP in Pakistan for the last 4 years on both on undergraduate and graduate levels, so LLB and LLM. And I know for a fact that LUMS is doing that. I know for a fact that Punjab University is doing that. I know that it's being taught in UMT Lahore. Even certain universities in like I know that it's being taught in Sindh University and different programs as a it is still an elective, so it's an optional course. But for example, at Zabul, where I teach, it's offered every year. So it's not really, it's a quasi-optional course in that sense. So it's happening. Coming back to my point about the importance of IP, it's also very important to be seen present in this dialogue. So for example, when it comes to the waiver that was proposed by India and South Africa and the countries of Africa, I don't know how active, and I'm hopeful that Pakistan was active as well, but it was behind. It seems like it was behind the scenes. So it's also very important for Pakistan to actually feature as a country, and I'm pretty sure that with your interest in IP, we will be able to achieve that, and the presence that we need to have in WIPO assemblies and all. The focus on interaction between IP and health, IP and food security, IP and education, traditional knowledge, and digital technologies, it's something that is really, really important. And along with developing IP practitioners in Pakistan, we need to develop understanding of these cross-cutting issues as well. And that's only when we can have a national IP policy or national IP understanding, which matches the other policy objectives of the government. So we need to see IP in the context of other policies, and that's why I really appreciate that the IP policy is important. Yes, you mentioned about patent filings. We really need to focus on improving the statistics on patent filing in Pakistan. It has hovered around between 800 to 900 applications. The good thing is, and that's what I presented yesterday, the good thing is that the Pakistani applications, the number of Pakistani applications are increasing thanks to all these people who are actually sitting here and those who are actually attending online. So a lot of the attendees here have also filed patent applications, not only in Pakistan, but also abroad. Interesting statistic, and that's almost my second last point. Trademark filing are respectable in Pakistan. And I was just looking at the statistics between Pakistan and South Africa. So trademark filing between Pakistan and South Africa are comparable. When you look at the patent filing between Pakistan and South Africa, it's not comparable. So South Africa is like 8-9 times more patent filing. You talked about opportunities. I just wanted to add 2 more. WIPO has good LLM programs. So that's also something that is available for people from developing countries. They also make it, they provide scholarships as well. And then there are other DL courses.
And PDP courses.
PDP is also important, other online distant learning courses. I'm also a tutor at the IP management course, and Dr. Mitra is also actively engaged with those DL courses. So these are two more opportunities that are available for citizens of the world, including Pakistanis. So yeah, Salman, I'm really, honestly, it's not just exaggeration. I'm really happy. I was not expecting somebody coming from, okay, this will be non-diplomatic language. I was not expecting somebody who was having so much interest in IP. I have been to your office in Geneva, I think back in 2016. You were a, how should I say, breeze of fresh air. And I hope that you also create more leaders who follow in your footsteps and represent Pakistan, especially when it comes to IP, competition law, digital technologies in Geneva. Thank you very much.
Thank you very much, and very briefly, thanks a lot for your kind words. It's only after dealing IP, I came to Geneva early in 2020. It's only after 2 years that I have started to basically understand the vocabulary. I don't call myself an expert, but when you attend meetings every other day, you listen about things. So the same thing again and again, you interact with people. Although this has taken more time because we had COVID, there was no in-person interaction. But of course, very happy to be here. You talked about the mission in Geneva. I spoke earlier that it's basically human rights and arms control and disarmament issues which consume 80% of the time, as well as the sources of not only the mission but the overall team, the ambassador, everybody. So what I have been trying to do is to raise the IP profile, because being in WIPO for 2 years, I have seen how innovation and IP can do wonders for countries, for individuals. So thank you very much for your kind words. This is our job, and this is nothing extraordinary. This is what we are paid to do. So, but your discussion it points out that definitely there are so many things that we can talk about further. I mean, this definitely needs a follow-up. It's only when you do the follow-up, that when you follow up on the opportunities and points raised, that you make progress. So definitely we'll be happy to follow up with you, sir, and with the instructors, especially from Iran. On behalf of the government of Pakistan, I also take this opportunity to thank the mission of Iran and their embassy in Islamabad and the instructors for taking time out for this course. Madam, you mentioned geographical indications. In fact, I have a number of interactions with my Irani counterpart in the mission here. So Iran is doing some wonderful work. Just last week we had the assemblies of WIPO. So Iran had a stall. It was not only a stall; it was basically a GI exhibition within in the premises of the World Intellectual Property Organization. And if I recall correctly, it was it was based on a special GI Irani carpet. So what they did was very interesting. They basically made a carpet. It was hand woven, and it had a WIPO, big WIPO logo, handmade in the center, and they gifted it to WIPO. Now it would be displaced. I mean, this is the branding that we need for our geographical indications. And I agree that comsats could become an anchor for OIC countries to take forward not only the development agenda, but as well as the overall IP profiling and raising the IP profile. We stand ready to cooperate. In fact, not being IP professionals ourselves, we depend on the advice of professionals like yourself. to take forward this dialogue. With regard to the South African and Indian proposal, of course, Pakistan, we co-sponsored the proposal. I would not try to shift responsibility here, but the fact of the matter is that we don't deal with WTO as a mission. We have a separate dedicated mission which deals with WTO. We have a separate ambassador, a separate team. They basically come from the Commerce and Trade Department in the capital. But of course now this became the very reason that we started having regular interactions between our two missions. In fact, our ambassador was there only yesterday for a meeting. So we have started a monthly dialogue with our colleagues in the WTO mission, so that to coordinate our activities for the current as well as God forbid for any future pandemics. So yeah, but very well, your point very well taken. Thank you very much.
Last but not the least, I think Professor Maheser is also sitting here. So I don't know if you have been to Comstech. I'm not from Comstech, by the way, but I'm so amazed by the team and the hospitality that Comstech has actually extended to us, and the building. I'm so amazed by the facility that they have created. So I think Comstech is this venue, and the team is one of the best. I've actually encountered Professor Saab in Pakistan, having such so much facility, and the team, Akil Saab is sitting there, the way they have handled the whole thing. So I should thank them as well for carrying this out so professionally. Yeah. Thank you. Sir, would you like to say a few words? Ajay, sir.
Experts have already spoken. Thank you. Experts have already spoken. Thank you very much for joining us. I don't have to say much. I'm not an expert in IT and IP. So all I can say is that thank you so much for joining us and enlightening us with your observations. And because everybody else is waiting for lunch. So I'll just close it. Thank you very much. Thank you. Grateful. Thank you very much.
Thank you.
Thank you, everybody, and goodbye from Geneva.
Thank you. Bye.
Anyone who does not have case study number 2. We are starting in a couple of minutes.
But you had it, okay? But you had it before. They had it. Yeah. It means that they read it. Okay, it's okay. It's forgetting is okay, but not having it all. I'm not that much.
Okay, I think we distributed the second case study yesterday.
Okay. Okay. Did you read the case? Okay. Shall we start with a short introduction of the case? Okay. The case is about a startup start to work in 1997, and the device they invented is a nebulizer. You know what is nebulizer? Okay, can you introduce what is nebulizer?
Well,
just I put the picture of the nebulizer. Okay, because in the corona time, yes, all the people know what is ventilator and such things. Okay.
So nebulizer is actually a device which contains a mesh-like stuff that basically enable liquid medication to be transported. I mean, first it converts them to smaller particles, and it actually enables the liquid to be transferred into a fine, yes, particle mist. So it facilitates delivery of a broad range of drugs deep into the lung of critically ill patients, actually. So, and this leads to drug deposition and rates greater than the rate which is achieved by conventional aerosol technologies.
Okay, thank you.
So about
the invention. Their invention is that they make the drops in a very small size, in micro size, 5 micrometer, and it can be attached to a ventilator and to help the ill people to in that way in hospital they can deliver some medication through the system of ventilation. It makes the drops in a very small drops, in micrometer size, and they can get the medication through the
deep into the lung. The mesh
breathing
actually
system.
vibrates, and
so they started to marketing at first. They started to file the patent in their own country, which was Ireland, and then started to negotiate with the other companies, big companies like Philips, GE, and also they participated in different prizes and competition. They get lots of awards and grants. Thank you. So, and after that, they have a kind of, after about 10 years, they have a merger and acquisition somehow strategy to become big. Okay, have you all read the case? You're supposed to. Actually. Okay, most of you read. I know. If you need, okay, we can start with people who read. Okay. Meanwhile, the others can go through the case very quickly. Is it okay? Because
Will we make groups?
It doesn't. We can.
Will we make groups? So if there are 4 or 5 of the participants who have actually read, we can put them in one group each. So that
yes, we can make group, or even we can do without making group to.
Because you can take individual opinions, because there is no specific question.
Yeah, there is no question.
From your group anyway comes individual.
One person group.
Which is good.
Yesterday we asked you to extract the strategies about the business regarding to the, with the mesh of the intellectual property, what they do in the intellectual property side, and extract the strategies. Okay. What do you think? Is it better to make? I think we can stop because of the time limit. I think we start. We start. I forgot your name. Ahsan. Ahsan. The best. Better.
Well, I like the definition.
Okay.
So, what do you want me to tell you?
You said that you
Well, I read
okay.
it, yes.
We asked you to extract the strategy. Just I want to add something that we decided. We three decided to not take the paper exam, and we evaluate the class because you are all researchers. Your contribution was very good. And we decided to evaluate the course by the contribution of the people in the presentation, asking questions based on the case studies, and that. Just that.
That's a good thing.
That was a good news.
So you want me to tell you the strategy?
The strategy you get that from the case.
Okay. Well, the main point is that they initially developed a device made from platinum.
Everybody can hear?
nickel.
Everybody can hear?
So they just made one device, and then later they keep on improving their portfolio, although they are taking help from other collaborators as well. But not much is mentioned in the document that how much from where they are taking the help, but they need, because the basic work, the research work is done in the universities, and because they are unable to do it, they don't have time. So within the time after their first patent portfolio, their focus remain on the getting more and more patents and earning from the patents, not like more than the research, the basic device research. They are more focusing on the patent, and they are probably the best in management of the patents. For example, they are looking what competitors are doing, the products they themselves are developing. They just check if it can be reverse engineered or not, and if it can be reverse engineered, then they will patent it. If it is not reverse engineered, then they will make it as a trade secret. So in that way, and then of course continuously they are also focusing on what other companies, their competitors are doing. They are analyzing them, and then of course suing them and wherever necessary, and getting help from three main attorneys from America, Germany, and Ireland. So, and most of the story is based on how they are handling their patents. So that's really a great understanding that how companies work in terms of patents, and they support they as they say they try to save their intellectual property, and then actively trying to find out what other companies are doing and so on.
Exactly. Asan, Dr. Asan, you're really Asan.
Yes, I was so about to say that.
Yeah,
he has-
because
and I'm
he
going,
here
because
with
you're
the
done.
case
Like,
very
it's
deeply.
finished.
Yeah,
We should go. We should just completely leave.
Has with merit.
Yes, thank you. There's nothing left.
You read the case very deeply and mentioned to the very strategic point about the patent portfolio and patent management, using the the attorneys in different countries, in Ireland, in Germany, in US, and the main point is that they are watching the competitors and making kind of collaboration with competitors. It is very important to making collaboration with competitors. If you can not compete with your enemy, it is better to be a friend with enemy. Okay. It is very important strategy in IP management. If you cannot compete with the enemy, be friend with it. Okay.
I would like to just add one or two points into it.
Can you speak some
Yeah,
louder?
I would like to add one or two more points into it. That since 2008, first they were actually having a merger with the mainstream ventilator producing companies, Philips, GE Healthcare, Hamilton, Medtronic, Bragger, etc. So what they did, they were dependent on their technology nebulizer to be used in that ventilator, and they made their own market. And one more thing, in 2008 they had a very good growth rate of 30% through product sales in over 75 countries, recorded revenue of 40 million, and out of which 5.2 million they reinvested in their R&D to make more patent and to become sustainable and market competitive.
Exactly. So what's your name?
Riaz.
Riaz.
Dr. Riaz.
Dr. Riaz.
Dr. Hassan, full name?
Dr. Hassan Jabbar. We are the same family.
And just to mention about the online participant, if there is any, because they have the case, I think yesterday is Mr. Akil sent them. If you have any comments on the case, please write. Okay. Okay. Dr. Riaz mentioned to R&D. Now, when we start a business, and it is a startup and small business. When we earn money, we get money, we think that, okay, it is very good, we can have it and go to do some like luxury and leisure. But it is very important, especially for SMEs, to put part of the money in R&D to make the company big. R&D, it means that, for example, if you do an invention and you bring it to innovation, I mean, make it apply, okay? The other competitor is not just stay and watch you. They are doing something. They are going to compete with you and they innovate. Innovation is something that inventing continuously.
Yes.
In inventing continuously means that you need money. Okay, where the money is, R&D. R&D money is not just come from the pocket of the founders. Okay, maybe at the first time from the pocket of the founders, or maybe the grant by university, or maybe grant by any, governmental funding agencies. But after that, when it become a business, so business should make the business, and the percentages of the revenue they allocate to the R&D is very important. So they did this strategy. I think 30% of their 30% of their sale in 75 countries they put in the R&D.
Yes.
Okay. Do you want to add something?
Yeah, and they not only included the industry, but also in their R&D, they contacted universities, they collaborated with the entire industry because they had a limited capacity in their company, and the university hiring respective consultants to use their, so that was their strategy to become sustainable, market competitive, like getting a certain percentage of revenue, and out of which reinvesting in R&D and giving some parts to other collaborators through licensing and be the key product item in those anesthesia devices regulators, such as for specifically very ill patients, and giving some portion to the universities to give them R&D and then come back to you.
Exactly. What is the name of this strategy? Using university as a source of R&D. A good definition, and one another.
Smart partnership.
A smart partnership is good.
Contract research.
Contract research. All of them is the umbrella of one term, open innovation. Okay. Why do they? I mean, why do they did this? For example, you are a company and you are, especially you are a small one, okay, or even you are in university, okay, no difference. You have different department, like for example, trade department, law department, financial department, and you have R&D department, okay. If you are a company of, for example, 15 or 20 or 50% even, how many people can you hire in your R&D department? More than 5 people? For sure not. And how much knowledge can you gather in the R&D department? Okay. And how much money you have to pay them as a wages? You have to provide them with room and working facilities and everything. Okay, pay taxes and many infrastructure. But you have access to limit knowledge. Okay. It is the strategy of the, the new era strategy is open innovation, that companies use the, especially universities, as the source of R&D. In that way, okay, for example, if you have a contract management with a research contract with one university, 2 universities, you have access to many researchers, it means that you have access to many R&D. But there is a big challenge here, okay? What university wants and what industry wants, because their mindset are different, okay? What university wants? A university researcher wants to publish the articles, okay? But the industry say no, okay? So how we can, solve this challenge? It is very important. The solution is intellectual property, okay? For the researcher at university, what is important? Money for the research, industry bring the money, okay? They want the article, okay, industry said, okay, just wait some months. I file the patent. I do some protection about the intellectual property. And after that, the copyright is for you. Industrial property rights is for me as an industry, as a company, as a business, and the copyright right is for you. Or even they can share the revenue or the consultancy, contract. So open innovation paradigm that is going very, spreading a lot nowadays. The main structure is intellectual property. Doctor, you want to add something?
I just want to say that this exactly right. When I was doing my PhD, there were a lot of people working on open innovation, writing their PhDs on that. And this is what you said regarding collaboration. So this is an era of collaboration. The thing is, within the closed silos of your own R&D department, you can only get as much innovation. You cannot expand your R&D team as fast. You don't have the resources. What you actually do is you bring in collaborators from different universities, and it's happening in Pakistan as well. A lot of the people sitting here actually would be doing this as well, working with other universities as well. And then obviously bringing in academia, industry, which helps you to make your research applied. So that's really, and they give you the insights about the market, the consumer feedback. This is not about the case study, but another variation of open innovation is called user innovation. So user innovation is also something which a lot of innovative companies are actually capturing and putting it in their own R&D. So they actually very actively get feedback from the user, and at times they bring in users in their labs and ask them to modify their products. So 3M, for example, is one of those companies which actually actively engages its customers and brings them in their they have makers spaces. So what they do, they bring them in, they ask them to solve different problems, create different products, and from that they get inspiration, they make new products, and then they find patents.
One more thing, because the document is very long and I read it in the back, so I just try to fill it up. One important thing, there is one regular strategy meeting they used to do it once in a year, and it has the strategic objective, specifically whatever they get from the universities after the R&D. So it was very important that their team who makes the strategy used to provide advice on what to patent, what not to patent, and where to patent, assessing potential infringers and monitoring the status of competitors' patents, and to stay in, become visible and sustainable all across and keep growing and reach. So that was a process they actually tried.
Dr. Let me ask you this question. As the head of OIC, let's stop thinking about university as a university. Let's think of university for a minute, that you're not part of a university, you're part of a company, and you are the OIC, which actually in the company would be R&D. But not only R&D, what else would be there in the company of the department that you are heading? So if you're heading the exact department with the JD in a company, what functions will you be having as well?
What functions?
And this actually connects to this study.
If I am a designer company, which usually lacks in Pakistan, so designer company, I will have my R&D division separately, and also innovation and commercialization strategy division as well. And
what would that division do? What could that division do? And go back to your comment that
You mean that R&D division?
What would ORIC in a company do?
Yeah.
Connecting to what you just said.
Yeah. So I will have, and I will also have a division that will actually take care of the training and sustainability of the HR, especially like that is being trained, that are those who are writing patents. Somebody, for example,
So R&D, training development, let's put it like this, and
training development and patent writing. Yeah.
There should be an attorney.
Attorney.
Who knows the laws and if someone infringes it.
Attorney.
In-house.
There's a reason
Maybe
why
outsource or in-house.
there's a reason why I moved from university setting to a business setting. What am I alluding to? And you also mentioned it, Dr. Esam also mentioned it just now. What we don't do in the university, the ORICs don't do. But a spin-off company would do, even from an ORIC.
They track the competitors, what they are doing.
Competitive intelligence. ORICs don't do that somehow. And I think they should. If they have to do commercialization, they have to do what, and one of the best sources, obviously, the market intelligence is a good source. One of the best sources is actually patent databases. The interesting thing about patent databases, you as a researcher, when you will get the patent, you will get the patent probably 6 to 8 years down the road from the day when you started working on your research. So you as a researcher already are thinking at least 15, 20 years ahead of your time. Because if you're going to get a patent, you will at least feel that the effective patent life should at least be 10 years. Yeah. So what you're doing today is actually thinking about, and a researcher, if not doing that, I don't know how will the invention survive in the market when it actually comes into the market after patenting. And that's when you need to actually go in the patent database and see what the rest of the industry is working on. What is the gap? And this is exactly what she mentioned when she mentioned in the morning that there are paid databases which actually have, for example, Clarivate. Clarivate's database is expensive, but if HEC wants, it can actually buy some membership subscription. Sorry, it actually gives you a tool which identifies in a map your competitors, related technologies that have expired. I mean, it gives you a complete competitive intelligence map for you, for your own technology. So it's a great learning tool, it's a great teaching tool, and at the same time, the same thing is a great tool for competitive intelligence. Unfortunately, it's paid at this point. It's amazing.
In case of universities, we are not competitors to each other.
No,
We
no.
have different departments and each and every researcher
Yes.
is free to opt.
And I'm not talking about competition. Competition is good, generally. Okay, it helps you to innovate as well as keep prices down. What I'm saying is, as ORIC, you have to think about if you're ORIC. If there was no ORIC, I wouldn't say this. What's the point of having an I and a C? R was already being done in the university. Research was being done. There was no innovation and commercialization. That's why ORICs were established. And you have to know what can you actually sell in the market if you don't know that. And the best teaching is from the competitor. They have taken the risk already.
So do you want to say that in other words, ORIC's duty is to see what is requirement of the industry?
Yes.
Which are the gray areas where work is to be done and you can earn money and do research as well?
It may happen, sorry sir, it may happen that you as a researcher is actually by reading the patent database, for example, and doing the analysis of the field, reading the patent families, it can actually go back to the industry, for example, in Pakistan, and say, listen, you are so behind the curve.
Yeah.
This is the database. These are the patents that are there. And in 5 years' time, you will be out of the market, or you will always remain the second or third company in the market, you will never be able to catch up with these big names because you're not looking at what's going to come 5 years down the road. So that's what I'm trying to say.
Could you help from the Iranian experience? I think this is great what you're saying. Although it's a very enormous task. Could you share from the Iranian experience how you address these things of competitive, the universities address these issues of competitive?
Before
Could you share some of the experience?
his question, I would like to add to that will help everyone, and maybe you can help us. When the COVID came, I was the one who was the inventor of the ventilator as well. And that ventilator actually got the provisional approval of almost 50 to 100 ventilators from Pakistan Engineering Council, and I've gone through personally through that all ups and downs of the drive, how to get the license. And we are still in process, and we found out that without having any SME who are interested and a good manufacturer of the biomedical devices, and we cannot actually commercialize that. So the thing is that I absolutely agree 100% with your point that we should have a database. After that, what I did, I became the director of the OIC, because the university thought that this guy already doing R&D and working on the things and the projects that are actually needed by the government and the university. I'm just cutting short. And then we try to contact the relevant industries, but we found out there is some kind of problems with the country mindset that, for example, the country who mostly do imports on their goods, especially in biomedical and other things. So they actually are reluctant to indigenously build. It for us, it looks like it's a long process. It's a very long process to convince people to come into that technology. Then we found out we should develop our own startups and go in that. Then being a government employee, you cannot directly involve into that. So there are a lot of things going around, and still. So in ORIC, what I try to do is to find out the relevant product and prototypes that are attractive to the industry. That's why we establish some research and technology showcase so that they can be attracted. Industry start coming towards us, and then they start telling that these projects we are not needing from you. These are the projects that we are needed, and the ORIC should. So in that direction, we are slowly, gradually going already. So I would like to hear from you what in Iran, how you tackle these problems, and some university professor or faculty led, then how, what way you get to commercialize and bring industry closer.
Okay.
Before we go to Iran, this is a quick one. You ask a question, Google Patents gives you the answers. These are the top assignees for ventilators. I've just written ventilator, that's all I've searched.
And even you
can
can access that. Even they have you can access better data in patent scope. Yes,
yes. I'm just saying that this is
the easiest one.
to Google.
Just
You
to
just Google Baba. You just go and take it from Google. Somebody says Google bot. Yeah. But yeah, this is the comparative analysis, and you can narrow down the search. You can define what the exact technology. You can keep narrowing it down. You get the assignees. You want to collaborate with the inventors. Go to the inventors. These are the guys who actually have top relative count of that. Maybe you can write to them, try and or just click on them, see what they're working on.
So these are the owners of the invention.
these are the owners.
These are the inventors.
Top owners.
So this I changed.
You changed it.
So this James guy, whatever the name was, is actually has in the database it can find I don't know 182 applications or granted patents.
Okay. Okay. Imagine I come from Iran and I just know the Farsi language and I don't know English. Okay. And you, Dr. Riaz, from Pakistan, you just know Urdu and you don't know English. How we can communicate to each other and how we can talk together?
There must be
is a dictionary is enough? For example, if we have a dictionary, Farsi to Urdu, or even Farsi to English, English to Urdu, and when we want to talk, just check word by word from the dictionary and start to talk to it. It takes time, okay? We need to know a mutual language. So imagine I'm university, you are industry. We have to find a mutual language, okay? If we want to, for example, we decided to, okay, I'm Persian, you are Pakistani, we are going to find the language, okay, we say that, okay, English is the best one, we are going to learn English. It takes time, it takes time. It is not just one time, action. But there is a solution that we find someone who knows Persian and who knows the Pakistani, a translator. Who is a translator in the field of technology and innovation management? Dr. Shatter, who is?
The TTO.
TTO. TTO, yeah, it has. And it is not unnatural that you said that they negotiate and they fail. The industry university negotiation is negotiation. Even they fail many times, but after 2 years, 3 years. And TTO is there to facilitate this procedure, okay? So we cannot say that, okay, we had a negotiation and we failed and the collaboration finished at that time, okay? By the way, can you elaborate more about what is the application of patent analysis to checking the competitors and how you do this?
Yes, of course.
And please having the freedom to operate.
Yes. Before talking about that, I would like to emphasize on technology life cycle. So we actually, how do we have that graph of technology life cycle, that S-curve? We have it exactly based on what we get from databases, from patent databases, sorry. So is it always necessary that I establish a company, that I go found an SME, I don't know, whatever, a startup, something like that, and then I start working in my R&D from the beginning, from 0 to get to the 100? Is it worth it? When I get to the 100, the world has gone to where? Maybe I should put like 10 years, especially in some technologies. So patent databases are actually one of the main things which is one of the main applications is exactly that S-curve. That S-curve is very important. And about the key players, yeah, those most of the analysis, because you find many patents. When you search, there are lots of patents. Not all of them are important. Those which are isolated patents, like I'm a researcher, I have come to this field, I have done a research, and then I'm gone. So these are not important at all. They are isolated. I should find those which are integrated to each other, those which have made a network with each other. I think.
We call them patent families, right?
Yes, yeah. Patent families and those, yeah.
I want to talk about patent families later. Okay.
Yeah, okay. No.
Family right now.
Yeah. No, I was saying that, yeah, those network, I mean, those are the important patents that we can actually gain technology from, or from the technology life cycle that we get from this patent analytics. We can know, okay, I'm producing this technology, same as like this nebulizer. I want to produce this nebulizer and I want to add some improvements. So do I have to develop it myself, all of that? Should I just, maybe, is it not better to go through licensing and stuff like that, to get the license and then improve it?
I'll just quickly make one point.
No, I just in this, I'm sure.
Yeah, and for this, one thing that we did not emphasize enough or did not mention really, patent documents have a very important and interesting section. It's called citation.
Yeah.
And citations will teach you a lot about the past. Obviously, description part also.
Prior.
Prior, exactly. And you can actually go and click on all these patents. These are related patents to what one. I opened one patent and then there are like these backward citations, forward citations. You know the company's name. Which name is coming up in this part very often?
So
Which
there
is
are
the company
exactly the
that's
network.
coming up? So you know, have an idea. You extract the name from here. You can actually put it in your own database. That's all.
Sir, I have a question not regarding this discussion, but in general about the Pakistani patent system. I know that HEC, Higher Education Commission, in the past was supporting for the attorney fees and these kind of patent filing in the US. Then I learned that the attorney was not competitive enough, and then most of the patents were being rejected. So, and then currently HEC has stopped funding for that one. The universities, because of the economic situation, are not supporting all the patents. They are only focusing on those patents which they think that can bring some money. If they think that it can't bring money, they will not entertain it. So my question is that according to your experience, what are the current possibilities other than university itself, which can provide funding for the patent filing if we are interested to file in US or somewhere else?
If there is in Pakistan, yeah, you said I gave you our experience in Iran because there are other
questions. Or do we park this
yeah.
question? Okay. So in Pakistan, at this as such, I don't know of any facility like this. IPO does provide some help. I'm not sure what, I'll be honest. But there have been some international help desks. Okay. So what do you want the money for? That's the biggest question. Why do you need money? If you go to the US, you pay 190 or 102, I don't know, 190 euros.
US?
Dollars.
Official fees or official fees?
It's not that much.
It's less than $1,000.
Who are you paying the $14,000 to? To the attorney.
To the attorney, yes.
Yeah. So if we are able to train ourselves in writing some kind of claims and patent application, today we start today, and maybe in 3 years' time, some of you will be able to. That Dr. Suhail Chaudhary. He would be a good person for me to focus on for writing good patent applications, not only for ComStats. Why only for ComStats? ComStats can actually ask him to write it for others as well, who pay him, and he keeps some money, and the university gets the other part of the money. So at this point, I don't have a solution. I don't know of a solution in Pakistan.
But this is something that I can share you from my experience. A couple of years back, I was working on an idea. Well, later that idea failed, and I was planning to patent it. Directly patent it without involving the attorney. And then I tried to look into that matter, and I found many links which were trying to guide you how to file a patent without the attorney. So this means that theoretically it is possible if one person is. However, what happened that unfortunately the idea didn't get through, and then I stopped it. So
in this respect, university can train its applicability. It can use its applicability.
It's basically not a lawyer's job. It's basically an attorney's job.
Attorney's job.
And you have to have in that field of invention, you will have to have a background in sciences. You need to have background.
I just want to share the Iranian experience.
We may propose this to comstech-oic. You can propose this.
Okay, just I want to share the Iranian experience. You want to add something?
Yes, sure. Mr. You just said that TTO, Technology Transfer Officer, from TTO means he do the liaison work between the industry and the university. I mean to say these TTOs Are they government officials or they officers of the?
TTO is another name for audit.
Okay.
The TTO belongs to university.
It's audit. We call it audit.
Correct.
Office of Research, Innovation and
ORIC.
Commercialization.
ORIC.
It depends. You can.
There are different names in the word, TLO, TTO, OTC. Yeah, TTO.
Earlier I said that this was a job.
Office of Technology Corporation. OTC have different special meaning in
I don't
Pakistan.
know. I thought about something. And then I laughed. And I don't want to share.
Okay. About the Iranian experience, you have two questions. But what companies do in Iran for the technology? I mean, the competitor. Some big companies do this, do themselves, okay? But the small ones cannot do that. And because of that, I mean, Iran is somehow new in this field as well. But there are some companies and firms, like the company Fatima came from, they do this for SMEs. That they do some researches and all the time they, I mean, monitoring the patents of the competitors. But in the world, I mean, in the US, in Europe, they are very, I mean, professional firms do this and give services. And we are talking about the TTOs. For example, we are from university. Okay, how many PIs are there university?
PIs?
Principal research.
Principal.
Well, there are many because.
For example.
Well, in my campus, for example, the number of PhD should be around 150 to 200. So,
200.
and
Okay.
maybe at least
How many
75% of them are have got the funding. So this means
Okay.
that.
How many patents every year?
Not
They
many.
file.
Well, yesterday.
Approximately, I don't want the exact number.
Four patents a year.
Four,
But
five.
because our university has 7 campuses, so if including all 7 campuses, we had only 4 patents last year.
Mhm. Imagine not 4, imagine not 5, imagine 10. Okay. Is it feasible to launch a TTO? And in TTO, you have to have, for example, a person for collaboration with industry, a law person, a finance person, a marketing person, having an attorney, in having different speciality for just for 10 cases?
That's the problem that the
It
audits
is
are
not
facing
feasible,
facing
okay?
today for the last 6 years. That's
For
the-
example, in countries like Colombia, they have, I mean, their public universities are 80. They have 80 public universities all over the country. The government launched a IPM, Intellectual Property Management Office, IPM, and they give service to all public universities. It is feasible. In Italy, there is a network which name is Netwall. Yesterday I told you. In Netwall, I think it is something like 7 university and research center. Their TTOs are connected to each other through a MOU, and they have a confidentiality agreements. If, for example, your university needs some kind of services and you don't have, and I have, through that network, they are collaborating each other. Maybe it is the best solution for the starting point. For the starting
This is
point,
what
you have to
exactly we
do-
were talking about at lunch. This is exactly what I was saying.
Yes.
And the interesting thing is, in the ORIC, the intellectual property manager position is half. As far as I remember, in the beginning at least, the IP manager was not supposed to be a full-time employee. And every university was supposed to make an ORIC irrespective of where it was, whether it has, my university is law university. We are supposed to have an ORIC. We don't even have computer science department. So I can think of my LLB students or LLM students thinking about law and delivering law through digital means. We don't have them. And this is happening.
And but one point about the, I mean, the money for the attorney, because when you file a patent in EPO in US, the official fee is not too much. It is about $1,000 or $2,000 or euro, something like that. Yeah, the attorney fee is very high. For example, in EPO, if you want to file a patent, it takes more than 10,000 euro. in US, we have an attorney that is Pakistani. He's Pakistani.
Yeah, I told that.
Yeah. Our attorney in US is Pakistani. His name is
Mr. Harris Bajwa, if you want to search maybe.
He's a very good guy.
Yeah, it's pretty cool.
Yeah. And you have to pay more than $7,000. Okay. Our experience in Iran is that we try to internalize the attorney fees for the filing in foreign IP offices. We have a center which name is IP Kanun. Okay, you know what's Kanun? Kanun Center. Kanun Center. Not Kanun, Kanun. Kanun Center. It is different from IPO. I mean the official one. IP Kanun is working under the Vice Presidency for Science and Technology, okay, which the Carafom is a main agent of that, and they also help to National Innovation Fund as well. They try it during the years. I mean, it takes 5-6 years to send some people to the such kind of classes, drafting patent classes. Even many times this Harris came to Iran to teach the researcher, because, for example, people like Fatima has scientific background, she's biotechnologist. And we have, chemical engineering, patent attorney, mechanical engineering, electrical engineering, because the attorneys are like this, they have scientific background. You know, it is very good offer for you as well, okay? Because patent attorneys is very, very expensive. If you change, you can change your job.
That's where the money is, not in research.
Yeah.
More than
Okay.
And during last 6 years, we started this project in Iran, and they funded by government. I mean, the learning process, and the government is starting to launch some firms, private firms, because it is not the government's job to do this. It is the job of the private firm. So not just one private firm to be some kind of exclusivity, because at that time the quality of the services decreased. They started to, at first they started 2 agents, and they increased to 4 agents, and Fatima is from one of them. It is a very good way, because in that way the government don't pay. I mean, even the companies don't pay in dollar to Fatima.
Yeah.
They pay in real. Okay, and we decrease the money of the filing. And during this 5-6 years ago, the Iranian application in PCT in the US goes, increase, I think, more than 4 or 5 times. Yes.
Yeah.
It affects, and because in that way, the researcher, the person from the company, from the industry, can communicate with the attorney with the local language. It is very important, because sometimes language is the main barrier.
Understanding the system, the informal system, the culture.
Okay, and another point Dr. Riaz talks about the strategy. This company, Erogen, have an annual meeting. Do you remember yesterday I talked about the business plan of the company? And the IP business plan, IP strategy is connected to the whole business strategy. And we have this plan in management level, in operational level, and in long-term vision. Okay, when the C levels of the company decided to do something, okay, decided to enter to one market, they decided to compete with one of the competitor, but in the operational level, they don't translate the strategies to the operational level language. It is difficult, because in that time the R&D department, the researchers don't know what they are going to do. So in that meeting, they translate the strategy, the market strategy, to scientific strategy. It is very important, one of the most important. Okay, one another, you say something and you. Anyone else?
I forgot my question.
Ah, sorry.
And somebody, it means that I can get one idea, maybe little, I don't know, but something like we should have some contact with the firm that provides services to at least write our names and something in that case. But we will have the kind of criteria or the meeting that which patent to send or which not to send. And that case, and then if we think that the patent will surely be licensable once, because we are lacking that kind of you can say the craftsman who can actually build us a right patent and will be accepted in a time. So I think right now I'm getting this idea from you. Am I right?
Yes, I think the only thing that I add to it,
because it has their funds as well.
Exactly.
Right now,
At this point, what audits in the universities need is, even before writing a patent, they need to have a team which can do market intelligence for that, competitive intelligence for that. This is done if you collaborate with the industry. They do it for you.
But sir, my opinion is, in most of the Pakistani universities, ORIC has different KPIs and the teaching staff or the academic staff has different KPIs. The problem is that, for example, I have reached the level of professor right now, but during my preparation of the documents for professorship, there was no requirement for patent, or there were no such marks for that if I have patent or not. So the faculty is moving in a different direction, and ORIC has different set of KPIs. So you know that we need to align first the faculty and ORIC together, and then ORIC will be in a better position to cope up with the industrial needs. So faculty is going this way; they are just looking at the promotion and all sort of things. ORIC has different KPIs, a set of 4 main KPI domains that is set by the HEC. So how you can say
So
that
you are at a public sector university.
Yes.
So how many of you are at public sector university? Okay. Let's say you are now a professor, you're 21 grade, at the pinnacle of the teaching career.
Yes.
What is the maximum salary that you can think that you can actually, or a professor gets? What's the maximum?
I think it's in TTS 500,000.
Let's put it 800,000.
Yes.
900,000. A million.
Yes.
1.5. 2 million.
Done.
I don't think that.
What do you want?
The faculty does not understand. The faculty, I shouldn't say the faculty, that will be wrong. We have not been able to convince the faculty, see, if you are able to license, we are talking about $2 million for you. If the university doesn't come in the middle, all the bureaucracy. Yeah. So you do get that kind of money. And this is exactly what I would hope at some day, that people who are rich in Pakistan would be faculty members. Not necessarily as a burden on the public sector, on the public exchequer,
yes,
but because you are creating that value that actually market values and then gives back human. This is what ORIC is supposed to do. For example, I don't know how many universities I made IP policy, innovation policy for one research institution, actually two.
I have just drafted the other thing, and my colleague, we have both drafted the IP policy. And first time in our university that we have drafted the IP policy, and now we have placed it before the governing body for approval. Once approved, then definitely it will be implemented. So this is
the point that I wanted to make about the IP policy. How many universities have any policy about a faculty member creating a spin-off company?
I don't think so.
1, 2,
few
3,
maybe
4. No, what 5?
Still, there is a question that a government officer can
exactly. So we are still living in the past. That's the problem.
Because yesterday someone said that in Qaidazam it is allowed, in HEG it is allowed, but probably most of the universities. I think there is conflict, because as far as the Pakistani law is concerned, there will be a conflict of interest. For example, like I am sitting from 8 to 5 in a university doing a job physically, but I am thinking
of my spin-off company in the evening that I'll be running and I'm getting patent.
You
So
should
it
go
is-
to your spin-off company during the day. That's what I'm saying.
So this is, but actually our administration don't understand this.
When I came back and I'll take one moment. So somebody or VC level said something like, the task of a faculty is to teach. I said, no. Who said that? The task of faculty in a college is to teach. The task of the faculty in a university is to create new knowledge. My task is not to teach. I teach because I know and I can contribute. This is what, as a faculty, I'm contributing. This should not be my duty. I'm teaching because I'm learning new things, obviously, while teaching. My task should be predominantly to research. And that's where I will create new knowledge, either it's applied research or basic research. And this is the fundamental mindset.
Sir, we have 15 credit hours teaching.
Yes, I know.
Okay.
This is what the legacy is. This is what our legacy is.
Not the opposite.
So
research, creation of knowledge, as far as the creation of knowledge is concerned, everybody here sitting as faculty member has produced numerous papers during their research time. There any fiscal year or literary year, whatever. Number one, creation of knowledge is there. But as far as the transformation of that created knowledge into something that is of industrial nature or that on something sellable product, that's a problem.
Yes.
But that problem is not because most of us are self-blaming that we as university or we as Oregon are not doing the thing that we should have been doing. But instead, I think the other player is industry. Our industry as Pakistani industry, we see the dynamics.
Who is asking you to look at the Pakistani industry?
Because
this is the problem again. When you are looking at the database, which is giving you the knowledge for the rest from the rest of the world, why do you have to look at the industry in Pakistan?
Because we have to transform our whatever.
No, we don't have to transform anything.
Outside,
If we get funding from our outside, we will be transforming anyway. So I don't want to put the spotlight on Iran. What impresses me about Iran, and especially about the things that these guys are doing with regard to IP, very narrow. They have been under sanctions for a long time. And I meet Iranian women I've met in Munich at the EPO, in Geneva, and in different parts of Europe, who are so good in IP. And I'm just amazed that IP is such a Western concept. And here is Iran, which has been outside of the global trade for such a long time. And they're producing people who are actually talking about, oh, they know PCT better than we do. They know filing better than we do. I don't disagree. I have a different opinion about this, but I think we need to get back. I'm sorry, I am the perpetrator of this discussion.
Okay.
I take that blame.
That's okay. That's okay. Is anyone want to add the other?
Yeah.
Did you find some strategies? Okay. Because there are lots of strategy, and at the end of the session, I will sum up all of them.
Talk about the Kanun kind of department.
Kanun on IP.
Kanun IP. Is it a kind of, you said, this department is from government?
It has a kind of mixed structure.
Okay.
The governing system is from government.
Okay.
But they are trying to initiate the private sector. They are going to encourage the private sector to play as IP firms, because IP firms are private sector. It is not the duty of the government. The government duty is just the policy making the infrastructure and facilitating the system and making the ecosystem. Okay, in the ecosystem, government do something, private sector do something. But for the initiating, it is like a car, for example. Okay, when the car wants to, wants to move, it needs petrol. Okay, and this fuel came from the government for the first, but when the car started to move, they can find the oil station. They can use it themselves. Okay, but it is not inside the activity is not inside the government, but just the governing system.
So this Kano IP has some kind of specially trained attorneys and people and when industry people from industry come to them, they give them services and give for filing their applications at international level or national level, whatever, and then they are paid in their relatively as compared less paid as compared if they have get attorney at international level, Americans or European.
Okay,
kind of thing
can I just I wanted to recommend something for Pakistan about our experience.
Yes.
You know, you are a researcher from different university. You are PIs, okay? Maybe, for example, somebody is professor and don't have time to do something, and for example, I have, for example, a C-level position at university. I'm a manager of department. I cannot start to be an IP attorney. But all of you have PhD students, master student, just headhunting, okay, just do headhunting, the best one. And you are here now, you can make a very good network to each other, okay? For example, in this course, we have 27%. Imagine that 20 of them from Pakistan, okay, imagine more than that. If just 50% of you bring one student, then you have 10 students. You can, in 2-3 years, for 10 students, you can make a class. You can invite an attorney from outside of Pakistan, okay? You can do everything online as well, okay? The COVID teach us to, we can do everything online, okay?
You don't even need a PhD.
It takes time, but you know, in the idea in Iran and the logic in Iran is that not all the graduate people from the university must go to the university and teach something and go become the PI. Okay, they can have other jobs in private sector. But that students have the knowledge, have the power, have the the energy of it depends on their age, but they don't have a political power. Who have the political power? You at the university. You can do something together. Okay, shall we move to other strategies? Okay, anyone else to add, please? Shall we go to the patent family? Okay.
May I ask a question, please? What about technology valuation? Because we spoke about the cost associated with patenting.
You are talking about the case of erosion, or you say something general?
Yeah, it's about actually this exactly about IP management.
Okay.
So, one of the applications of technology valuation is to see whether is it worth that I go for just patenting in several countries. Do I start patenting this technology in several countries?
Okay.
Because we talked about the high costs of that, and why should we actually get into that?
Okay.
Can I I'll try to partly say something about this. And it goes back to knowing the size of the market. If you know the size of the market, you know if you want to go ahead and keep doing it. So about the comment about Pakistani market is small. Pakistani market is small for many things. Okay, so as compared to the rest of the world, obviously Pakistani market is small. And if you're looking at a bigger market, you will have a bigger opportunity, obviously, to license and to get back a bigger chunk of royalty if you're looking at a bigger market. And if you think that your product is actually worth going into the bigger market, that only comes by looking at the patent data. Not only, I shouldn't say only, but it at least to a great extent comes from knowing how big is the market, where is the assignee from, how many companies they own, in which countries they own companies, how many product portfolio they have. Can I sell to them? Instead of me going in 10 different countries, can I simply sell my technology or license my technology to them? So this is something that can help you in valuation of your invention, knowing the size of the market.
And exactly the key point is the size of the market. In this case, if you say that in Ireland, in Germany, and in US, they have their own attorney, they fight with their own names, they assign the assignment of the intellectual property is on the origin. But the market are not limited to these 3 countries. They started collaboration with other countries, but not based on the do everything by the origin. They have a strategic contract by licensing, okay? And there is a, defensive strategy as well, okay? There is a main patent. For this part, I need to you introduce more about the patent family, because I'm going to say something about the strategy of patent family when changing the claim. Okay, is it okay to? Can you elaborate more about the patent family or the patent family?
So in the first session that we had, we said that, okay, so I have an invention and I can actually file this application for several patent offices in different countries. So I have only one invention and I have several patents. And this is a legal document. Even any minor modification which is made in that, it should be published again. So because it's changed, it's legal. So all the documents, all the patent documents actually, all those that are basically related to just that invention, that same invention, or they are, maybe they comprise minor innovations. They are not different inventions, because we have patents like, we call it continuation patents, continuation in parts. These patents, when you see them, usually they may have some like, they are usually the same inventors, but maybe one inventor is added because a minor improvement is actually, there is a minor improvement in that continuation or continuation in part. So these are all actually, we have 2 kinds of families, simple families and in-patent families. These continuation and continuation in part, or we say that all the patents which share, all the patent documents which share at least one priority date in common are patent families.
And about the claim,
about the
maybe
claim,
the claim are different from in different country based on the
So
I want to add that.
So you see the patent documents, one being published in UK, one being published in US. You compare them, they're exactly the same invention, but one, during the prosecution, one of them, the claims, especially the independent claims, have gotten narrower. That's due to difference in patent rules there. So when the examiner examines that patent, so it is like, okay, if you want this to be granted, it should be narrower. You should add some of those dependent claims to the independent claim to make it narrower. Now it does not overlap with the prior art. Okay.
And the point here is that, for example, as Fatima said in the morning session, the invention is like your land, okay? This is your area. In Pakistan, you have this whole of this area. You go, for example, in Italy, in Spain, or other countries, okay? Based on their IP law and rules and regulation, they say that, okay, it is forbidden to have this part of your land, okay? In that time, you don't say, okay, I came back to Pakistan again, but you said that, okay, I don't want this part, but I want the remaining part, okay? In that way, the claims maybe are different in different territories, but they bargain to have at least a limit, a narrow, right. and it is one of the strategy. And the other strategy is it is a company. And we said that based on the Paris Convention, that even Pakistan is a member of the Paris Convention, okay, you have just 12 months. When the business wants to expand the business area and they want to protect their patent, it is difficult to do everything in every country in 12 months. So they changed the strategy to go country by country. They started to file in EPO because at that time, in that situation, they get the patent, through EPO in many countries. And the other strategy is continuation part, as Fatima mentioned. They file the main patent and they innovate continuously, and they can attach to the other parts and the improvement part of the invention, little by little, maybe not patent, and maybe utility patent, utility model, petty patents, okay?
Do you have this case? Yeah, what I like about this case, it starts with like core technology and not different products, and that core technology is actually improved over time.
Okay, I'm just checking that.
And they have, I think, 14 patent, right?
14 patent family.
Ma'am, there is a question here. I don't know if you have answered or not.
No,
It's a
not
very-
yet. Yeah, not yet.
It's a very interesting question.
How can TTOs check the authenticity of a patent of a researcher? A patent of a researcher. Many a times non-reproducible and fake results are being registered in the name of novelty, and TTO is asked to commercialize it.
Yes, it is.
Dr. Rajda, thank you for the question. Chief, Dr. Rajda is actually, I think, if I know correctly, Dr. Rajda is actually the head of, I think, OIC of Jinnah Women University in Karachi. Now she's federally. I think she was Jinnah Women University. Yeah. Really good, and as you can see from the question.
Okay, there's two questions. For the first one is how can TTO check the authenticity of a patent of his researcher? It is easy because there are, patent database in every country from the National IP Office. Every data are disclosed there. You don't have.
No,
So you have to go to the IP
of the
office.
submitted patent.
Yes.
You
So
don't
you
have
to go to the-
online. You don't have online database.
No. For example, I submit a patent, I file a patent, and he is the officer. How will he authenticate that whatever I have written is correct or I am lying?
No, it is the second question. I'm
The
saying
scientific authenticity is referring to, not the legal authenticity, of course.
everyone can go to the IPO and ask for the, yes, everyone can. Okay. And for the second question, it happens everywhere. Maybe a researcher give you the fake, data. For the patenting system, it is the duty of the examiner to check it, okay? If it's not.
No, he can't run the experiments to verify it.
But examiner has the characteristics of to being fuzita, person having an ordinary skill in the art. She or he knows that skills and have that skills.
It's
And,
like general
and it
use.
is not just is the first time the examiner faced an invention in that field. Many invention. He or she was interacted with many invention. But in any case, maybe it happened. There is a fake result and get patent. And if anyone can get it, they can revoke it and invalidate the patent. It is like an article, there isn't any article. All the articles in the the journal are original.
And that's exactly, you also made that point.
If we
Within
look
the
into
University
the
as well,
retraction watch,
you check
have you come across the retraction watch?
interaction.
Retraction watch.
Retraction.
So the
As
retraction
well.
watch actually, in most of the retraction watch, actually the people look into the results, and sometimes the readers look into the results and then they put a query, and sometimes they have to retract the paper. Same like this.
Earlier, sir said TTO is basically OIC. let's say my PhD in is education, and a person comes to me, he is from microbiology. He said, I have made this innovation and I want to get a patent. Entirely different field. How can I judge his that particular?
Okay.
This is exactly what she was saying. And this is exactly what I've been saying in Pakistan for the last 6 years.
So,
An ORIC cannot have experts in all fields if that ORIC is only in one university.
yeah,
You cannot have
Okay,
the
but
resources.
he has a question, you know, there is there is an institution inside the TTO and ORIC. Its name is IP committee. IP committee, officially can do something in between this. When someone approach to you and ask you, it is not in your field, you have IP committee. IP committee
You send it to the
members are from different departments of the
And
university.
there are some top members as well.
And
based on
they are educated, okay? They are educated in the IP and commercialization field. And you bring the case to the IP committee. For example, there is IP committee once a month or once in 2 weeks.
How many universities do have?
Are based on the cases, okay? And this IP committee decides that university want to protect this invention or not, because protecting invention is just a cost for university, okay? You are not obliged to pay for any request by any researchers, okay? Maybe it is like as Dr. Rashida said, this is fake. That is committee. In Farsi, we have a proverb say "Hame cheez ro hame gandanand," and all people knows everything. It means that not just one person knows all the things. It is the concept of shura, you know.
We asked all the departments that are actively research work to constitute these IP committees. But when we are getting only 4 or 5 patents in a year, so there is no evaluation.
It is not good. You have to have evaluation, because maybe if it depends, and also it depends on the strategy of the university. And strategy is not a fixed term for the long life of the university. For example, if maybe university decided for 2 years, for 3 years, accept every request for what? To encouraging researchers and to say less no to them, okay? Because university wants to attract people, okay, come. It is the market, okay? After 2 years, when the request increase from 2 to 20, okay, you are in the position of the selecting, okay? At that time, you can change the strategy, and their IP committee works there. In that time, because I forgot your name. Dr. Irfan, okay? When the Dr. Irfan is the head of TTO, and I'm the researcher of that university, because he is not the permanent manager of the TTO. Maybe the next year somebody else, okay? When I approach Dr. Irfan and ask him for patenting my invention, and he's watching and it's rubbish, he cannot say no to me. Because if he said no to me, maybe after 2 years, I will be in that position. And I say, it is difficult because he cannot say no to his colleagues, okay? But IP committee can, make it flexible to say no, because there is not just one person. IP committee said that. Committee. And IP committee is mentioned in the IP policy. You have IP policy, okay? You have IP committee?
I would like to share our practice in my
Okay, very good.
To answer the Irfan questions. So every time when I receive application from the lecturers or professors to patent their invention, what I do is normally I will do the evaluation, and I will invite the professor to present. And we have the panels from different background, the legal background, and I will find, for example, if application from the microbiology background, and then I will find one panel that has the expertise, either inside of the university or outside of the university. And then also sitting in the panel is the patent agent. So based on the presentation and evaluation by the panels, and then the panel will give recommendation. And then once it comes to me, and then what I will see is the commercialization potential. Even if the recommendation is positive from the panels, if I feel that the commercialization potential is not there, I cannot file for patent for every application because we have a limited amount of budget. So that's the process that happened in our university.
You're from
There's one.
Indonesia?
Malaysia.
Well, in our university, people also have issues, trust issues. So a person who is inventing will not trust his colleagues to present in front of them.
Exactly.
So
That is
that
the
is
point.
also one of the issues.
Exactly.
Yeah.
You know, patent is something different from article. I myself, I'm not okay with peer review approach even in article, okay? But peer review in the patent is not good strategy because that reviewer they have a skin in the game also. If they say yes, they limit themselves. You know how? Me and you, we are working in the same field, okay? I'm a consultant for the IP committee in TTO. You bring your invention, okay? And the TTO asked me to evaluate the invention. Is it okay or is it fake? Is it can be patentable? And I see that if I say yes, and he file a patent, he have some right, and he limit me. I cannot do something commercial, okay? Because I'm doing some activities in the same field. So peer review is not good strategy in the IP evaluation.
Then what is the
Unless
solution?
unless you
Yes,
also
NDA.
pay a small amount by the university for doing the service.
And also the NDA.
Can
For the
NDA of
NDA is very important.
But what she's saying is is not taken care of by the NDA because the person is thinking that let's not approve this. He's not revealing this to anyone. He may not go ahead and do anything with it, but he would just stop him from actually filing or.
But what's NDA?
NDA, sorry.
NDA is non-disclosure agreement.
So that's why in our panel, we do not only have the peers from the same field, but we also have the patent agents.
The solution is patent agent, not peer review. The solution is patent agent.
So it means that having an IP committee must also have patent agents as well.
Most universities use patent agent as an external, I mean, yeah.
We can pay per service.
Pay for service as you do. Okay. It's something, you want to add something?
Different question, because the time is running out.
Yeah, yes,
What about
because of-
that I file a certain patent, but it is gonna take almost 5 years to get granted or published. In the meantime, a company approaches me to make license. Should I go with that? And what are actually I need to hear from you? Like without getting published or getting granted?
Okay, so
Can I go to license for licensing?
I didn't get.
If the company approaches me?
Without having a patent, let's say the question is, he just filed the application. It may be published, it may not be published, and somebody approaches, he has been talking to someone, and somebody approaches him, what should he do? Should he license without having the patent?
I mean, patent pending?
Patent pending?
Yes. Exactly after I said that, exactly after 1 minute, you file your application, you can do anything. You can do publication and you can negotiate with for commercialization of your patent, but you have to know that you are in the patent pending procedure, okay? And you don't have much right, okay? When I approach to you and you say that I have a granted patent, okay, maybe I say that, okay, it is granted patent, I pay for you $100. But if you say that I'm patent pending, I'm in the process of the patent pending, I think that, okay, 50% he win and 50% maybe he fail. I said, that, okay, $50.
There is some genuine context. That is why I asked this question. COVID, there was an emergency situation, and when we were hitting media headlines, and the people starting approaching us because that was a different situation. That people at that time, people were not in those kind of negotiations. They just wanted to get in contact and to start negotiation and to perform some licensing activity.
And another thing, I don't know the name of the translation. Maybe Dr. Gibran can help us. When you have pending patent in Iran, it is like that. We have to kind of, and complaints, yeah. When you have a granted patent, even you can stop the infringer and ask for damage. But if you are in the patent pending process, you can stop the infringer, but you cannot ask for damage. What about the Pakistan?
You can't.
You can. It's the same.
You can't stop. You can't sue infringer. You can only tell them that we'll come after you once we get it. Don't do it. But you can't go after them.
But you can stop them.
No, you can't. Till the grant, till after the grant, you cannot sue them. You can only threaten. You can show them your teeth, but that's it.
But even in US and EP, they can sue in the
In
pending.
Pakistan, no, there's actually a case law which actually stops somebody from suing others without a grant.
And that's the point. Okay.
I like that.
Okay. Any other? Just I review all the the points I have written, and we cover all of them, I think. Is there any other comments?
If having a confirmed patent, if a researcher has a patent in office, some company asked him for license. License is a kind of agreement with
contract
company and the inventor that he will let him use his innovation or invention, and he will pay such kind of such money. Is it at the same time they will pay that much, or it is kind of gradually they will, as much they sell the thing that they will? What kind of,
there is two kind of contracts here. A contract by university and industry, and university is responsible for its researcher, and university have to have a contract or agreement or any kind of that with the researcher. The industry is not responsible for the researcher at university, unless maybe university let the inventor have a consultancy agreement to the industry, because just having the contract with university and between university and industry cannot implement that innovation and technology in the field. For implementation, they need the help of the researcher, okay, in place. In that time, they can have a consultancy agreement. You want to add something?
My question is,
in Iran for the
I think
it differs from university to university and industry to the industry.
So can you repeat? Yeah, I think you had a different question.
Sir, my question is, if somebody is an individual researcher, inventor, and he is the financer and owner right as well, and he has got patent, the person he said that companies were asking me for license.
People asking you as a university?
Yes, both sides.
Yeah, let's assume as a university.
First, if the rights are with university and the researcher, it's okay. If it is only the researcher, and he has done it by himself, as he has the capacity to do that. I mean to say that when give license to some company to use his product or commercialize his product, what is the nature of that license? I mean to say, do that company will pay them at the same time, or
there are different modes. This is called royalties.
Commercialize it, and then we will.
Yes, so this is called royalties. You can actually combine different modes of royalties. So sometimes you can actually, it happened. So in one case that I know, and I was involved in it. So in that case, there were 5 years of royalty, fixed payment, even before the grant of the patent by the licensee. So fixed payment because the licensee asked the research institute in Pakistan to grant them the license to apply for the patent. And during that time, they would also develop the product. And for 5 years, that was the thinking that it will take 5 years. They will give the institution a fixed payment.
On yearly basis?
On yearly basis of X thousand amount dollars, yeah. And then the second part of the royalty payment was once the product was developed, trials were done in the market, on the basis you can either have a percentage of the revenue,
okay,
or you can have a percentage of the profits. So it depends on what you agree. And that again can again be on product by product basis. So based on the product value, which actually at the end of the day, it's a revenue total. Yeah, so you can make that percentage 5% to 3%, whatever the market, the industry averages. So yeah, so they can be two parts.
Okay.
Or you can also have full, even in licensing, you can also make one-time payment. Even in licensing, normally people think that one-time payment is associated with assignments. That's not necessary. One-time payment can be done with licensing as well.
Okay, fine. Thank you.
There's a question by Dr. Shahzadi. A granted patent letter, has it been written that if you want to seal that, what does it seal that or sell that?
So sealing is basically the fee that you pay just before the patent is granted to you. So the patent office would advertises the applications in Pakistan in the journal. So there's a separate section which is titled sealing fees due, which means it has been published, no opposition has arrived, or opposition has arrived and opponent failed. Now you're at the stage where you should pay the sealing fee, which is in trademarks is called registration fee. And once you pay the sealing fee, and this is very interesting because patents have been historically royal grants.
Yeah, in Europe.
So I don't know if you have actually noticed the change of terminology. In trademark, we talk about registrations. In patents, we use the word grant. In trademark, we say registration fee. In patent, we say sealing fee. So it used to be the prerogative of the king, of the monarch, of the royal to actually grant letters patents in the past. And interestingly, East India Company had the letter patent for this part of the world, that will be the only company that will be doing trade here. And that's how they became so, okay, there were other reasons as well why they became so powerful, but no other European, no other English company could actually come and
So the king had earlier king had.
this is how it started. Yes.
Give back some to do business to some company.
Yes.
That was the patent.
That was called letter patents. And then now we only call patents. Patents are available for an exclusive right for actually exploring a new area in the world. Actually, if you explore a new area, you have the exclusive right to do business in that area. I'm simplifying the whole thing, but this was the idea of patents.
So now the ceiling money is that and money of the fees which they have to pay at the end, or then after all, then they get grant of the patent.
Yeah. She says that fee has been paid on the publication. I don't know what fee has been paid on the publication. I think the fee is, yeah. Yeah, I think there's also, you have to pay the sealing fee anyway. So sealing fee has to be paid.
Okay. Shall we finish? Okay.
They're having fun.
We have to say.
We are having fun.
We have to conclude, Mr. Abhi.
Yes, he just told me to write to him so that Professor Nice also comes on.
Okay, just give us the feedback of these 2 days.
Verbally or in the form?
Yeah, in the form they will. They want to
She wants to hear some nice stuff.
No, 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 no.
Otherwise, we decided that it will not. Okay, we didn't decide it will not be verbal, but come on, she worked hard for like such a long time. Say something nice. She is visiting Pakistan. That's a nice thing. Not nice. I told her, for me, honestly, as somebody who has been working in the area of IP for almost 16, 15, 16, 17 years, I really had a very interesting session yesterday. The first session was really good. I also learned many new things. I recalled many new things. And this morning too, Fatima was also amazing. She was really, and the way she actually summarized everything and connected, it was pretty amazing. So now, any more feedback? And before you give your feedback, let me give my feedback to you. And they also said this, and they will say it themselves. Honestly, I mean, I really, really enjoyed. It didn't really feel. I was looking constantly at the clock all the time, almost all the time, and the kind of engagement we received from all of you, it was amazing. It was just amazing, honestly.
Because it's not my first time. Yeah. It is not my first time I've been in a workshop. I mean, the international one, abroad one. This class, this workshop was really, I really got impressed, and I didn't think we have such a class. Okay, that was very good. I learned a lot.
And the participants online who had been
they are
silently following us, not getting
They're
the chance to
patient.
speak. We are also thankful to all of them. And I think that there are like more than 6 of them. So,
Shall we give them a clap?
Yeah. Okay.
so now your feedback. Okay. Now you have to be very careful because I was really nice to you. So I've set the stage.
You want to say something?
Well, my name is Dr. Muhammad Irfan, and I'm my PhD in the field of education. So about teaching. Recently, I've been given this administrative post of Deputy Director OIC. So 1 or 2 months back. I'm just new in this field, and I feel myself very lucky that I got this chance to have this training with you and interact with all of you. And I really feel what I say, happy and elevated to be with you. And when I talk with all of you, teachers, I call you teachers. I mean to say, you are really very good teachers, and the way you talk with us, with me and all my friends here, it was very nice. And with a very peaceful way, very patiently, you answered our questions. It's really great to have you here. You taught us, you guide us in a very good sense. In fact, Sir Wes and ma'am, answering your PhDs in this field, and person like me who's just new and can ask any question. You may have somebody feel, what is this question? Yeah, it's very basic question and you don't know. So I never felt that you feel annoyed or with these questions, and you try to like me and all of us in a very good way.
Thank you, Dr. Sir. Thank you.
So all of you.
Honored. Thank you.
Lots of thanks.
Any other comments to make the next workshop better?
Yeah.
Criticize us.
I think you should send some study material. You should make a WhatsApp group before you start a workshop like this, and then you should send some study material and videos to the participants who are coming for this workshop. And once we'll go through this, I think it can be more interactive session.
Yes, very good suggestion. I mean, this.
I'm just
department has-
recording it to the CEO, to, you know, to,
That's good.
yeah, to.
In fact, this department has group, they made a WhatsApp group, they may delete it after this, I don't know what are their policies. But the participants and big people are here, you may have data. You may, if agree, you can create a permanent group of this. We can, so that we can communicate with each other after when we are having problems in our departments and we can get help from each other. That would be fine if it is possible.
You know, the official networks, like networks, start from
Like
the unofficial network. The network, I mean, the network in Italy is started by Professor Picalaga. They were some friends gathered together and started this.
Yeah.
You can do this.
I have a few suggestions that I'll do, but first we'll take the feedback.
You're going to compliment.
I'll do that on video.
Okay, you want to add something? You want to say something?
Yes. In these 2 days, there are 2 online tasks. These are being drive, giving more as compared to the.
Actually, this is the constraint of the faculty of science.
What was the comment? What was your comment?
Online speakers.
Not to have the online speakers? Yeah, but yeah, there's,
Yeah,
you have to live in the world which is not, you know, the best.
Online.
Jannat mein karenge na, with present everyone. You think of somebody in the first.
Jannat Makar?
So we'll do that in Jannah, that, you know, we think of someone and the person comes in.
Okay, you want that?
First of all, thank you. I think
Assignment, that's called assignment.
All the good things have been said. For that, if there had been better time management, I think this would have been a much better experience. It's great. I think it's still great. Perhaps next time I do this. It's not
So there was, I totally agree on that. We had a discussion on this and we decided to take as many questions as possible without considering the time. The only reason for that was we hardly get to meet like this from so many different parts of Pakistan in one place. If I would be, if you let me, I'll take another hour and say, okay, any more questions, whatever you have. So that was the only thing.
Great, I think that's great. This discussion space is priceless. What we can just do is, like, say, some people, if perhaps they have to go home, catch a bus, or the different issues, drop some children or something. You can say, who want to go, they can leave, take their certificate or whatever. Who want to stay, they can continue with the dialogue.
Yeah, you are right. But
People sitting here, sitting here for certificate.
Not for us.
For the group photo. No, we are waiting for the form.
Feedback.
Okay, it will be online. We will share the link in the WhatsApp for the sake of the saving environment, not the paper version. We will send you either you are in the WhatsApp group. We will send you that. Feel free, think about us. Right,
अभी अखिल साहब नीचे
do you want to add something?
अखिल साहब नीचे आएंगे.
Everything is okay. Where is Mr. Abhi?
He's coming up. Is there any other feedback? Anything?
Well, nothing to make it official, but I was interested in this workshop as much as I was interested to go to Iran. And then plans were changed and it was happening in Islamabad. So next time maybe you can call us to Iran.
She wanted to say.
Because this workshop is supposed to be 3 days, and the first draft was 3 days, and the drafting part was and the was responsible for that one. But it is again the restriction of the state. They asked us to relate it. We wanted to have searching kinds of, like double searches. Yeah, we in the draft
program, we have a day for searching and drafting and filing.
I think if the audience want to have the mastery over this content, it should be at least 5 days workshop. Means like lecturing followed by some work. You give us, we do some work, then we check it like mentors, and then we proceed.
A WIPO program in this field is in 2 weeks.
Yeah.
Excuse me.
Yeah.
I have important things to mention there.
I can't hear you.
Sorry. There is a group of this WhatsApp group they are created for this. But the presentations all of you used or showed on they are not shared in the.
They will be shared. They will be shared online on the drive, and you will all get the link.
All of them is going to send you in the group. But whoever wants,
My suggestion is usually, I mean, I don't disagree with the WhatsApp group because it's easier to communicate. But my suggestion would be that we have a, like, let's say, milestone. First milestone would be, I would say, if you have an innovation policy at your university, you share with us till that day, till a certain day. So, and then maybe we can get online, we can share with each other, review each other's IP policy, innovation policy and IP policy. And we can then discuss, see what is missing in certain. One thing that I think that I forgot to mention, sorry for going back to the university IP policy. At times, this is important, at times the university decides not to patent something. What would happen to the invention then? That's an important question. Should the university allow you to patent it by yourself at your expense, or should the university not allow you to do this? I am pro first. I say, put it in the policy. If the university has already decided that they were not going to patent it, they should allow you to do it. And if the university wants, it can get a smaller equity percentage or whatever if it wants. So this is something that when I created the IP policy for the institution, I inserted that as well. Because if the professor can see the logic in the invention and the IP community is not seeing it, why punish the professor? He's spent his time. Give it to him.
We have
you have that. Oh, it's perfect. So we can decide on a date where everyone from their universities can share with us what I simply have requested them. In addition to having the group, let's set some milestones of doing, because we have talked a lot of things, we have talked about a lot of issues that sometimes seem like they're beyond our reach, policy issues and all. What we can do is we start with sharing the IP innovation policies, and we all review the other institutions' IP policies. That may be the first thing. Maybe 5 months down the road, we can again come back together online and discuss probably policy issues that you are facing in the implementation of.
At one point, I have to add that you know that today, Mr. Salman Khaled Chaudhry talks about the TISC project. You know what is TISC project? Okay, you are the member of the TISC project as well. Okay, TISC project is Technology Innovation Support Center. It is the program, the part of the development agenda program of WIPO, that they involve universities and research center. Through this project, you can use WIPO's educational program freely, okay? Even here, even online. Don't miss that. This project is very important.
How we can reach to that?
Your university must be the member of this project. Mostly, more than 80 countries now involved in this project. And the core institution in the country who is responsible for this project is IP.
Please share the details and parcel. Please share the details of that project. So who may ask our question?
Yeah, we will just
And messages are maybe also.
अगर डिस्ट्रीब्यूशन जहाँ करा ले और यहाँ पर ये लोगो आ जाए तो उससे खींचेगा ना